Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in.
Good morning, everybody. I hope you're ready. We have a fun day ahead. Yes, we do. Thank you guys so much for joining us. I really appreciate it. It was a long day yesterday, but a good day. It was a long but good day. It's a good day. We're singing a song. Hello, oh sunny day. Oh, sunny day. All right, guys, let me get it going. The court has not started yet. They've got people skirting around in the background, but they have not started yet. Oh, let me get this where I needs it. There we go. 7 days. Oh my gosh, the state continues. They must be getting really close. Hello, to Brit. They must be getting pretty close of getting into the defense case in chief. I'm just getting ready to rest. Oh, plugging in my phone. My house is all messed up. Hi, June. I've got a lot of things to reconnect after last night. Thank you guys for joining last night. Oh, but he's got his orange tie on. Lucky Judge. He likes orange. I have a friend that loves orange. His kitchen is orange. Everything is orange. Except for his food. He's an orange kind of guy. Trying to get my stuff back where it should be. Don't knock that off. Y'all, everything is all cray-cray, but that's good. Yeah, I know. And in the beginning, they were showing stuff they shouldn't have, and I was having to really monitor it. Well, this would be a good time to. Like I said, I got to rearrange everything. It has been. I really appreciate everybody joining me this morning. We heard from the medical examiner yesterday. The one who actually did the autopsy, and then we heard the chief medical examiner. And I didn't like what had happened in court, and the attorney used the judge to bully the medical examiner into answering a question that she wasn't fully comfortable answering. We have a defendant's motion. Thank you. I'll have to give you a shout out in a second as the gavel drops. A defendant motion in the Karen Reed trial to reconsider reciprocal discovery order. Now comes defendant Karen Reed. I better do it over here so I can see what's going on. Make it bigger. And respectfully moves this honorable court to reconsider its reciprocal discovery order regarding the defense pretrial production of impeachment evidence related to the Commonwealth anticipated trial witnesses. As per grounds to this motion, the defendant states that the production of impeachment evidence prior to witness testimony is not required under Massachusetts R. Crime P 14 (A) 1 (B), and will unduly prejudice the defense by allowing witnesses to tailor their responses to preempted cross-examination. What? The production? Oh, I'm going to do this. It's going to drive me crazy all day. Of impeachment evidence related to the witnesses proffered by an adverse party is not subject to mandatory disclosure under the Rule 14, and in this case would particularly prejudicial. Why can't I say that? Prejudice the defense, given the public nature of producing and the closing personal relationship of many of the parties involved. Prejudice. I can't say it. Factual background. Ms. Reed is accused of following the crimes. We already know that. She has faced trial by jury in the above crimes in April. We know all that. Paragraph 4 of the Commonwealth's motion requested to produce a production from defendant of any written or recorded statement, as well as any oral statement reduced in writing of any individual whom the Commonwealth intends to call as witness at trial, including but not limited to such statements contained in the defense investigative reports or in the non-legal reports. Playing hardball. The Commonwealth motion was allowed by court regarding the defendant to turn over evidence intended to be used as impeachment evidence against witnesses called by the Commonwealth prior to those witnesses being testified in trial. On several occasions during various Commonwealth witness testimonies at trial, the witness subsequently tailored their testimony and included details which has not previously been discussed to account for the impeachment evidence turned over by the defendants. For example, May 21st, 2024, the reporter, it's not what I wanted to do. Hold on. It's going to be one of those mornings. For example, trial on May 21st of 2024, Jennifer McCabe testified for the prosecution. During the cross-examination, Ms. McCabe testified on January 30th, 22, the day after John O'Keefe had been found in front of the 34 Fairview Road. She went to the house of Canton PD Officer Michael Lank at 17170. Okay, they're given the line number. Prior to this testimony, Ms. Cabe had never disclosed publicly or in any report or witnesses interview, even when asked directly about her meeting and her conversation in the days and weeks following January 29th, that she visited the house of one of the responding officers, 234 Fairview Road. Miss McCabe, who is friendly with Mike Link and knew him growing up, testified that she could have been at Lieutenant Blank's house for an hour. After initially denying entering Lieutenant Blank's house during the hour that she presented, she then remarked how she might have ran into the bathroom. When asked why had she never testified to this incident before, Miss McCabe responded, I guess I never thought much of it. The only time Miss McCabe claimed to have discussed this meeting with anyone related to the case was at the DA's office with Mr. Lally, Mr. Laughlin, Steve Nelson, and Trooper Brian Tully. Miss McCabe confirmed that at that meeting was the prosecution. She was specifically asked about her meeting with Lieutenant Lank at home. Her meeting at Mr. Lieutenant Lank's home. Something which she had never revealed and about which she had never previously been questioned. At trial, she saved the information for cross-examination. After questioning Mr. McCabe about a different topic, Miss McCabe about a different topic, Attorney Jackson asked Miss McCabe, did anything significant happen on January 30 in connection to this case? Any meetings? Any get-togethers? Anything that you can think of? Compound cool. But anyway, Miss McCabe responded, I went to O'Keefe's house. Attorney Jackson follow up. Other than that, anything else? In response to the open-ended question, without any indication from Attorney Jackson regarding the answer he was seeking, Miss McCabe volunteered through her answer. Well, on my way home, Carrie Roberts' daughter is good friends with Michael Link, so we dropped her off at Michael Link's house, and Mike's wife came out of the house. He and Carrie are friends, and she, jumped into the car and was consoling Carrie and asked how the O'Keefes were doing. And, we talked to her. That's significant. This extremely detailed, comprehensive explanation is an answer to Attorney Jackson's open-ended question, accompanied by Mrs. McCabe's testimony that she had been asked about this meeting by Lally at the DA's office, leads to inescapable inference that Mrs. McCabe was prepared for this impeachment question in advance of trial. That was only possible because in compliance with the court's impeachment evidence reciprocal discovery order, the defense had turned over location data obtained by Mrs. McCabe's cell phone to the prosecution on May 6th of 24. This location data showed Miss McCabe was indeed present at Lank Lally's personal home for approximately 45 minutes on January 30th of 22. Although the Commonwealth did not elicit this information during its direct examination, Miss McCabe had clearly been prepared for the question on cross-examination as a result of the defense's production of impeachment evidence. Another example occurred at trial on May 28th. On May 28th, 2024, when PF testified for the prosecution. PF, who was 11 years old at the time of Mr. O'Keefe's death and 13 years old at the time of testimony, described his experience with the defendant during the SAIN interview on February 22nd, 22. PF had testified about an incident with the defendant wherein at least one witness likely violated the separate sequestration order with the knowledge of the prosecution. July 1st, 2024 at 5:48:21 p.m. Prosecution witness Trooper Michael Proctor sent a text message to Assistant District Attorney Adam Lowley, and it stated, quote, "Yeah, didn't watch asshole Jackson's closing for good reason. Like all of us, our anticipation and anxiety of the verdict has us all on edge." See screenshot. Mr. Proctor's message suggested that his decision not to watch the proceedings on July 1st, 2024 was not out of effort to abide by sequestration order, but instead related to the nature of the defense's closing argument itself. The message implies that Mr. Proctor had been following the trial online, simply skipped the defense's closing argument because he doesn't like Attorney Jackson. Whoa, y'all, that's huge. That is huge. Even absent this admission, the unique nature of this case, including pervasive media coverage, real-time streaming of the in-court proceedings during trial, created opportunities for temptation for witnesses to watch the testimony of others in violation of the sequestration order. The risk of even inadvertent witness exposure to trial testimony, such as witnesses would alter their testimony or anticipate otherwise unexpected impeachment material, would be cured by the court modifying the reciprocal discovery order to include defense impeachment material. Apparent violations of sequestration order allowed, coupled with the defense production of impeachment material, allow prosecution to either one, preempt cross-examination topics by first addressing damaging information during direct examination in effort to take the sting out of the cross-examination, or two, have the polished answer prepared when asked about the same topic for the first time during cross-examination. This inability for the defense to be able to properly confront prosecution witnesses with impeachment material without giving those witnesses the ability to devise a way to incorporate the material into their revised testimony created an undue prejudice. I finally got it, to the defendant, and improperly controverted the intended purpose of the mutual discovery rule compiled by blah, 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 blah. When the defense has impeachment material it intended to use at trial, the presumption should be that it is not discoverable before trial, because generally the defendant need not reveal this defense. Blah, blah, blah. And we're going to pause here and get going in court. Now, she looks like a teenage girl today. By the way, she walks weird, with her hands kind of out in front of her. Are we ready? I need to get coffee. Big time.
Sidebar.
I'm just testing it, make sure it's working.
Oh, well, you told me 3 weeks, so I went ahead and typed it in for 3 weeks. But I've changed it on the original. So yesterday, the state indicated they may have another witness or at least exhibits. And then at the sidebar, I was told that there might be an objection to whatever the exhibit is.
Yes,
So I thought we'd take that up before I brought the jury in and had seen it.
yes, Judge. The state intends to introduce a certified copy of the order from the Circuit Court in Bristol, Virginia, which ordered
Fluid
Hunter
Grit?
Wood
You mean this case?
voluntarily committed to the mental
You
hospital
get me.
over there in Marion. There's a copy of the appearance by the attorney over there, the request for evaluation and report to be done, and then there's a
That's
letter
else
dated
before.
January 10th, 2025, which is from the Southwestern Virginia Mental Health Institute updating the court as to Mr. Wood's status. And like I said, it is I believe, a self-authenticating document. There's a certificate of official record that is attached, signed by the judge of the Circuit Court in Bristol, Virginia.
We have no objection, Judge.
Okay.
My hometown.
So what I intend to do, and then after that,
Unfortunately, Bristol
Do you
courthouse
think that-
burnt down. Go.
No, Your Honor.
so what I'll do,
There
bring
was-
the jury in, get that in the next number of exhibit. Then you can rest in front of the jury. And then I'll have to send them back out so we can take up some matters out of the present.
Looks like they're getting ready to rest.
Bring the jury.
County clerk's got a fancy shirt on today.
Everyone stand, please.
Good morning, everybody. Thank you so much for joining.
You may be seated. Thank you.
All right, Jen, I'll call your name. Oh, wait, before we do that. Ladies and gentlemen, yesterday when we left, I gave you certain admonitions. Do any of the jurors have anything to report with regard to those admonitions? If you do, raise your hand. Let the record reflect none of the jurors raise their hand. All right, John.
Judge, at this time, the state would move to introduce what we believe is a self-authenticating document, which is an order from the Circuit Court in the city of Bristol, Virginia, which
Bristol,
orders
Tennessee.
a mental health evaluation on Preston Hunter.
Just so you know, Bristol, Virginia and Bristol, Tennessee is the same city. It's just State Street divides it between the north of Bristol is Virginia, south is Tennessee. They do have two separate courthouses. Just letting you know, it's crazy but cool.
Hunter Wood. It also contains a letter from Southwestern Virginia Mental Health Institute, which is dated January 10th, 2025, which talks about the fact that he has been involuntarily hospitalized at that facility. If we would offer that as the next exhibit in this case. 261, I believe.
261, any objection?
No, sir.
All right, that'll be exhibit 261.
This is speaking of Hunter. His parents, family put him in a psych hospital because he went cray because the community was calling him a baby unaliver, and
Judge,
he
stay with
already had
All right, ladies and gentlemen,
the
I
disease.
know you've only been out here for 2.5 minutes, but I'm going to send you with the officer.
Everyone stand, please.
All right. um, they're saying that the defense is going to say that he's the one that used oil hats to keep the words from coming, the voices at bay. And that's going to be their part of their defense.
You may be seated. Thank you.
They've alluded to 3 different possible defense strategies: rollover, SID, or
Mr. Scott,
boyfriend.
you have a motion?
Don't ask me why.
Judge, pursuant to Rule 29 of the Rules of Criminal Procedure, I move the court for a judgment of acquittal as to all counts. Just briefly, I'll go through them. As it relates to the first 3 homicide counts, the state has failed to prove the cause of death, which is required to be proven beyond a reasonable doubt. I understand the burden here is that the state has to prove it in a light most favorable to the state. The court has to look at it from that standpoint. Even when looking at that, Dr. Schmidt testified to various, although she stated that she believed it was a asphyxia, she later under cross-examination admitted it could have been a SIDS death. She admitted that it could have been a heart issue, or it could have been a laryngeal spasm that caused the death. She really couldn't specify the manner of death. When it came to Dr. Malushnik, she testified that she felt like it was asphyxia caused by being placed in the trash can, but ultimately she did answer that she could not conclusively say that the baby was alive or dead before being placed in the trash can. As it relates to count 1 in premeditation, there is no evidence whatsoever in this case of premeditation. So those are the 3 murder counts. Aggravated child neglect, the state hasn't produced any evidence that the child was neglected in such a way to adversely affect his health and welfare. Similarly, of abuse, there's absolutely no proof in the record of child abuse. In fact, there is ample proof to the contrary. Both medical examiners testified there was no broken bones. There's no trauma there. There's testimony, I think, from 6 lay witnesses talking about Megan was a good mother, a loving mother. They never saw any signs of abuse. The pediatrician testified that she never saw any signs of abuse, or she would have reported it under her duty under the law. So those are my arguments to those counts. As it relates to tampering with evidence, I'll leave that to the court's good discretion. False report, obviously, there is, as it relates to those, there is a double jeopardy issue that the court will have to address if the jury returns multiple verdicts on those. So, but I will leave those for now, but I do move for a judgment of acquittal without further argument. And the same with abuse of a corpse and failure to report a death. I'll move the court for a judgment of acquittal.
I'm a brief, Judge. Of course, the court reviews this motion in the viewing the evidence in the light most favorable to the state. As far as Mr. Scott's argument regarding premeditation, I think the proof's been pretty clear in this case. The child's found upside down, stuffed into a trash can with its head wrapped in a blanket. And then on top of that, there's a substantial amount of aluminum foil. I think that clearly shows an intent to murder. So we would argue that the element of premeditation is at least shown through the physical evidence in this case. As far as the remaining counts showing the cause of death, both medical examiners, their opinions as they came in yesterday were that this was a homicide and that Evelyn Boswell died from asphyxiation. Mr. Scott certainly challenged and threw some other possibilities out there, but at the end of the day, that was their opinion as to the cause and manner of death. So I believe that the proof has been sufficient at this point to show how the child died and to let the jury make decisions on all the remaining counts.
All right. Of course, as Mr. Scott and the general has stated, in viewing the evidence in light of the Rule 29 motion for judgment.
Okay, is that better,
the
guys?
court's
I had
required
to switch a bunch
to
of
view
cords.
the evidence in the light most positive to the state. And looking at these charges and proof through
Well,
that
Zach,
lens,
what are you saying that gets you deleted?
with regard to count one,
Change the acronym.
premeditation,
I don't know what's going on with
coupled
that, babe.
physical
Sorry.
evidence of the way the child was wrapped and placed in the trash can. You couple that with the
I'm sorry.
voluminous amount of evidence.
Put a dot
that was
between the
given-
letters.
given
Get that work.
different stories as to where the child was,
I just had to reset everything from last
how the
night.
child was doing.
It happened.
When you look at that count in light of the statements the defendant was making on social media, the fact that there seemed to be, from the proof, there seemed to be a cutoff date where before that date, the defendant seemed to be very caring for the child, and after that day, it was story after story about where the child was. The defendant appeared to have moved on to other things. And I think when you take all that evidence and a lot most favorable to the state, that the jury would be able to find premeditation. As for the cause of death, both medical examiners stated that in their professional expert opinion, the cause of death was asphyxiation. Again, Mr. Scott did a good job cross-examining those witnesses to introduce other potential theories. But the course of the opinion the state, when looking at that proof in light most favorable to the state, that they have put forth evidence that the jury can consider. So with regard to count one, I'm going to deny the motion for judgment of acquittal. With regard to counts 2 and 3, the abuse or the neglect, I think that taken in light most favorable to the state, the fact that that child was wrapped and placed in the garbage can, I think the jury can look at that. And I think that those facts taken along with all the other proof in the case. There was testimony that the child was filthy, dirty toward the time late November, early December. I know that the one babysitter testified how dirty the child was. We saw pictures of the living condition of that trailer when the gentleman was cleaning it out. And I think that taking all that together, the jury would be warranted in finding.
Wow, I don't know
abuse or
why.
neglect. I think that
It's YouTubey.
taking the lot most favorable to the state, that those two counts would survive the Rule 29 motion. And I'm going to deny the motion with regard to those two counts. With regard to the tampering with evidence and false report charges, as well as the abuse of the courts and failure to report, when the court looks at all the statements, all the messages, all the social media posts, when you take those as a whole and view them in the light most favorable to the state,
Got an eyebrow fit.
think those are issues the jury can determine, and will have to determine. I'm going to deny the motion with regard to all counts for those reasons. Mr. Scott, first question that I have for you is, will the defendant testify?
Judge, we're prepared to state at this time the defendant will not be testifying.
All right, in that case, we have to go through the Loman versus State questioning. And I'm going to hand this down and let you do that.
Judge, for the purpose of the record, would you like her to come to the,
No, just put the microphone back up on the table for that. We just need to make sure she's recorded. Ms. Boswell, raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, ma'am?
Yes, sir.
Go ahead, Mr. Scott.
Megan, I want to ask you some questions about my representation as you've explained to you your right to testify.
Okay.
I've been representing you for a couple of years now. We've met and discussed your case. You need to answer out loud.
Yes,
Okay. And part of that, I've talked to you about, you have the right to testify, is that right?
yes,
And if the jury can't hold it against you if you don't testify, do you understand that?
yes,
Do you understand you have a right not to testify?
yes,
And if you decided you wanted to testify, I couldn't stop you from that. Judge Goodwin couldn't stop you. Mr. Harper couldn't. That's solely your decision. You understand that?
yes,
And after consulting with me and looking at the evidence and hearing the proof here in court, have you made a decision as whether or not you want to testify?
yes, I have.
Do you want to testify?
No,
I think I covered it, Judge. Approach.
Yeah. Will you have other proof? No. I know it seems like a calisthenics exercise, but we need to bring the jury in. I need to ask you that question in front of the jury, and then you can rest. And then I gotta send the jury out so we can finalize the charge and give the parties time, because what we'll do,
Are they not putting on a
as
defense?
soon as the proof closes, we'll take a break, and it'll be an extended break. We'll take a break so that I can get the charge finalized, and then what I do is I will make a notebook for each juror so that they can read and follow along as I read the charge to them. It's been my experience, especially after lunch, that fewer of them nod off if they're reading with me. Plus, it gives them the charge when they go back in to deliberate. Each one of them has a copy of the charge so they can actually look at it and refer to it. And that also will give you time, because what I'll do is once the charge is done and I get the notebooks ready, we'll bring them back and I will read the charge to the jury up until almost the end. And then I will have you argue your case, and then I will finalize it and send it out. That's the
Yes, sir.
process going forward. And during this extended break, it will give you all time to go through your notes, go through the exhibits, organize your thoughts for closing argument. Okay? So we need to bring the jury. And I need to give you an instruction about.
Yes, sir. I was going to ask about that, but I forgot.
I did too.
Everyone stand, please.
Grand jury.
You may be seated. Thank you.
All right. Ladies and gentlemen, one thing I omitted to do a moment ago. Yesterday, during Dr. Malushnik, did I say that right?
Yes, it is.
At the very end of her testimony, she answered a question and then gave what I'm going to call a parting shot that the answer was no, and that the baby would have to have been murdered some other way. Y'all remember that? Yes, sir. I'm going to instruct you that last phrase you're not to consider. That is outside of her expertise. Okay? It's a legal term, not a medical term. Does everybody understand that? Can everybody put that murder in some other way out of their mind and not consider it? If you can, raise your right hand. Let the record reflect that all the jurors have raised their right hand. Now, Mr. Scott, the state has rested. Will the defense have proof?
Been at rest.
All right. Ladies and gentlemen, where we are now is the proof is closed.
They are not
It is
going
not time for you to begin deliberating or talking about the case. We're going to have to take an extended break because I've got to prepare and finalize the jury charge. And then I'm going to make a notebook for each of you with the charge in it so you can follow along and you'll have that for your reference while you deliver. Okay? This will also, and what'll happen is it'll probably take 45 minutes to an hour. I'll get all the notebooks made. We'll give the lawyers time to organize their thoughts for closing. When we come back, I will hand out the notebooks and I will read you the charge, which will be painful, and I apologize for that, but that's the way it is. And then we'll go straight into argument. Okay? So I apologize for the length of the break, but just bear with me. It's necessary. Okay? You'll go with the officer.
Everyone stand, please.
Okay, guys. Oh, okay, guys. I have an exam I've got to take. I'll be doing while we are. When we'll break, we're going to go to the Simatilli trial.
You may be seated, thank you.
All right, we'll be in recess. We'll probably take 45 minutes.
Court stands in recess.
Well, he said 45 minutes to an hour, so let's do this. We are going to go to the Simatilli trial. Okay. We'll share this. Go here. The defense did not put on any form of, no form of defense, which is shocking.
Do solemnly state the testimony you may give in the
Oh.
cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Please have a seat and stand. And for the record, say and spell your first and last name, please.
Andy Chang, ANDYCHANG.
Thank you. Sir, can you tell us how it is that you're employed?
I am a detective with the Los Angeles Police Department.
And how many years have you been so employed?
Approximately 18 years.
And where are you assigned currently?
I'm currently assigned to Risk Management Legal Affairs Division.
Okay. And previously, between 2014 and 2017, do you recall where you were assigned then?
I was working the Gang and Narcotics Division.
What is the Gang and Narcotics Division?
It's a division where we mainly focus on gang crimes and narcotics crimes.
Okay. Is it also a unit that handles surveillance?
Our specific unit, yes, we were the gang field unit, and we assisted homicide detectives with either surveillance or apprehension of people at interest for the homicide case.
Okay. And that would include gang members and non-gang members?
Correct.
In various homicides, correct?
Yes.
All right. And what type of surveillance operations did Gangs and Narcotics Division run back when you were there between 2014 and 2017?
For surveillance, we have plainclothes surveillance and undercover surveillance. Plainclothes being you still identify yourselves as police officers with either police raid jackets or some type of police insignia on yourself to identify yourself as a police officer. And the undercover surveillance would be without any insignia of police at all. You're not identifying yourself as a police officer. You are acting like a normal citizen, conducting surveillance on whoever the target is.
I want to direct your attention back to February 21st of 2017. Were you called out to be a part of a undercover operation by your supervisor at the time?
Yes,
And who was that?
it was a Detective Richard Jaramillo.
And approximately how many individuals were involved on February 21st in this undercover operation?
It was 5 officers and detectives in total.
And in addition to you, your supervisor Jaramillo, did it also include Joe Anaya?
Yes,
Okay. And on that particular day, were you partnered up or were you all in separate vehicles?
we were all in individual vehicles.
Okay. Were those unmarked vehicles?
They were unmarked vehicles.
Okay. And can you tell us, when you're working a surveillance operation, how does an active or fluid surveillance operation work generally? Not specifically, just generally.
I'm sorry, a fluid operation?
Yes.
So a fluid surveillance operation would be, there would be a target that's at interest, at our interest. And we want to make sure that we keep an eye on that target. So generally, there would be one of the 5 officers who have physical eyes on the target, while the other 4 officers assist with the movements of the target. So if the movement goes northbound, instead of following it, we pass that point off to the person that's on the north point or the west point or the south point or the east point, wherever the direction of the target goes. We are able to maintain surveillance on him at all times. That's a fluid surveillance operation.
Okay. And during this type of a fluid or active surveillance, are you in constant communication with the other individuals involved in the operation?
Yes. So the point officer will communicate via the radio to the other officers who do not have a visual on the target to let them know what the target is doing, which way the target is traveling. So we do maintain a constant radio communication with all the other members of the team.
Since you told us that this was an undercover operation, I'm assuming you were in plain clothes that day?
Yes.
And what did that entail, if you recall?
I had a button-down shirt, a pair of jeans, and I believe that was it, and some socks and shoes.
Okay. And were you advised that your task was to follow certain individuals on that particular date?
Yes.
And do you recall who those people were?
It was Ms. Semitelli and Mr. Baker.
Okay. And were you, in terms of conducting this operation, advised that you were assisting LAPD homicide detectives Gene Parshall and Ryan Verna?
Yes.
And did you receive, as you do in every operation, a briefing prior to the operation?
Yes.
And did that include photographs of the target suspects?
Yes.
Your Honor, I have a photograph of the defendant, if it could be marked as people's next in order.
140.
Thank you. Showing you Exhibit 140. Were you shown a photograph such as this
Yes.
of the defendant?
Yes.
And we've also shown a photograph such as what you see here in Exhibit 14 with respect to Target Baker.
Yes.
And what was your goal or task on this particular day in February?
On that particular day, our mission was to locate Mr. Baker and find out where his residence was.
We also provided not only with photographs of the 2 suspects, but also with photographs of their vehicles.
Yes.
Your Honor, I have an exhibit that contains photographs of a Ford F-150 registered to the defendant in Fabio Santilli. Could it be marked as Exhibit 141?
Yes.
And I also have a photograph of Robert Baker's black Ford Expedition that can be marked as People's 142.
Yes.
Thank you. Showing you Exhibit 141, were you provided with photographs, information, including license plates, as you see here in Exhibit 141 that was being utilized or owned by defendant Santilli?
Yes.
Were you also provided with photographs as well as information and two different license plates regarding suspect Baker's vehicle, that being a Ford Expedition as seen as Exhibit 142?
Yes.
On that particular day, were you notified by your supervisor, Rich Jaramillo, that the suspects were in the Hollywood area?
Yes.
And prior to that date, had you placed a tracker on defendant Santilli's, bless you, Ford F-150 as seen in Exhibit 141?
Yes.
Okay, and where was it that you placed the vehicle tracker on this vehicle?
It was at a car dealership in Thousand Oaks, I believe a few days prior to February 21st.
On February 16th?
Yes, February 16th.
At a Ford dealership, is that right?
Correct.
Okay. And what does that tracker provide you with in terms of information?
The tracker provides detectives live location of the vehicle when the tracker is on.
Okay. So it gives you a live feed or a simultaneous feed as to location based on coordinates?
Yes.
Okay. Based on the vehicle tracker that you had placed on the defendant's Ford F-150 on February 16th, did you then make your way over to the Hollywood area?
Yes.
And where were you as you were looking for this particular vehicle that we see here in 141?
I was on Melrose Avenue looking for the Ford F-150 truck being guided by my supervisor, Rich Jaramillo.
Okay. And did you in fact locate the vehicle?
Yes,
And when you located the vehicle, did you alert the other members of your team?
I did.
And can you tell us what you saw at that point in time?
I saw Mr. Baker driving the vehicle and Miss Samatelli sitting in the front passenger seat. And we crossed paths. So I turned around and to follow the vehicle.
And where did you follow the vehicle to?
To a bar called The Parlor on Melrose Avenue.
Is that a bar that's located at 7250 Melrose Avenue in Los Angeles?
Yes.
Your Honor, I have a series of 4 different photographs from the parlor bar. May they be marked collectively as People's 143?
Yes.
And there is numbers in the bottom left corner, numbers 5 through 8.
Very good.
Approximately what time at night was it when you saw Baker drive the defendant's vehicle up to the parlor bar?
It was around 8:50 p.m.
Showing you Exhibit 143 that has a red 5 in the bottom left corner. Do you recognize what you see here?
Yes.
And what is this?
That is the parlor bar where Miss Cementelli and Mr. Baker entered.
And did you see what they did, either of them, with the defendant's vehicle, the Ford F-150?
They gave it to the valet that was pretty much right in front of the establishment.
And what did you do at that point?
I parked my vehicle and I made entry into the bar as well.
Showing you exhibit 143 that has a 6 in the bottom left corner. Does this depict the interior of that location?
Yes.
And what did you see when you entered the location?
When I entered the location, I observed Mr. Baker and Miss Cementelli seated on a like a 2-person booth. So I proceeded to take a seat just several tables over in that same bar area.
Okay. And at this point, given that you were inside of the location with the 2 targets, were you the point person?
I was.
And did you take any photographs while you were inside of the parlor bar that night?
I did.
Showing you what's been marked as People's 143, page 7. Do you recognize what you see here?
Yes.
And can you describe for us what we see?
Those are the 2 photos that I took of Mr. Baker and Miss Cementelli seated in the booth.
And
Snap.
you, I assume, were seated near them in order to be able to capture these photographs inside the bar?
Yes.
And approximately how long were you inside of the vehicle? I'm sorry, inside the location. Thank you.
Approximately 30 minutes.
And can you describe what each of the individuals was wearing?
Overall.
Yes, Mr. Baker was wearing a black leather jacket and a pair of jeans, I believe with some black boots. And Miss Cementelli was wearing a black evening dress skirt type. And yeah.
And did you notice any facial hair on Mr. Baker that night?
Yes, Mr. Baker had a goatee.
After the 30-minute time period, what was the next thing that you saw happen with respect to these 2 individuals that you were watching that night?
Mr. Baker and Miss Cementelli proceeded to walk out of the bar, and they went to the valet stand to retrieve their car.
Okay. And what did you do?
I followed them out to just next to that valet stand.
Okay. And what did you note at that point in time?
While Mr. Baker and Miss Cementelli were waiting for the car, they began kissing and making out in front of the establishment.
At the valet stand?
Yes,
Approximately how far away were you from the 2 of them at that point in time?
maybe 2 feet, 3 feet max.
Showing you exhibit 143, which has an 8 in the bottom left corner. Is this what you observed?
Yes.
Okay. And do you know who took this picture?
My supervisor, Rich Jaramillo, took the picture from across the street from his vehicle.
And did you see the Ford F-150 being brought to the valet stand?
Yes.
Okay. And then what did you observe?
I observed Mr. Baker and Miss Cementelli get into the vehicle, and they left the parlor bar.
And at that point, when you say they left the parlor bar, did you then pass off point to somebody else?
Yes.
And who was that?
It was a Detective Joe Anaya.
At some point after that, based on the communications between your unit, did you go to another location?
Yes.
And where was that?
It was the Dime Dive Bar on Fairfax Avenue.
I have a photograph of the exterior of that location that is marked as Peoples 144.
In May.
Showing you exhibit 144, it has a 9 in the lower left corner. Is this the location on Fairfax that you drove to?
Yes.
When you arrived at the location, were the targets already inside?
I believe so, yes.
Okay. They were not within your eyesight.
They were not within my eyesight.
So what did you do?
I parked near an alley, further away from the bar, just listening to my radio communication of what the team was doing.
Okay. Subsequently, did you receive communications that they left that location?
Yes.
And where did you go at that point?
The vehicle traveled westbound on the 10 freeway, then to the 405 north, and it had exited on Sepulveda Boulevard.
And is that where you went?
Yes.
And once you exited onto Sepulveda Boulevard, did you follow the vehicle, the Ford F-150 somewhere?
Yes, I had received communication that the vehicle had parked at a mobile gas station, and shortly after I arrived at the mobile gas station.
Okay. And that mobile gas station, was that on a corner
Yes.
of what two streets?
I believe it was Sepulveda and Saugus.
All right, I have 3 photographs relevant to this particular mobile gas station at 4528 Sepulveda. May they be marked collectively as Peoples 145, and there's an 11 through 13 in the bottom left corners.
Very good.
When you got to the location, what did you see?
When I got to the location, I saw Miss Semitelli seated inside the truck, and she was crying and either talking to someone on the phone or attempting to talk to somebody on the phone.
And did you see Baker at that point?
He was not in the truck.
Showing you exhibit 145 with an 11 in the bottom left corner. Is this the location that you responded to?
Yes.
Showing you exhibit 145 with the 12 in the bottom left corner. Do these 2 photographs depict the location where you saw?
Good morning, Jim Dawn.
It's only in this second photo is where the truck was parked. The truck was parked right where the blue vehicle is, right there. Yes.
Okay. And what did you do at that point once you got to this mobile gas station on Sepulveda?
Once I arrived, I had eyes on Miss Semitelli inside the truck, and I was told through radio communication that Mr. Baker had left the truck and that he was walking on foot on Sepulveda Boulevard, just back and forth, quite a few, not too far away, but enough distance where we wouldn't be able to keep eyes on them both. So what our team decided to do was we conducted a rolling surveillance. What a rolling surveillance is we keep switching point frequently back and forth between Ms. Semitelli target 1 and Mr. Baker target 2, so that they're not noticing that cars or people are following them in any way, so that we keep switching point. They have different vehicles that are passing by every time, so that they do not know that they're being surveyed at the time.
Okay. Well, approximately what time of night is it when you're at this mobile gas station?
It was around midnight.
And so you said that you came to the mobile gas station. Did you park somewhere?
I parked across the street from the mobile gas station on the street side.
Could you see whether or not any of the windows in the defendant's truck were up or down?
Both of the front windows were down.
The front passenger and the driver's seat?
Yes, the front
And
passenger in the driver's seat.
which position was she seated in as you were making your observations by the time you got to the mobile stations?
She was seated in the front passenger seat.
Okay. And you said that you could hear her crying
Yes.
and talking?
Yes.
Okay. And could you hear what she was saying from where you were?
I could not make out what she was saying, but I can hear that she was crying and clearly unhappy about something.
Okay. Approximately how long were you in the position where you were making these observations?
The total time that we were at the gas station was approximately an hour. Within that hour, I switched point with multiple teammates. So at any given time, I could be sitting, observing Miss Cemetelli for maybe 5 or 10 minutes. And then we would switch and my eyes would be back on Mr. Baker while he was walking back and forth in Sepulveda. And then I would come back and be seated watching Miss Cemetelli again in the vehicle. So to give you a time estimate, I wouldn't be able to, but it was within that hour between midnight and 1 o'clock in the morning.
Okay. And what did you observe the defendant doing in the vehicle, if anything?
The defendant being Miss Cemetelli?
Yes.
She was, I believe, either texting someone or talking to someone. I couldn't make out, but she had her phone in her hand and she was saying something out loud in tears. So I couldn't tell whether she was talking to somebody on the phone or she was angrily saying something as she was texting somebody on the phone. That I couldn't tell.
Okay. So you heard her talking. You don't know if she was having a conversation or leaving a voice message, for instance?
Yes, I couldn't tell what she was exactly doing.
Okay. And by the way, do you see the defendant here in court today?
Yes.
Can you identify her, please, for the record?
She's wearing a beige blazer seated on my right.
Thank you. At some point, did you discontinue your surveillance on the defendant and focus on Robert Baker?
Yes.
And what did you observe at that point in time?
I was given information through radio communication that Mr. Baker had jumped onto a bus on Sepulveda Boulevard. So we decided to move away from Miss Cemetelli and focus our mission on Mr. Baker because that was our mission from the start.
So your entire team followed the bus at that point?
Yes.
Okay. And what, if anything, did you observe at that point as you were following this bus?
The bus eventually stopped at a bus stop somewhere on Van Nuys Boulevard,
Okay.
and Mr. Baker had exited the bus.
And what did you observe regarding Mr. Baker at that point?
Mr. Baker was standing at the bus stop on Van Nuys Boulevard and Burbank Boulevard. I was parked at the gas station in that same corner, and from there I was able to see him calling a taxi cab to grab a cab.
You were close enough that you could hear him?
Yes, my car was approximately 2 to 3 feet away from him, and at one point during the surveillance, he even leaned on my car just as a resting stop for him to, just to rest his body on the car.
And at that point in time, were you able to make any observations regarding the type of mobile phones he had in his hands?
Yes, Mr. Baker had a total of 3 phones on him. He had 2 smartphones and 1 flip phone on his person.
How many of those phones did you actually see him utilize while you were at the corner of Van Nuys and Burbank?
He was using 2 of them, one of them being the smartphone and the other one being the flip phone.
And from your location, given that he was leaning on your car, could you actually hear him calling
Yes,
these cab companies?
yes,
And at some point, did you observe a cab come and pick him up?
yes,
And at that point, did he drive out of sight?
yes.
And what did you do?
Then we and myself, we all followed him, followed the cab that he was riding in.
Okay. And at some point, were you advised by another member of the team following the cab where Mr. Baker was dropped off that night?
Yes,
And in response, did you drive to that location?
yes,
And was that a location in Glendale?
Yes.
Your Honor, I have two photographs of the address at 331 Salem Street in Glendale. May they be marked, please, as People's 146? There's a red 3 in the lower left-hand corner of one, and a red 4 in the lower left-hand corner of the other. Showing you exhibit 146, is this the location that you went to after receiving information regarding where Baker was dropped off?
Yes.
Showing you 146 that has a 4 in the bottom corner. The first one had a 3 in the bottom corner. Do these appear to be also photographs of the front entry area into that apartment building?
Yes.
And at that particular point in time, were you advised that Baker had indeed entered the location, or did you see him before he entered?
I did not observe it myself. My teammates told me that he had entered the building.
Okay. And what did you do at that point?
I was told that we were going to place a tracker on his vehicle if his vehicle was in the garage.
Okay.
So I exited my vehicle, entered the building, and into the garage of the building.
And approximately what time is this?
It's approximately 2:20, 2:30, somewhere around there in the morning.
So at this point, we're talking about the date of February 22nd.
Yes.
And did you indeed locate Baker's vehicle inside the parking area, underground parking garage at that location?
Yes.
And again, that was the same vehicle that we saw in People's 142.
Yes.
And where did you find the vehicle inside of the parking garage, if you recall?
It was in the stall 307.
And what did you do at that point in time?
I placed the tracker on the vehicle.
Y'all, he's serious, man.
And at that point, did it have the license plate on it that we see in the upper left corner that starts with a D?
Yes.
And by placing that vehicle tracker, did that allow you to maintain information as well as the homicide detectives with respect to where the vehicle went?
Yes.
Thank you. I have nothing further.
Okay, Cross.
Thank you.
Good afternoon.
I just had a couple of questions. Your SISS unit at the time, you were working in your capacity as a detective with the gangs and narcotics unit?
I was an officer at the time.
Okay. And you were asked to conduct surveillance on individuals that you understood had been targeted for investigation, correct?
Yes.
And those individuals who'd been targeted for investigation had been targeted by these detectives you spoke of, Detective Parshall and Verna?
Yes.
Okay. And those two individuals included Ms. Simontilli, correct?
Yes.
And on how many occasions, Detective Chang, did you surveil or observe Ms. Simontilli?
Maybe a handful of times, maybe 3 or 4 times in total,
Um,
including the incidents that we talked about today.
Okay, so including the incident we spoke about today, you surveilled Monica 3 or 4 times?
My memory, it was a while ago, so I can't give you a definite answer, but I believe it was 3 or 4 times.
Okay. The incident we're speaking about today was, I believe, February 21, 2017. Is that right?
Yes.
Okay. Had you surveilled Monica prior to that date?
Yes.
Okay. And when was that?
I know for sure on February 16th when I placed the tracker on her truck.
Okay. And where did you surveil her? Where were you surveilling her?
She ended up at Thousand Oaks Ford dealership.
Okay. And what did she do after?
I believe once we placed the tracker on the vehicle, that was our mission for the day. So we
Okay.
cleared out. So I do not know what she did afterwards.
Okay. And did you surveil her again between the 16th and the 21st?
I do not recall. I don't think so, but I do not recall.
Okay. How about after the 21st? How many occasions did you surveil Miss Simontilli?
After the 21st, we did not surveil her. My unit did not surveil her again.
Okay. So your understanding was you surveilled her 3 or 4 times, including this surveillance on the 21st of February.
Yes.
You surveilled her once on the 16th, and that was at the Ford dealership where you placed the tracker.
Yes.
But you don't recall what other dates?
Not off the top of my head, no.
Okay. On any of those other dates that you surveilled Miss Simontilli, did you ever see her with Robert Baker?
Other than the 21st?
Yes.
No.
Detective Chang, you talked a little bit about watching as you observed Miss Simontilli in a truck with Robert Baker going to, I think you said the parlor bar, correct?
Yes.
Okay. And am I correct that Miss Simontilli wasn't driving the truck, it was Mr. Baker?
Yes.
Okay. And when the truck, I think you said, was valeted, Mr. Baker got out of the driver's side of the car?
Yes.
Okay. And then you watched them and actually followed them into the bar, correct?
Yes.
And they were there for 30 minutes, you said?
Yes.
Okay. And then when they left, Mr. Baker was also driving the vehicle?
Yes.
And then the next time you were able to observe the two of them was at this dime bar, correct?
I personally did not see them at the dive bar.
Okay. Were you in that general location?
I was.
Okay. But didn't observe them and then next actually observed them at this gas station you described, correct?
Correct.
And when you arrived at the gas station, Detective, was Miss Simontilli alone in the car or with Mr. Baker?
When I had arrived, she was alone in the car.
Okay. And you said she was in the passenger seat?
Front passenger seat, yes.
Front passenger seat. And did you make any report of your observations that night?
I did not personally, but Detective Joe and I completed a chronology of the event.
Okay. And you were able at some point to review the chronology he wrote of that event?
Yes.
Okay. And was it accurate in based on what you observed?
Yes.
Okay. And I believe you testified earlier that when you were observing Miss Simontilli, you saw and heard her crying. Is that right?
Yes.
Now, you were with Detective Anaya at this point?
Can you define with?
Were you in the same location?
We were in two different vehicles, but we were working the same operation.
Okay. And so Detective Anaya was parked in a vehicle, correct?
He, at points of the surveillance, yes.
Okay. I'd like to draw your attention to the point at which you were testifying about seeing Monica Cementilli crying. Do you know where Detective Anaya was when you first observed that?
I do not know where Detective Anaya was when I observed Cementilli crying in the car.
Okay, and where were you?
I was across the street from the mobile gas station, directly looking at the opened front passenger window of the truck.
Okay, so the truck was parked inside the mobile gas station parking lot?
I believe it is their parking lot, yes.
Okay, and you were across the street looking towards the vehicle, the truck, where Mrs. Cementilli was?
Yes,
Okay, and you said that you were able to see from that distance clearly she was crying.
yes. And I can hear her crying because my window was down as well.
Okay, so from across the street, you could also hear her crying.
Yes.
Okay, and you observed this occurring for how much time? I think the chronology says, let's see. Well, you tell me, how
Excuse me.
long? Yeah.
Are you withdrawing the question?
Yes, withdraw. Detective Chang, for how long did you observe Ms. Cementilli crying?
Like my previous testimony, it was about an hour's length in time that I was there between the mobile gas station and following Mr. Baker during a rolling surveillance. So I would say when I was parked in front of her, I could at least testify to 5 or 10 minutes of her crying when I was at scene with her observing.
Did you leave? Did you leave to break off to go after Baker while she was still crying?
Yes.
Okay. So you don't know how long she continued to cry, if she did?
In total, I do not know.
Okay. And you mentioned that you thought she was attempting to text or make a call.
She just had her phone in her hand and she was looking into her phone as she was crying out loud. So I don't know whether she was texting or talking to somebody on the phone or she was just searching something on the phone. That I do not know, but I can only testify to what I observed.
Of course. And you never verified whether that wasn't your job. You never verified whether there was any call made from Miss Cementilli's phone, correct?
I do not know whether phone calls were made.
Or any text sent.
I do not know whether texts were sent.
Okay. And you testified earlier that with Mr. Baker, you observed him having 2 or 3 different phones?
Yes.
Am I correct that with Miss Cementilli, you only saw her with a single phone, one phone?
That's all I saw, yes.
Okay. And if someone, if Detective Anaya described Ms. Cementilli as crying uncontrollably, would that be a fair representation of what you saw?
Just think.
The crying you saw was in the vehicle, correct?
Was she in the vehicle?
Yes.
Yes, she was in the vehicle.
And Mr. Baker was nowhere around?
Mr. Baker was not in the vehicle.
Okay, thank you.
Anything further by the people?
No, thank you.
Thank you, Detective Chang. You're excused. You may call the next witness.
Do you solemnly state that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please have a seat in the witness stand. And for the record, say and spell your first and last name, please.
It's Joe Anaya, Joeanaya.
Thank you. Sir, can you tell us how it is that you're employed, please?
I'm employed as a detective with the Los Angeles Police Department, and in April will be 27 years.
Where are you assigned?
Right now, I'm currently at Mission Area Detectives.
That's in the San Fernando Valley.
Correct.
Directing your attention back to 2017, do you recall how you were assigned at that point in time?
Yes, I was at Gang Narcotics Division, working the gang field unit, a surveillance apprehension team.
And how many years were you assigned to G&D?
Approximately 7.5 years.
I want to direct your attention to the date of February 21st of 2017. Were you part of an undercover surveillance operation that evening?
I was.
And were you working with your supervisor, Detective Rich Jaramillo, as well as Detective Andy Chang, who just testified?
Yes, I was.
And on that particular evening, were you directed to follow particular targets?
Yes.
Was one of them Monica Sementili?
Yes,
Do you see her here in court today?
I do.
Can you identify her, please?
She's wearing the blazer, seated at the defense table.
Indicating the defendant.
Was there also another individual that you were asked to follow?
Yes, it was Robert Baker.
Showing you what's been previously marked as People's 14, are you showing a photograph of this individual?
Yes, that's him, Robert Baker.
There appears to be a number 2 in the bottom left corner.
Yes.
Now, had you also previously
Toxic. Yes, we did love, and we read part of it this morning. And while we are on that subject, let me go ahead and thank you again. I want to thank As the Gavel Drops for providing all our wonderful court documents that we use every single day during our live views. Go to Discord, go to As the Gavel Drops, sign up or register your account, and then validate your account. Once it's validated, you too can have access to all the fabulous documents that we have. Thank you again, As the Gavel Drops, for being our partner in crime. We will be reading more of that in a little bit. I'm taking a midterm exam right now.
followed the defendant to a Ford dealership on February 16th of 2017?
Yes, I did.
Did you use the vehicle trackers that have been placed on the defendant's vehicle on February 16th of 2017 in order to find her along with Baker on February 21st of 2017?
Yes, I did.
Showing you exhibit 141 that has a number 1 in the bottom left corner. Is this the vehicle that you saw on February 16th and that you were looking for again on February 21st?
That is the vehicle. I don't see the one on the bottom, but yes, that's the vehicle.
The vehicle is the
The Ford F-150.
Ford F-150 along with the license plate?
Correct.
At some point in time on the night of February 21st, did you find the defendant's black Ford F-150 that we just looked at?
Yes.
Okay. And when you saw her vehicle that night, did you also call Detective Parshall to alert him?
Correct.
All right. How are you dressed on the night of February 21st?
I was wearing civilian clothing, Normally I'd wear just regular attire, jeans, t-shirt.
And were you also driving an unmarked vehicle that night?
I was.
The first time that you saw the defendant on the night of February 21st, where was that?
That was on Melrose at 7230 Melrose at the Parlor Restaurant at approximately 8:50 p.m.
Is that 7250 Melrose?
It could have been 7250 on the corner.
Let me ask you this. Looking at exhibit 143 that has a 5 in the bottom left corner, is this the location that you responded to on February 21st?
That's it.
Did you go inside that location?
I did.
When you went inside, did you join Detective Chang?
I did.
And was that in the bar area?
Yes, it was in the bar.
Showing you exhibit 143 that has a 6 in the left corner. Looking at the photograph to the left, is that the area where you joined Detective Chang?
It looks familiar, yes.
Showing you exhibit 143 that has a 7 in the bottom left corner. Is this what you observed with respect to the defendant and Baker when you went into that location that night?
Yes.
Now, at some point, did you follow them to another location?
Yes, to 442 North Fairfax in the city of Los Angeles.
And what location was that at the time?
That was the Dime Dive Bar. That's what it was called, the Dime Dive Bar.
Showing you exhibit 144, these two photographs appears to have a number 9 in the bottom left corner. Is this the location you followed them to?
That's it.
Okay. And when you followed them to this particular location, did you go inside or did you stay outside?
I stayed outside. I parked across the street and maintained visual on the front door.
You said you were the point person.
I was the point person monitoring the front of the location.
Approximately what time did the defendant and Baker arrive at this location?
Approximately 10 p.m.
Okay. And about 30 minutes later, did you make some other observations?
I did. The defendant exited the front door of the parlor bar onto Fairfax.
As irrelevant, cumulative, based on Detective Lerner's discussion of this already in testimony, and improper character.
Overruled.
Go ahead.
I saw her exit the front door. She sat down at the bench area that's in front of the location there. And the
Location here, the bench. That we see in the photographs to the right, like a wooden bench.
that's it right there.
Okay.
She sat down, and at some point, he appeared to be a security guard / host, male, black, about 40 years old, walked up to her. They sat down next to her. They talked, and their interaction lasted about 10 minutes as she smoked a cigarette.
I'm sorry?
As she smoked a cigarette.
And as she was smoking a cigarette, you saw her talking to the security guard or bouncer?
Yes.
And what did you see, if anything, her do?
Objection, irrelevant, improper character evidence, and cumulative.
I believe I ruled on this. Again, it's overruled.
Go ahead.
What I saw was them talking. She began to use her right hand, and as he sat to the right of her, she began to caress his inner left thigh.
Did you see her doing anything else with respect to this bouncer?
Yes, she used her right hand and began to rub the back of his neck.
Was that while she was speaking with him?
Correct.
And did you see what she did next?
She initiated a passionate kiss on his lips.
How long did that go on for?
The kiss was approximately 4 seconds.
And what, if anything, did she do after that?
She went inside.
When she came out from the bar to have this cigarette and you saw this interaction with the bouncer, was she alone
She
or
was
with someone else?
She was alone.
was the next thing that you saw from your vantage point?
About 10:53, Robert Baker came out alone. He went to the valet to retrieve the pickup truck, the F-150, and then he drove to the rear alley. And my team advised me that he was trying to find a parking spot in the rear alley.
And at some point, were you advised that he went back inside the bar?
Correct. He went inside the bar, out of view for about an hour.
Somewhere around 12 a.m. midnight,
Correct.
did you see something else?
I did not see. I was advised by my team, Detective Whitney, that they re-entered the pickup truck. Baker was driving. The defendant was in the front passenger seat. And at that point, we resumed our surveillance in the vehicles and followed them.
When you said they, are you referring to the defendant and Robert Baker?
Correct.
And were you advised that they came out from the back door and then entered the defendant's vehicle?
Correct.
And did you see where Baker drove at that point?
Yes, we followed the vehicle. They didn't make any stops to the 10 freeway, then to the 405 North transition. And at that point, Baker exited the Ventura exit off of the 405 freeway that kind of drops you off onto Sepulveda Boulevard.
Okay. So now we're talking about any observation at this point is on February 22nd of 2017, correct?
Correct.
Okay. And did you observe him stop the vehicle at some point?
Yes. He came to an abrupt stop in the mobile parking lot at 4528 Sepulveda Boulevard. And then he immediately got out of the vehicle, slammed the door, and briskly walked away eastbound on Dickens Street.
Showing you exhibit 145. Do you recognize what you see here?
Yes.
Is this the mobile station that you followed the defendant and Baker to?
Yes.
And when you said he stopped in the driveway, is this the driveway area?
It was more onto the flat surface in the mobile, like where the blacktop is at. To your left a little bit, right around there.
And did you see where he parked the vehicle?
It was right where your finger last was.
Okay. Showing you exhibit 145. The one we were pointing to was 145. It has an 11 in the bottom left corner. Now I'm pointing to 145 that has a 12 in the bottom left corner.
Okay.
Does this photograph, these two photographs depict the location where eventually he parked the Ford F-150?
No, the other one showed where he parked. Later on, she moved the car, which was what you were showing me. So right here on this photo is where he stopped in the middle of the pumps, a little bit to your right, around that area right there. Correct.
Okay. So at some point, after you saw him get out of the vehicle from the driver's side, did you see what the defendant did?
The defendant, later on, she moved the vehicle to that other spot that you showed me.
Looking at 145 with 12 in the bottom left corner.
Correct.
Is this the location where the defendant then parked her vehicle?
Yes, where that blue car approximately would have been.
Okay. Showing you exhibit 145 that has a number 13 in the bottom left corner. Just to orient us, the area that I'm pointing to in the bottom left corner, would that be the same area that we see in 145, page 12?
Yes, it is.
Okay. And so you observed the defendant get into the driver's seat and move the vehicle to this particular location as we see in exhibit 145, page 13?
No, I didn't make that observation.
You were advised of that by others in your unit?
Correct. I maintained the surveillance on Mr. Baker.
Okay. And did you see where Mr. Baker went?
Yes, he kept walking eastbound on Dickens and through the neighborhood there. Very quiet, small street. And then eventually he kept walking very briskly to a north direction and ended up on Ventura Boulevard.
And what did you do at that point in time?
I continued to follow him with the team. We conducted a rolling surveillance and maintained a visual on him. And he walked quite a ways. I would say at least a mile or so.
And when you said you had a rolling surveillance, that means you're passing off point between the individuals in your unit at that point?
Correct. Just to minimize your exposure to your target, you just kind of leapfrog and let the target come to you as you're parked, and you're trying to minimize exposure to that target and minimize exposure.
As Baker was walking, what did you see him do, if anything?
I saw him on his cell phone. It was dark, and I could see his cell phone lighting up, and he was talking on it from approximately 6 to 8 inches. He held the phone away, so I assumed he was on his speakerphone.
Can you describe the phone?
One of the phones I saw was a large square type smartphone, and the other one was a flip style cell phone.
Okay, so you saw him using two different phones?
Correct.
Flip phone? Burner phone, you mean?
And did you follow him to a particular location?
I did. I went back to check on the defendant. In between that time, we were going back and forth between both targets, but I did eventually make the call to go back to see what the defendant was doing.
Okay. And when you went back to see the defendant, was she in the still in the driver's seat at this point after moving the car?
Yes, it was after she had moved the car to that spot off of Saugus. That side street is to the east is Saugus, and she was parked where the inner car was. I was parked right next to her, to the left of her.
And did you have any windows in your vehicle down at that point?
I did. I had my right passenger window open, which was the window closest to her window.
That would be her driver's window.
Correct.
And could you hear what she was doing?
Yes, she was crying uncontrollably. She was using her cell phone and looking down at it. I remember her saying, "I'm so stupid," and repeating that 3 or 4 times.
Okay.
And she was continuously crying.
Do you know if she was speaking into the cell phone at that point in time?
She appeared to be, yes.
Could you hear her speaking?
I could.
Okay. After that, did you go back to a bus stop location?
Yes, I determined to stop the surveillance on the defendant and just focus on Baker, since he was walking around. At this point, he was on Van Nuys walking northbound on Van Nuys Boulevard from Ventura.
And did you see what he did there?
Yes, he eventually got onto an MTA bus and took the bus north on Van Nuys Boulevard to Oxnard. And at that point is where he got off the bus. It wasn't that far,
Okay.
but he jumped on and then jumped off about 2 majors later.
Okay. And what did you see him do at that point, if anything?
He began to walk back towards the direction he came from, which was southbound on Van Nuys. And then eventually he came to a stop at the southeast corner of Burbank Boulevard and Van Nuys. There's a bus stop there, and I think that's also a mobile gas station.
And at that same time, as he was walking, did you see whether he was using his phones again?
Yes, he was using his phones and talking on 2 different phones.
And what did you see him do next, if anything?
At that time, eventually I was alerted by a teammate that a cab company, United Cab, picked up Baker and proceeded to drive away.
And did you follow Baker in the cab?
I did. I made the determination to have myself and Detective Whitney to go ahead of the surveillance to try to cut get there before he did and guessed that he would be returning to the area of Salem Street. And at that point, I was able to get to that street before the cab arrived at that street at the corner of Salem and Central in the city of Glendale.
And did you see the Mr. Baker get out of the cab?
I did.
And did you see where he went?
Yes, I followed him on foot. I got off of my vehicle and I followed him from across the street, followed him to 331 Salem. I don't know if it's street or avenue.
Okay. And did you see him go into that apartment building?
Yes, I did. After he used the intercom to try to get buzzed in, it appeared as he waited for a few minutes. And at that point, he must have gotten buzzed in. He opened the door and he went out of my view into the Veteran Village apartments.
Okay. Is that the location, the Veteran Village apartments that we see in Exhibit 146 that has a number 3 in the bottom left corner?
Correct. That's the place.
Okay. Approximately what time was that?
It was at approximately 2:30 p.m.
In the morning on February 22nd?
Correct, 2:30 a.m.
Thank you. I have nothing further.
Mick Ross.
Thank you. Detective and I think I just heard you say that you, when you were following Mr. Baker at the end of your testimony, you had assumed he was going back to the Salem address, and that's how you knew where to go?
Correct.
So you already knew where Mr. Baker was residing?
No.
Well, why did you assume he was going back to that address?
Because earlier in the day, around 8:00 p.m. on the 21st, is when I was monitoring the GPS tracker on the defendant's truck.
Mm-hmm.
I saw that she was headed in an easterly direction, and at that point, I figured she might meet up with Mr. Baker.
Okay, I'm curious. I'm sorry, Evelyn.
I'm sorry, I should have continued. So then, when I was monitoring the cell phone and getting the team together to conduct our operation, I continued monitoring the phone, and I saw that she had stopped in the area of Salem and Central in that vicinity of the 300 block of Salem.
Okay, so you had actually surveilled Ms. Simontilli earlier that same day?
No, I was using the electronic device and monitoring her activity from there.
Okay.
So that kind of surveillance, yes, but not physical.
Okay, so you don't know if Robert Baker was driving the truck or Ms. Simontilli was driving the truck. All you knew was from the tracker that the truck was at that location, correct?
Yes.
Okay. And had you surveilled Ms. Simontilli prior to February 21st?
I did.
Okay, on how many occasions?
Just on the 16th of February, a few days before.
Okay, and that was the only time before the 21st?
Yeah, I can remember that was the only time on the 16th.
Okay, and how about after the 21st? On how many occasions did you surveil Mrs.
None that I could remember.
Okay, and am I correct that the way that you write down anything you feel is important from this surveillance is you wrote in this case a chronological log? Is that correct?
I did.
Okay, and you did it specifically for what you observed on February 21st that you felt was important?
Yes, that I felt was important, that was relayed to me either through my team or from my own observations. Correct.
Got it. Okay. And am I right that when you observe
We have movement in the other courtroom. We're going to listen in.
Reviewed the final charge or the charge in its final form.
I have, Judge.
I have to.
And on behalf of the state, General, do you accept the charge as written?
Yes, Judge.
Mr. Scott, on behalf of the defendant, do you accept the charge as written?
Yes, sir.
All right. What I'm going to do, it's 81 pages long.
Oh my God.
I'm going to bring them in, give them the charge. I'll probably, of course, I have to read all the judgment forms. If you look at it on page 49, I'm going to read down to, I'm going to stop where it says when you retire to the jury room. I'm going to wait and give them that part after y'all argue. I would ask if the state's ready, but I think General Harper just left.
He's coming right back. He left his copy of the jury instructions on his desk. He's just grabbing them. The state is otherwise ready.
And I won't say it. I'm sure I won't think to say it, but the presentment is required to go back with the jury charge, and it's in the back of the book.
Your Honor, count 18, was that redacted out? Just making sure.
Yep.
Yeah.
Yep. All right. Is the state ready to proceed? Defense ready to proceed?
Yes, Judge.
Then let's bring the jury in.
We'll bring the jury.
Everyone stand, please. You may be seated. Thank you.
All right. All right. In the criminal court for Sullivan County, Tennessee, at Blumble, State of Tennessee versus Megan Boswell, defendant, case number S72869, date February 3rd through 12, 2025. Count 1, first degree premeditated murder. Count 2, first degree murder in the perpetration of a felony. Count 3, first degree murder in the perpetration of a felony. Count 4, aggravated child abuse. Count 5, aggravated child neglect. Count 6, tampering with evidence. Count 7 through 17, false report. Count 19, abuse of a corpse. Count 20, failure to report a death under suspicious, unusual, or unnatural circumstances. Jury instructions. Members of the jury. Count 1 of the presentment charges the defendant, Megan Boswell, with the offense of premeditated first-degree murder. This offense embraces the lesser included offenses.
Whoa, what happened, Your Honor?
Of facilitation of premeditated first-degree murder, attempt to commit premeditated first-degree murder, facilitation of attempt to commit premeditated first-degree murder, second-degree murder, facilitation of second-degree murder, attempt to
Hello.
commit second-degree murder,
Good morning.
facilitation of attempt to commit second-degree murder, voluntary manslaughter,
Put on a
facilitation of voluntary manslaughter, attempt to commit voluntary manslaughter,
right.
facilitation of attempt to commit voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, facilitation of criminally negligent homicide, child abuse, child neglect, attempt to commit child abuse, attempt to commit child neglect, assault, attempt to commit assault, and misdemeanor reckless endangerment. Count 2 of the presentment charges the defendant, Megan Boswell, with the offense of first-degree murder in the perpetration of a felony. This offense embraces the lesser included offenses of facilitation of first-degree murder in the perpetration of a felony, attempt to commit first-degree murder in the perpetration of a felony, facilitation of attempt to commit first-degree murder in the perpetration of a felony, second-degree murder, facilitation of second-degree murder, attempt to commit second-degree murder, facilitation of attempt to commit second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, attempt to commit voluntary manslaughter, facilitation of attempt to commit voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, facilitation of criminally negligent homicide, child abuse, attempt to commit child abuse, assault, attempt to commit assault, and misdemeanor reckless endangerment. Count 3 of the presentment charges the defendant Megan Boswell with the offense of first-degree murder in the perpetration of a felony. This offense embraces the lesser-included offense of facilitation of first-degree murder in the perpetration of a felony, attempt to commit first-degree murder in the perpetration of a felony, facilitation of attempt to commit first-degree murder in the perpetration of a felony, second-degree murder, facilitation of second-degree murder, attempt to commit second-degree murder, facilitation of attempt to commit second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, attempt to commit voluntary manslaughter, facilitation of attempt to commit voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, facilitation of criminally negligent homicide, child neglect, attempt to commit child neglect, assault, attempt to commit assault, and misdemeanor reckless endangerment. Count 4 of the presentment charges the defendant Megan Boswell with the offense of aggravated child abuse. This offense embraces the lesser included offenses of facilitation of aggravated child abuse, attempt to commit aggravated child abuse, facilitation of attempt to commit aggravated child abuse, aggravated assault, facilitation of aggravated assault, attempt to commit aggravated assault, facilitation of attempt to commit aggravated assault, reckless aggravated assault, facilitation of reckless aggravated assault, misdemeanor reckless endangerment, child abuse, attempt to commit child abuse, assault, and attempt to commit assault. Count 5 of the presentment charges the defendant Megan Boswell with the offense of aggravated child neglect. This offense embraces the lesser included offense of facilitation of aggravated child neglect, attempt to commit aggravated child neglect, facilitation of attempt to commit aggravated child neglect, aggravated assault, facilitation of aggravated assault, attempt to commit aggravated assault, facilitation of attempt to commit aggravated assault, reckless aggravated assault, facilitation of reckless aggravated assault, misdemeanor reckless endangerment, child neglect, attempt to commit child neglect, assault, attempt to commit assault. Count 6 of the presentment charges the defendant Megan Boswell with the offense of tampering with evidence. This offense embraces the lesser included offense of facilitation of tampering with evidence, attempt to commit tampering with evidence, and facilitation of attempt to commit tampering with evidence. Count 7 through 17 of the presentment charges the defendant with Megan Boswell with the offense of false report. This offense embraces the lesser included offenses of attempt to commit false report. Count 19 of the presentment charges the defendant Megan Boswell with the abuse of a corpse. This offense embraces the lesser included offense of facilitation of abuse of a corpse and attempt to commit abuse of a corpse. Count 20 of the presentment charges the defendant Megan Boswell with the offense of failure to report a death under suspicious, unusual, or unnatural circumstances. This offense embraces the lesser included offense of attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances. The presentment in this case is the formal written accusation charging the defendant with these charges. It is not evidence against the defendant and does not create any inference of guilt. To this presentment and each offense charged and included therein, the defendant has entered a plea of not guilty. The evidence in this case has been completed and final arguments will take place momentarily. Now it is my duty to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks that I have made, do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. As to any question to which an objection was sustained, you must not speculate as to what the answer might have been or as to the reason for the objection, and you must assume the answer would be of no value to you in your deliberations. You must not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken out by the court, such matters to be treated as though you had never known it. You must never speculate to be true any insinuation suggested by a question asked of a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. Whenever the singular of a word is used in these instructions, it may be taken equally to mean the plural unless clearly inapplicable. Whenever the word he is used in these instructions, you may consider it as applying equally to a woman. The law presumes that the defendant is innocent of the charge against her. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless, from all the evidence in the case, you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. A conviction cannot be based on conjecture, suspicion, or a mere belief that the defendant is guilty of the crime charged. Reasonable doubt is a high burden, but it does not mean proof to an absolute certainty. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of the offense. Reasonable doubt does not mean a captious, possible, or imaginary doubt. A reasonable doubt is not a whim. It is not speculation or suspicion. It is not an excuse to avoid the performance of an unpleasant duty, and it is not sympathy. A reasonable doubt is a doubt based upon reason and common sense after careful and impartial consideration of all the evidence in this case. The state must have proved beyond a reasonable doubt all the elements of the crime charged, that the crime, if in fact committed, was committed by the defendant before the finding and returning of the presentment in this case. The date of the offense is not an essential element of any of the offenses charged in the presentment or any lesser included offense. The state is not required to prove beyond a reasonable doubt a specific date upon which any of the alleged offenses occurred. The state is only required to prove beyond a reasonable doubt that the alleged offenses occurred before the finding and returning of the presentment in this case. The burden is upon the state to prove by preponderance of the evidence that this offense was committed in Sullivan County, Tennessee. Proof by preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by preponderance of the evidence that this offense was committed or consummated in Sullivan County, Tennessee, then you must return a verdict of not guilty. If you have read or heard anything about the case other than in open court, you should disregard what you read or heard and base your verdict only upon the law and evidence presented under the direction of the court. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all the evidence in light of your own observations and experience in life. You are the exclusive judge of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile them if you can, without hastily or rashly concluding that any witness has sworn falsely, for the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of his or her general character, the evidence, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any are shown, and all the evidence in the case tending to corroborate or to contradict him or her. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance to his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. Further, a witness may be impeached by careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it's corroborated by other credible testimony or by the facts and circumstances proved in the trial. Your decision on the facts of this case should not be determined by the number of witnesses testifying for or against a party. You should consider all of the facts and circumstances in evidence to determine which of the witnesses you choose to believe or not to believe. The defendant has the right to remain silent, that is, the right not to testify. You shall not consider such silence as evidence of guilt, and you can draw no inferences of guilt from such silence or decision not to testify. You are reminded that the state has the burden to prove guilt of any offense beyond a reasonable doubt. Evidence has been introduced in this trial of a statement or statements by the defendant made outside the trial alleged to show an admission against interest. An admission against interest is a statement by the defendant which acknowledges the existence or truth of some fact necessary to be proven to establish the guilt of the defendant, or which tends to show guilt of the defendant, or is evidence of some material fact but not amounting to a confession. While this evidence has been received, it remains your duty to decide if in fact such statement was ever made. If you believe a statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. In so determining, consider the circumstances under which the statement was made. Also, consider whether any of the other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement, but rather should consider all of any statement you believe was made and is true. You are the sole judge of what weight should be given such statement. If you decide a statement was made, you should consider it with all the other evidence in the case in determining the defendant's guilt or innocence. Expert witness. During the trial, you heard the expert testimony of Dr. Matrina Schmidt, who was described to us as an expert in the field of forensic pathology, Dr. Darinka Polchan, who was described to us as an expert in the field of forensic pathology, Paul Durant, who was described to us as an expert in the field of forensic analysis of digital devices, Marla Gray, who was described as an expert in the field of serology and DNA analysis, and David Hoover, who was described to us as an expert in the field of latent fingerprint identification. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state their opinions concerning such matters and give reasons for their testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reason, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Evidence. You may have heard two types of evidence in this case. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. The law makes no distinction between the weight that you should give either direct or circumstantial evidence. It is for you to decide how much weight to give any evidence. The crime charged or included in each count of the presentment is a separate and distinct offense. You must decide each charge separately on the evidence and law applicable to it. The defendant may be convicted or acquitted on any or all of the offenses charged or included. Your findings as to the crimes charged must be stated in your verdict. You will not be provided with a transcript of the testimony. However, you were permitted to take written notes. Notes taken by a juror to be used only as an aid to the memory of that juror alone and may not be used as authority in the jury deliberation room. The fact that something has been reduced to writing does not make it more significant than matters not noted down, and does not make it more accurate than independent memory. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media such as a telephone, cell phone, smartphone, iPhone, BlackBerry, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including all social media, to communicate to anyone any information about this case, or to conduct any research about this case until you have returned your verdict and the trial has concluded. The court will now instruct you as to the law applicable to all counts of the presentment. Count 1, premeditated first-degree murder. Any person who commits the offense of premeditated first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally, and 3, that the killing was premeditated. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time she allegedly decided to kill must be carefully considered to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. If you find from the proof beyond a reasonable doubt that the defendant is guilty of premeditated first-degree murder, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of premeditated first-degree murder, as charged in the presentment,
I'll be right
then your
back.
verdict must be not guilty as to this offense. Count 2, first-degree murder in the perpetration of a felony. Any person who commits first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the killing was committed in the perpetration of or the attempt to perpetrate the alleged aggravated child abuse. That is, that the killing was closely connected to the alleged aggravated child abuse and was not a separate, distinct, and independent event. And 3, that the defendant intended to commit the alleged aggravated child abuse. The following essential elements apply to aggravated child abuse. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the act of abuse resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated child abuse. The killing may precede, coincide with, or follow the aggravated child abuse and still be considered as occurring in the perpetration of the aggravated child abuse, so long as there is a connection in time, place, and continuity of action. Knowingly means that a person acts knowingly with respect to the conduct or the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct when it is the person's conscious objective or desire to engage in the conduct. Child and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of first-degree murder in the perpetration of a felony, then the jury will not fix the fine. If you have a reasonable doubt as to the defendant's guilt of first-degree murder in the perpetration of a felony, as charged in the presentment, then your verdict must be not guilty as to this offense. Count 3, first-degree murder in the perpetration of a felony. Any person who commits first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the killing was committed in the perpetration of or the attempt to perpetrate the alleged aggravated child neglect. That is, that the killing was closely connected to the aggravated child neglect, the alleged aggravated child neglect, and was not a separate, distinct, and independent event. And 3, excuse me, 3, that the defendant intended to commit the alleged aggravated child neglect. The following essential elements apply to aggravated child neglect. 1, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare. And 2, that the act of neglect resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated child neglect. The killing may precede, coincide with, or follow the aggravated child neglect and still be considered as occurring in the perpetration of the aggravated child neglect, so long as there is a connection in time, place, and continuity of action. Knowingly and intentionally had previously been defined for you on page 15 of these instructions. Child and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of first-degree murder in the perpetration of a felony, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of first-degree murder in the perpetration of a felony and was charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted knowingly. Knowingly means that a person acts with an awareness that his or her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally has been previously defined for you on page 13 of these instructions. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. If you find from the proof beyond a reasonable doubt that the defendant is guilty of second-degree murder, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as the defendant's guilt of second-degree murder is charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Intentionally has been previously defined for you on page 13 of these instructions. Knowingly has been previously defined for you on page 17 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation, sufficient to lead a reasonable person to act in an irrational manner. If you find from the proof beyond a reasonable doubt that the defendant is guilty of voluntary manslaughter, then you may fix a fine in any amount not greater than $10,000, and you'll so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of voluntary manslaughter as charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, and 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also shown or established if it is shown that the defendant acted knowingly or intentionally. Intentionally has been previously defined for you on page 13 of these instructions. Knowingly has previously been defined for you on page 17 of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless homicide, then you may fix a fine in any amount not greater than $5,000, and you'll so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of reckless homicide as charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, and 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim would be killed. The risk must be of such a nature and degree that his failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown the defendant acted intentionally, knowingly, or recklessly. Intentionally has previously been defined for you on page 13 of the instructions. Knowingly has been previously defined for you on page 17 of the instructions. Recklessly has been previously defined for you on page 19 of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of criminally negligent homicide, you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of criminally negligent homicide is charged and included in the presentment, then your verdict must be not guilty as to this count. Lesser included offense counts 1, 2, and 4. Child abuse. Any person who commits child abuse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of child abuse, you may fix a fine in any amount not greater than $2,500, and you so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of child abuse as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 3, and 5. Child neglect. Any person who commits child neglect is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare. And 2, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of child neglect, then you may fix a fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of child neglect as charged in the presentment, then your verdict must be not guilty as to this offense. Count 4, aggravated child abuse. Any person who commits the offense of aggravated child abuse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the act of abuse resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and serious bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child abuse, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated child abuse as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 4 and 5, aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intentionally or knowingly caused bodily injury to another. And 2, that the act resulted in serious bodily injury. For purposes of this count, intentionally, knowingly bodily injury and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated assault, then you may fix a fine in any amount not greater than $10,000, and you'll so report your fine on your verdict form. Excuse me. If you have a reasonable doubt as to the defendant's guilt of aggravated assault as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 4 and 5, reckless aggravated assault. Any person who commits the offense of reckless aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant recklessly caused bodily injury to another, and 2, that the act resulted in serious bodily injury. For the purpose of this count, recklessly bodily injury and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless aggravated assault, then you may fix a fine in any amount not greater than not greater than $5,000. And you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of reckless aggravated assault as charged in the presentment, then your verdict must be not guilty as to this offense. Ladies and gentlemen, anytime that I make a change, I'm making the change in the notebook that's black. It says original charge. This is the official original charge. Those are just your copies, okay? Lesser included offense counts 1, 2, 3, 4, and 5. Assault. Any person who commits an assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant caused bodily injury to another, and 2, that the defendant acted either intentionally, knowingly, or recklessly. For purposes of this count, intentionally, knowingly, recklessly, and bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of assault, then you may fix a fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of assault as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, 3, 4, and 5, misdemeanor reckless endangerment. Any person who commits the offense of misdemeanor reckless endangerment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant engaged in conduct which placed, and 3, that the defendant and his actions constitute a substantial step toward the commission of the specified criminal offense. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit the specified criminal offense. The essential elements necessary to constitute each specified criminal offense are set out in these instructions. The definition of attempt to commit a criminal offense and the fine associated with each attempt to commit a criminal offense is as follows. Count 1. Attempt to commit premeditated first-degree murder, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $50,000. Attempt to commit voluntary manslaughter, maximum fine $50,000. Attempt to commit child abuse, maximum fine $50. Attempt to commit child neglect, maximum fine attempt to commit child abuse, maximum fine $500.
That's so
Attempt to
terrible.
commit child neglect, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 2. Attempt to commit first-degree murder in the perpetration of a felony, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $25,000. Attempt to commit voluntary manslaughter, maximum fine $5,000. Attempt to commit child abuse, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 3. Attempt to commit first-degree murder in the perpetration of a felony, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $25,000. Attempt to commit voluntary manslaughter, maximum fine $5,000. Attempt to commit child neglect, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 4. Attempt to commit aggravated child abuse, maximum fine $25,000. Attempt to commit aggravated assault, maximum fine $5,000. Attempt to commit assault, maximum fine $500. Attempt to commit child abuse, maximum fine $500. Count 5. Attempt to commit aggravated child neglect, maximum fine $25,000. Attempt to commit aggravated assault, maximum fine $5,000. Attempt to commit assault, maximum fine $500.
attempt to commit child neglect, maximum fine $500. Count 6, attempt to commit tampering with evidence, maximum fine $5,000. Counts 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17, attempt to commit false report, maximum fine $5,000. Count 19, attempt to commit abuse of corpse, maximum fine $2,500. Count 20, attempt to commit failure to report death under suspicious, unusual, or unnatural circumstances, maximum fine $2,500. Facilitation of a felony. The following definition applies to any offense of facilitation that is charged or included as a lesser offense in these instructions. Any person who commits the offense of facilitation of a felony is guilty of a crime. For you to find the defendant guilty of facilitation of any offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit the specified offense, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of the specified criminal offense. And 3, that the defendant furnished such assistance knowingly. The essential elements necessary to constitute the specified criminal offense are set out in these instructions. The definition of facilitation of an offense and the fine associated with each facilitation offense is as follows. Count 1,
there's a lot of
facilitation of first degree murder, maximum fine $50,000. Facilitation of attempt to commit first degree murder, maximum fine $25,000. Facilitation of second degree murder, maximum fine $25,000. Facilitation of attempt to commit second degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 2, facilitation of first degree murder in the perpetration of a felony, maximum fine $50,000. Facilitation of attempt to commit first degree murder in the perpetration of a felony, maximum fine $25,000. Facilitation of second degree murder, maximum fine $25,000. Facilitation of attempt to commit second degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 3, facilitation of first degree murder in the perpetration of a felony, maximum fine $50,000. Facilitation of attempt to commit first degree murder in the perpetration of a felony, maximum fine $25,000. Facilitation of second degree murder, maximum fine $25,000. Facilitation of attempt to commit second degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine
I'd hate to have to
$2,500.
write this up.
Count 4, facilitation of aggravated child abuse, maximum fine $5,000. Facilitation of attempt to commit aggravated child abuse,
saying.
maximum fine $3,000. Facilitation of aggravated assault, maximum fine $5,000. Facilitation of attempt to commit aggravated assault, maximum fine $3,000. Facilitation of reckless aggravated assault, maximum fine $3,000. Count 5, facilitation of aggravated child neglect, maximum fine $5,000. Facilitation of attempt to commit aggravated child neglect, maximum fine $3,000. Facilitation of aggravated assault, maximum fine $5,000. Facilitation of attempt to commit aggravated assault, maximum fine $3,000. Facilitation of reckless aggravated assault, maximum fine $3,000. Count 6, facilitation of tampering with evidence, maximum fine $5,000.
Fine.
Facilitation of attempt to commit tampering
Fine,
with evidence,
not
maximum
including
fine
jail.
$3,000. Count 19, facilitation of abuse of the corpse, maximum fine $2,500. Criminal responsibility for conduct of another. A defendant is criminally responsible as a party to the offense charged and included if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense or to benefit in the proceeds or result of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. Under the theory of criminal responsibility, an individual's presence and companionship with the perpetrator of an offense before and after commission of an offense
or circumstances from which his or her participation in the crime may be inferred. No particular act need be shown, and the defendant need not have taken a physical part in the crime in order to be held criminally responsible. However, a defendant's mere presence during the commission of a crime is not enough to convict based on the theory of criminal responsibility for the conduct of another. The jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant the inference which the law permits the jury to draw. The inference may be rebutted by direct or circumstantial evidence or both, whether it exists in the evidence of the state or the evidence of the defendant. Before you can find the defendant guilty of being criminally responsible for an offense committed by the conduct of another, you must find that all the essential elements of the offense have been proven by the state beyond a reasonable doubt. Definitions. Intentionally or intent means a person acts intentionally with respect to the nature of the conduct or a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly or knew means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Recklessly or reckless means that a person acts recklessly with respect.
Okay, we are in jury instructions right now, and the part that they're talking about now is knowingly that somebody else committed a crime, but she knew, and therefore she's equally responsible. I feel like that they're covering both bases. I think that the prosecution is of thought and mind that her and Hunter unalived this baby together. And since he is mentally incompetent right now and has been admitted to a psych ward against will, and he is mentally not capable of testifying or withstanding in trial. So to me, it sounds like they, i.e. the prosecution,
Circumstances surrounding the conduct or the
are trying to lay the groundwork so that if he should ever become competent, they can go after him for the unaliving of this baby as well. So it appears to me that by what I'm hearing being read into the jury instructions, that they are looking at both of them. So she can be found guilty of the actual, she's got like 20 something counts. So she could be found guilty of manslaughter and then also be found guilty for knowing of with somebody else perpetrating.
result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown the defendant acted intentionally or knowingly. Adversely affect the child's health and welfare may include, but not limited to, the natural effects of starvation and dehydration. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, or any physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Child means a person under 18 years of age. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty, or a broken bone of a child who is 12 years of age or less. Cause of death. Before a defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the deceased was proximately caused by the criminal conduct of the defendant. The proximate cause of death is that cause which, in natural and continuous sequence, unbroken by any independent intervening cause, produces the death and without which the death would not have occurred. The defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of two or more persons may work concurrently to proximately cause the death, and in such case, each of the participating acts or omissions is regarded as a proximate cause. It is not a defense that the negligent conduct of the deceased may have also been a proximate cause of the death. However, it is a defense to homicide if the proof shows the death was caused by an independent intervening act or omission of the deceased or another, which the defendant, in the exercise of ordinary care, could not reasonably have anticipated as likely to happen. However, if in the course of ordinary care, the defendant should reasonably have anticipated the intervening cause, that cause does not supersede the defendant's original conduct, and the defendant's conduct is considered the proximate cause of death. It is not necessary that the sequence of events or the particular injury be foreseeable. It is only necessary that the death fall within a general field of danger which the defendant should have reasonably anticipated. If you find that the defendant's act, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have a reasonable doubt as to this proposition, then you must find her not guilty. Deliberation process. Each count of the presentment is a separate offense, and you must deliberate on each count. When you begin your deliberations on each count of the presentment, you must first deliberate on the indicted or charged offenses. If you unanimously find the defendant guilty of the indicted offense, you may stop your deliberations as to that count of the presentment. You would then begin your deliberations as to the remaining counts of the presentment. If you unanimously find the defendant not guilty of the indicted offense in each count, or you have a reasonable doubt, then you must unanimously find the defendant not guilty of the indicted offense and next consider the lesser included offenses in each count as set out below and in your verdict form. You must first deliberate on the greater offense as to each count and unanimously reach a verdict as to the greater offense before you move to the next lesser included offense within that particular count. If you unanimously reach a verdict as to the guilt of a defendant as to a greater offense, you may stop your deliberations as to that count. You would then proceed to the remaining counts of the presentment until you have reached a verdict on each count of the presentment. The order in which you are to consider the charges and lesser included offenses in each count is as follows. Count 1. 1. First degree murder. 2. Facilitation of first degree murder. 3. Attempt to commit first degree murder. 4. Facilitation of attempt to commit first degree murder. 5. Second degree murder. 6. Facilitation of second degree murder. 7. Attempt to commit second degree murder. 8. Facilitation of attempt to commit second degree murder. 9. Voluntary manslaughter. 10. Facilitation of voluntary manslaughter. 11. Attempt to commit voluntary manslaughter. 12. Facilitation of attempt to commit voluntary manslaughter. 13. Reckless homicide. 14. Facilitation of reckless homicide. 15. Criminally negligent homicide. 16. Facilitation of criminally negligent homicide. 17. Child abuse. 18. Child neglect. 19. Attempt to commit child abuse. 20. Attempt to commit child neglect. 21. Assault. 22. Attempt to commit assault. 23. Misdemeanor reckless endangerment. Count 2. 1. First degree murder in the perpetration of a felony. 2. Facilitation of first degree murder in the perpetration of a felony. 3. Attempt to commit first degree murder in the perpetration of a felony. 4. Facilitation of attempt to commit first degree murder in the perpetration of a felony. 5. Second degree murder. 6. Facilitation of second degree murder. 7. Attempt to commit second degree murder. 8. Facilitation of attempt to commit second degree murder. 9. Voluntary manslaughter. 10. Facilitation of voluntary manslaughter. 11. Attempt to commit voluntary manslaughter. 12. Facilitation of attempt to commit voluntary manslaughter. 13. Reckless homicide. 14. Facilitation of reckless homicide. 15. Criminally negligent homicide. 16. Facilitation of criminally negligent homicide. 17. Child abuse. 18. Attempt to commit child abuse. 19. Assault. 20. Attempt to commit assault. 21. Misdemeanor reckless endangerment. Count 3. 1. First degree murder in the perpetration of a felony. 2. Facilitation of first degree murder in the perpetration of a felony. 3. Attempt to commit first degree murder in the perpetration of a felony. 4. Facilitation of attempt to commit first degree murder in the perpetration of a felony. 5. Second degree murder. 6. Facilitation of second degree murder. 7. Attempt to commit second degree murder. 8. Facilitation of attempt to commit second degree murder. 9. Voluntary manslaughter. 10. Facilitation of voluntary manslaughter. 11, attempt to commit voluntary manslaughter. 12, facilitation of attempt to commit voluntary manslaughter. 13, reckless homicide. 14, facilitation of reckless homicide. 15, criminally negligent homicide. 16, facilitation of criminally negligent homicide. 17, child neglect. 18, attempt to commit child neglect. 19, assault. 20, attempt to commit assault. 21, misdemeanor
This
reckless
jury's going
endangerment.
to be out for a year.
Count 4, 1, aggravated child abuse.
It's going to
2,
be long.
facilitation of aggravated child abuse. 3, attempt to commit aggravated child abuse. 4, facilitation of attempt to commit aggravated child abuse. 5, aggravated assault. 6, facilitation of aggravated assault. 7, attempt to commit aggravated assault. 8, facilitation of attempt to commit aggravated assault. 9, reckless aggravated assault. 10, facilitation of reckless aggravated assault. 11, assault. 12, attempt to commit assault. 13, misdemeanor reckless endangerment. 14, child abuse. 15, attempt to commit child abuse. Count 5, 1, aggravated child neglect. 2, facilitation of aggravated child neglect. 3, attempt to commit aggravated child neglect. 4, facilitation of attempt to commit aggravated child neglect. 5, aggravated assault. 6, facilitation of aggravated assault. 7, attempt to commit aggravated assault. 8, facilitation of attempt to commit aggravated assault. 9, reckless aggravated assault. 10, facilitation of reckless aggravated assault. 11, assault. 12, attempt to commit assault. 13, misdemeanor reckless endangerment. 14, child neglect. 15, attempt to commit child neglect. Count 6, 1, tampering with evidence. 2, facilitation of tampering with evidence. 3, attempt to commit tampering with evidence. 4, facilitation of attempt to commit tampering with evidence. Count 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17. 1, false report. 2, attempt to commit false report. Count 19, 1, abuse of a corpse. 2, facilitation of abuse of a corpse. 3, attempt to commit abuse of a corpse. 4, facilitation of attempt to commit abuse of a corpse. Count 20, 1, failure to report a death under suspicious, unusual, or unnatural circumstances. And 2, attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances. The essential elements for each offense of each count of the presentment have been previously set forth in these instructions. Please refer to those essential elements as you deliberate on the charged offense or lesser included offense of each count of the presentment. Fines. Excuse me. If you find the defendant guilty beyond reasonable doubt of an offense, you may, in your discretion, fix a fine in any amount not to exceed the amount listed for that offense in these instructions and on the verdict forms. If after considering the charged offense and lesser included offenses in each count as set out above and in the verdict form, you find the defendant not guilty or have a reasonable doubt as to her guilt as to all counts and offenses, then you must return a verdict of not guilty and acquit the defendant. In considering the charged offense and lesser included offenses in each count, in this case, do not consider punishment. If you find the defendant guilty of any offenses of any count, the court will set punishment at a separate sentencing hearing. Y'all want to come up here for a second?
I think you found a typo.
Sidebar.
Y'all, that is one heavy verdict form. That thing is so loaded. It's going to take it. Finding her guilty is not going to be the problem. It's finding her guilty of what and placing it where. That is going to be your problem. That's why I hate the lessers. Either she's innocent or she's guilty. End of discussion. All these lesser thans. I don't know. I don't like the lessers. It's like you overcharge and then you throw the lessers in. Oh. Yeah, there's bound to be mistakes in that one. That thing's as thick as my Bible. I wouldn't want to be on this jury just for that purpose right there alone.
I live in the town this took place in. Oh my God, I really think the verdict will come quickly despite the amount of counts. I don't know. It possibly could. I just think there's so many counts here that it's going to take time for them to weed through it all. I'm sorry you live there. I mean, I'm sure it's a great town. I'm sorry that you're getting this kind of this kind of publicity. This is not what your town wants. I guarantee it. Thank you for joining me and choosing to watch it here. I appreciate it so very much. I know I'm a little quieter than normal, but there's just so much here. I don't want to talk over it or miss anything. Really don't. You would have thought they had all this figured out. This is a heavy form. How many hours do you think it's going to take, Jamie? How many hours? See if you're close.
That's why I tell you, this is the original. I'll tell her. This is what it is.
Yeah, they're discussing something vigorously. Well, he should. It's his client. I'm always
All right.
put up any.
Now, ladies and gentlemen, remember, when you go back there and you select a four-person, this is the official jury charge. Okay?
That book.
And I'm not going to take up your books and make a change in every one of your books and hand them back out. Otherwise, we'd be here till later tonight. So I'm going to make the change on page 48. And when you deliberate, you go by what this black notebook says. Can everybody do that? Everybody's shaking their head yes. All right. Let me start that over. If after your deliberations you find the defendant guilty of first-degree murder, we will then proceed to sentencing and you will set the punishment. If you find the defendant guilty of any offense in counts 4 through 20, the court will set the punishment at a separate sentencing hearing. You'll be provided with forms for all possible verdicts in this case, and it will be at the back of these instructions. The jury, the jury will mark the appropriate verdict on the form by checking the box next to your verdict, and your foreperson will sign and date the verdict form. Now, in your books, you don't have, you may have. You have verdict forms? All right. This goes back to what I said about the original notebook. You use the verdict forms in this black notebook. All right. Verdict form count 1. We, the jury, find the defendant Megan Boswell mark the appropriate 1. Checkbox 1, guilty of first-degree murder, or checkbox 2, guilty of facilitation of first-degree murder. Find amount $ blank, not more than $50,000. Or checkbox 3, guilty of attempt to commit first-degree murder. Find amount $ blank, not more than $50,000. Or checkbox 4, guilty of facilitation of attempt to commit first-degree murder. Find amount $ blank, not more than $25,000. Or checkbox 5, guilty of second-degree murder. Find amount $ blank, not more than $50,000. Or checkbox 6, guilty of facilitation of second-degree murder. find amount dollar sign blank, not more than $25,000. Verdict form, count one continued, checkbox 7, guilty of attempt to commit second degree murder, find amount dollar sign blank, not more than 25,000, or checkbox 8, guilty of facilitation of attempt to commit second degree murder, find amount dollar sign blank, not more than 10,000, or checkbox 9, guilty of voluntary manslaughter, find amount dollar sign blank, not more than $10,000.
I know
Checkbox
it did,
10,
Don.
guilty of facilitation of voluntary manslaughter, find amount dollar sign blank, not more than $5,000, or checkbox 11, guilty of attempt to commit voluntary manslaughter, find amount dollar sign blank, not more than $5,000, or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter, find amount dollar sign blank, not more than $3,000, or checkbox 13, guilty of reckless homicide, find amount dollar sign blank, not more than $5,000, or checkbox 14, guilty of facilitation of reckless homicide, find amount dollar sign blank, not more than $3,000. Excuse me. Or verdict form count one continued, checkbox 15, guilty of criminally negligent homicide, find amount dollar sign blank, not more than $3,000, or checkbox 16, guilty of facilitation of criminally negligent homicide, find amount dollar sign blank, not more than $2,500, or checkbox 17, guilty of child abuse, find amount dollar sign blank, not more than $2,500, or checkbox 18, guilty of child neglect, find amount dollar sign blank, not more than $2,500, or checkbox 19, guilty of attempt to commit child abuse, find amount dollar sign blank, not more than $500, or checkbox 20, guilty of attempt to commit child neglect, find amount dollar sign blank, not more than $500, or checkbox 21, guilty of assault, find amount dollar sign blank, not more than $2,500, or checkbox 22, guilty of attempt to commit assault, find an amount of dollar sign blank, not more than $500, or verdict form count one continued, checkbox 23, guilty of misdemeanor reckless endangerment, find amount dollar sign blank, not more than $2,500, or checkbox 24, not guilty, 4-person signature line.
I don't know what to do, Don. I can't just leave the
verdict form count 2, with jury find the defendant Megan Boswell, marked appropriate 1, checkbox 1, guilty of first degree murder in the perpetration of a felony, or checkbox 2, guilty of facilitation of first degree murder in the perpetration of a felony, find amount dollar sign blank, not more than $50,000, or checkbox 3, guilty of attempt to commit first degree murder in the perpetration of a felony, find amount dollar sign blank, not more than $50,000, or checkbox 4, guilty of facilitation of attempt to commit first degree murder in the perpetration of a felony, find amount dollar sign blank, not more than $25,000, or checkbox 5, guilty of second degree murder, find amount dollar sign blank, not more than $50,000, or verdict form count 2 continued, checkbox 6, guilty of facilitation of second degree murder, find amount dollar sign blank, not more than $25,000, or checkbox 7, guilty of attempt to commit second degree murder, find amount dollar sign blank, not more than $25,000, or checkbox 8, guilty of facilitation of attempt to commit second degree murder, find amount dollar sign blank, not more than $10,000, or checkbox 9, guilty of voluntary manslaughter, find amount dollar sign blank, not more than $10,000, or checkbox 10, guilty of facilitation of voluntary manslaughter, find amount dollar sign blank, not more than $5,000. Checkbox 11, guilty of attempt to commit voluntary manslaughter, find amount dollar sign blank, not more than $5,000, or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter, find amount dollar sign blank, not more than $3,000, or checkbox 13, guilty of reckless homicide, find amount dollar sign blank, not more than $5,000, or verdict form count 2 continued. Checkbox 14, guilty of facilitation of reckless homicide, find amount dollar sign blank, not more than $3,000, or checkbox 15, guilty of criminally negligent homicide, find amount dollar sign blank, not more than $3,000, or checkbox 16, guilty of facilitation of criminally negligent homicide, find amount dollar sign blank, not more than $2,500, or checkbox 17, guilty of child abuse, find amount dollar sign blank, not more than $2,500, or checkbox 18, guilty of attempt to commit child abuse, find amount dollar sign blank, not more than $500, or checkbox 19, guilty of assault, find amount dollar sign blank, not more than $2,500, or checkbox 20, guilty of attempt to commit assault, find amount dollar sign blank, not more than $500, or verdict form count 2 continued. Checkbox 21, guilty of misdemeanor reckless endangerment, find amount dollar sign blank, not more than $2,500, or checkbox 22, not guilty. 4-person signature line date blank. Verdict form count 3. We, the jury, find the defendant Megan Boswell marked the appropriate 1. Checkbox 1, guilty of first degree murder and perpetration of a felony, or checkbox 2, guilty of facilitation of first degree murder and perpetration of a felony. Fine amount $ blank, not more than $50,000, or checkbox 3, guilty of attempt to commit first degree murder and perpetration of a felony. Fine amount $ blank, not more than $50,000, or checkbox 4, guilty of facilitation of attempt to commit first degree murder in the perpetration of a felony. Fine amount $ blank, not more than $25,000, or checkbox 5, guilty of second degree murder. Fine amount $ blank, not more than $50,000, or verdict form count 3 continued. Checkbox 6, guilty of facilitation of second degree murder. Fine amount $ blank, not more than $25,000, or checkbox 7, guilty of attempt to commit second degree murder. Fine amount $ blank, not more than $25,000, or checkbox 8, guilty of facilitation of attempt to commit second degree murder. Fine amount $ blank, not more than $10,000, or checkbox 9, guilty of voluntary manslaughter. Fine amount $ blank, not more than $10,000, or checkbox 10, guilty of facilitation of voluntary manslaughter. Fine amount $ blank, not more than $5,000, or checkbox 11, guilty of attempt to commit voluntary manslaughter. Fine amount $ blank, not more than $5,000, or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter. Fine amount $ blank, not more than $3,000, or checkbox 13, guilty of reckless homicide. Fine amount $ blank, not more than $5,000, or verdict form count 3 continued. Checkbox 14, guilty of facilitation of reckless homicide. Fine amount $ blank, not more than $3,000, or checkbox 15, guilty of criminally negligent homicide. Fine amount $ blank, not more than $3,000, or checkbox 16, guilty of facilitation of criminally negligent homicide. Fine amount $ blank, not more than $2,500, or checkbox 17, guilty of child neglect. Fine amount $ blank, not more than $2,500, or checkbox 18, guilty of attempt to commit child neglect. Fine amount $ blank, not more than $500, or checkbox 19, guilty of assault. Fine amount $ blank, not more than $2,500, or checkbox 20, guilty of attempt to commit assault. Fine amount $ blank, not more than $500, or verdict form count 3 continued. Checkbox 21, guilty of misdemeanor reckless endangerment. Fine amount $ blank, not more than $2,500, or checkbox 22, not guilty, 4-person signature line date blank. Verdict form count 4, we the jury find the defendant Megan Boswell, marked appropriate 1. Checkbox 1, guilty of aggravated child abuse. Fine amount $ blank, not more than $50,000, or checkbox 2, guilty of facilitation of aggravated child abuse. Fine amount $ blank, not more than $25,000, or checkbox 3, guilty of attempt to commit aggravated child abuse. Fine amount $ blank, not more than $25,000, or checkbox 4, guilty of facilitation of attempt to commit aggravated child abuse. Fine amount $ blank, not more than $10,000, or checkbox 5, guilty of aggravated assault, not more than, fine amount $ blank, not more than $10,000, or checkbox 6, guilty of facilitation of aggravated assault. Fine amount $ blank, not more than $5,000, or verdict form count 4 continued. Checkbox 7, guilty of attempt to commit aggravated assault. Fine amount $ blank, not more than $5,000, or checkbox 8, guilty of facilitation of attempt to commit aggravated assault. Fine amount $ blank, not more than $3,000, or checkbox 9, guilty of reckless aggravated assault. Fine amount $ blank, not more than $5,000, or checkbox 10, guilty of facilitation of reckless aggravated assault. Fine amount $ blank, not more than $3,000, or checkbox 11, guilty of assault. Fine amount $ blank, not more than $2,500, or checkbox 12, guilty of attempt to commit assault. Fine amount $ blank, not more than $500, or checkbox 13, guilty of misdemeanor reckless endangerment. Fine amount $ blank, not more than $2,500, or checkbox 14, guilty of child abuse. Fine amount $ blank, not more than $2,500, or verdict form count 4 continued. Checkbox 15, guilty of attempt to commit child abuse. Fine amount $ blank, not more than $500, or checkbox 16, not guilty, 4-person signature line date blank. Verdict form count 5, we the jury find the defendant Megan Boswell marked the appropriate 1. Checkbox 1, guilty of aggravated child neglect. Fine amount $ blank, not more than $50,000, or checkbox 2, guilty of facilitation of aggravated neglect. Fine amount $ blank, not more than $25,000, or checkbox 3, guilty of attempt to commit aggravated child neglect. Fine amount $ blank, not more than $25,000, or checkbox 4, guilty of facilitation of attempt to commit aggravated child neglect. Fine amount $ blank, not more than $10,000, or checkbox 5, guilty of aggravated assault. Fine amount $ blank, not more than $10,000, or checkbox 6, guilty of facilitation of aggravated assault. Fine amount $ blank, not more than $5,000. Verdict form count 5 continued. Checkbox 7, guilty of attempt to commit aggravated assault. Fine amount $ blank, not more than 5,000. Or checkbox 8, guilty of facilitation of attempt to commit assault, aggravated assault. Fine amount $ blank, not more than 3,000. Or checkbox 9, guilty of reckless aggravated assault. Fine in amount $ blank, not more than 5,000. Or checkbox 10, guilty of facilitation of reckless aggravated assault. Fine amount $ blank, not more than 3,000. Or checkbox number 11, guilty of assault. Fine in amount $ blank, not more than 2,500. Or checkbox 12, guilty of attempt to commit assault. Fine amount $ blank, not more than 500. Or checkbox 13, guilty of misdemeanor reckless endangerment. Fine amount $ blank, not more than 2,500. Or checkbox 14, guilty of child neglect. Fine amount $ blank, not more than 2,500. Or verdict form count 5 continued. Checkbox 15, guilty of attempt to commit child neglect. Fine amount $ blank, not more than 500. Or checkbox 16, not guilty. 4-person signature line date blank. Verdict form count 6. We, the jury, find the defendant Megan Boswell, mark the appropriate 1. Checkbox 1, guilty of tampering with evidence. Fine amount $ blank, not more than $10,000. Or checkbox 2, guilty of facilitation of tampering with evidence. Checkbox amount $ blank, not more than 5,000. Or checkbox 3, guilty of attempt to commit tampering with evidence. Fine amount $ blank, not more than 5,000. Or checkbox 4, guilty of facilitation of attempt to commit tampering with evidence. Fine amount $ blank, not more than 3,000. Or checkbox 5, not guilty. 4-person signature line date blank. Verdict form counts 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17. We, the jury, find the defendant Megan Boswell mark the appropriate 1. Checkbox 1, guilty of false report. Fine amount $ blank, not more than 5,000. Or checkbox 2, guilty of attempt to commit false report. Fine amount $ blank, not more than 3,000. Or checkbox 3, not guilty. 4-person signature line date blank. Verdict form count 19. We, the jury, find the defendant Megan Boswell mark the appropriate 1. Checkbox 1, guilty of abuse of a corpse. Fine amount $ blank, not more than $3,000. Or checkbox 2, guilty of facilitation of abuse of a corpse. Fine amount $ blank, not more than $2,500. Or checkbox 3, guilty of attempt to abuse a corpse. Fine amount $ blank, not more than $2,500. Or checkbox 4, guilty of facilitation of attempt to commit abuse of a corpse. Fine amount $ blank, not more than $500. Or checkbox 5, not guilty. 4-person signature line date blank. Verdict form count 20. We, the jury, find the defendant Megan Boswell mark the appropriate 1. Checkbox 1, guilty of failure to report a death under suspicious, unusual, or unnatural circumstances. Fine amount $ blank, not more than 3,000. Or checkbox 2, guilty of attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances. Fine amount $ blank, not more than 2,500. Or checkbox 3, not guilty. 4-person signature line date blank. Back on page 48. You'll be provided with, I just did that. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. If you find the state has proven the defendant guilty beyond a reasonable doubt, then you should find her guilty. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to her guilt, then you must find the defendant not guilty. I'm going to stop right there. Is there lunch here? Your lunch is here. I'm going to let you go eat. I want you to take your notebooks and sit them on your chair and leave them out here. I'm going to have you go with the officer, eat lunch. When we come back, the parties will argue, then I will finalize the charge.
Everyone stand, please.
I need one more stitch, y'all. Okay. They are finalizing everything in this case. We will have an hour lunch. They will come back. We will have our closing arguments. I just pray to God our closing arguments are not a day and a half for the prosecution. I am a little perplexed as to why they did not try to provide any defense. But then when I look back at how they were asking questions, especially of the ME, I can see where they're not going to. Do I think it's a wise thing in this case? I don't know. I didn't think she would get on the stand. I didn't think it would be good for her to get on the stand. That's such a horrible view of me. Look at this neck. It's awful, y'all. I'm showing my age there. Okay, let's talk a second before we go into the Simitilli trial. The rose petal trial has started. And I don't mind staying at night and us doing that at night to catch up. But the Simitilli, I think we're too invested in. Sorry, but I'll be happy starting tomorrow night. Today is my son's 25th birthday. My eldest is 25. I can't believe it. I'm feeling very old. And then, so it depends on if we do anything tonight or not. If we don't do anything tonight, then we'll be on today. Let's go on over to the Simitilli trial.
Robert Baker and Monica Simitilli, Robert Baker was driving that truck. Is that right?
Yes.
Okay. And you observed him drive that truck to this parlor bar. Is that right?
I just observed him in front of the parlor bar. I didn't see him drive up to it.
Okay.
That's when I first spotted them, was at the parlor bar.
Okay. And did you surveil him getting out of the vehicle?
Yes.
And he got out of the driver's side of the vehicle?
Yes.
Okay. And then you testified earlier, we don't have to go through it, but you were there approximately 30 minutes and saw the two of them inside, correct?
Correct.
And then you saw them leaving, and did you observe them leaving at the valet?
I did.
Okay. And you saw them engaged in a kiss?
I did, from the inside of the establishment. They had a large window and I was inside. They were outside. I had a clear, unobstructed view of both of them hugging and both of them kissing multiple times.
Got it. Okay. And then you followed them over to this establishment, the Dime?
Correct.
Okay. And let me ask you a question. This occurrence you testified about, seeing Monica come out of the establishment, and I think you described her having some interaction with this African-American gentleman.
Yes.
You observed that?
I did.
And you were able to see clearly what occurred, correct?
Yes.
And am I correct? How long was that event? How long between the time she came out of the establishment and smoked a cigarette and had some kind of interaction to when she went back in?
Approximately 10 minutes.
Okay. And am I correct that at no time during that entire 10 minutes you saw the things you saw? Did you ever see Robert Baker?
Not during that time.
Okay. You never saw him anywhere in the vicinity outside?
No,
And you never saw him anywhere in the vicinity inside the bar? You were not inside the bar?
correct. None of us were inside.
Okay. And Detective, after you followed Mr. Baker driving the truck with Ms. Simontilli inside, you testified about seeing him stop the vehicle at this mobile gas station, right?
Yes,
And you saw him slam the door and storm away.
yes.
And the next time you ever saw Mr. Baker was heading towards this residence in the Veterans Village, correct?
No, I followed him immediately from when he left the truck and continued to follow him while he was on foot and I was in my vehicle.
Okay. But you followed him as he was headed towards the Veterans Village?
Not necessarily. That eventually happened, but in between, about an hour and a half worth of him walking to Van Nuys Boulevard, northbound, got onto a bus, like I mentioned previously,
Right.
and then jumping on the bus, getting off the bus, walking back. That took well over an hour for all that to happen, and then eventually is when the cab picked him up, and then he proceeded to Salem and Glendale.
Got it. I wasn't clear and I apologize.
No, sorry.
I wasn't, he didn't go any other location other than between where you first saw him after he left the truck and Valley Village. He didn't make any other stops.
Not to talk to anybody, if that's what you're insinuating. He didn't talk to anybody and stop anywhere else. He did the things I had previously mentioned, though.
He took the bus, then he took the cab and
Correct.
went to Valley Village.
Correct.
Okay, now. Am I correct that you testified that you saw from very close up, sitting right beside Miss Simontilli, her crying uncontrollably?
Yes,
Okay. And that was because you pulled into a parking space. I think you described it as a stall right beside Miss Simontilli.
correct.
And at this point, she was no longer in the passenger seat. She was in the driver's seat. Correct?
That is correct.
Okay. And Detective, you specifically, when you pulled in, you were there monitoring Monica Simontilli, correct?
Yes,
Okay. And you were parked immediately to the left of her?
yes,
Okay. And her window was down and your window was down?
that is correct.
Okay. And you could both see and hear her crying uncontrollably?
Yes,
And she wept in a very loud manner?
yes,
And she wept for approximately 20 minutes?
I would say about 20 minutes.
Okay. And you also said that while she was weeping and crying uncontrollably, she said a couple of times, "I'm so stupid, I'm so stupid."
Yeah, at least a few times.
But you weren't sure, you saw a phone, but you weren't sure whether she was on the phone, was texting, or making a call.
It sounded like to me she was either talking to someone or leaving a voicemail, but trying to communicate, not just staring at her phone.
Okay. And what did that phone look like?
I don't remember seeing her phone very well because she kept it at her lap and I could see the illumination from the screen, but I could not see the phone itself.
So at no time during this 20 minutes did you ever see a phone?
No,
And at no time did you later attempt to verify whether the phone was actually in use? Am I
no.
correct?
And I actually did hear the phone ringing as well.
Okay. Did you see her answer the phone?
No, I saw her. It seemed like to me she was making the call. I never heard her phone ring. I could just hear the call going out, like ringing from her end, not from a cell phone. It's like a receiving end, more like an outcalling end.
So
You know when you have your phone on speakerphone.
yes, sir. So what you think you heard was a ringing as if her phone was on speakerphone in her lap, and she was trying to call somebody else.
Yes.
Okay, but you never heard the ringing. You never could determine whether anybody answered or she was actually ever talking to him.
That is correct.
Okay, got it. Detective, I just want to be sure. The only time that you yourself ever were surveilling Monica Cementilli, that you saw her with Mr. Baker, was on the 21st. Is that right?
The 21st into the 22nd.
Okay. That was the only time of the times you surveilled her that you saw them.
Together? Yes.
Okay. Thank you. Nothing further.
You're welcome.
Anything further by the people?
No, thank you.
Thank you, Detective Anaya. You are excused.
Thank you, Your Honor.
Let's take our afternoon recess for 15 minutes. Be back in 15 minutes.
So now we have both of them on recess. Let me get this matted down. I'm making sure we're all good with my knots. My last knot was here. Yep. Okay. Okay, let's get back to the court filings of today that we were reading. I'm going to bring this down here. Bring up the court filings. Okay, that's done. So what I think I'll do is I will try and catch us up in the rose petal this afternoon or this evening. We'll do some evening and get caught up in that, because I have a feeling that we may eventually have we'll eventually end up over there anyway. I hope and pray that the prosecution in today's Cementilli will rest. We'll see. Okay. Let me get the gloss on because we got a lot of reading to do, y'all. All right. So back to the Commonwealth. So what this is, let me mark my place so I know where I'm at. Page 6. This is the Commonwealth versus Karen Reed, the defendant's motion to reconsider reciprocal discovery order. So what they're wanting is they're saying that what's happening is the prosecution is wanting certain reciprocal evidence or information for trial. And what is being argued is that you have to share, and I'm trying to find a way to put this that doesn't sound crazy. You have to share all your evidence with the opposing side. That's discovery. That's we understand. But there's some things that you don't have to. And from what I'm understanding, once again, I'm not a lawyer, but from what I'm understanding, and if there's a lawyer who wants to correct me or help me explain it better, you're more than welcome. A case one is that there is some evidence, like impeachment evidence, that you do not have to turn over, because that was forced in the first trial, and Jennifer McKay was able to finagle her way out of an impeachment, which we noticed, but it was just crazy. So let's continue reading. You'll get the gist. When the defense has impeachment material it intends to use at trial, the presumption should be that it is not discoverable for trial. Generally, a defendant need not reveal his defense. There you go. Commonwealth versus Edward, ... The defense does acknowledge that allowing the defendant to withhold evidence against certain witnesses who is certain to be called to testify would undermine the discovery rules and allow attorneys to return to trial by ambush. Theatrics do not accord with our discovery process. So there you go. Good for you. Durham 466 MASH at 219, quoting Commonwealth versus Reynolds. So they are quoting from another argument. That is so funny. I don't know why my iPad is not charging. I mean, let me reorganize some things here. I don't know why. The iPad has decided it's not going to play nice. And I got to have it when my son goes and have lunch with his papa. Let's see if that works. There we go. After all, the defense is not requesting to withhold impeachment evidence until the very moment that the evidence would be sprung upon the witness on the stand. Rather, in an effort to avoid impropriety rather than create it, the defense merely requests to withhold impeachment evidence until after the witness has testified on direct examination, such that the witness cannot unfairly preempt the confrontation. Once the witness testimony is recorded, the defense would produce the relevant impeachment evidence that they intend to use upon cross-examination to the prosecution. So they can adequately prepare for the redirect examination. As a matter of protocol posture, as the court and parties are well aware, Ms. Reed is facing a retrial as a result of intentional mistrial. Oh, hold on. I'm so sorry, babe. I was going to tell you today, there's just no way we can do it. But when we do get ready to do it, we'll set it up where he can go. Go. Sorry. As a matter of protocol posture, the court and parties are well aware that Ms. Reed is facing a retrial as a result of an initial mistrial. Nearly all or all of the civilian and law enforcement witnesses that will be called in this matter have already testified at least once, and sometimes 3 or more times under oath, either during the state grand jury proceedings, federal grand jury proceedings, or during the first trial. The only witnesses who will appear to not have testified to this point would be a smaller number of experts who may yet to be subject to voir dire. To the extent that the defense thought to maintain any element of surprise, and the defense would suggest that Ms. Reed has been far more forthcoming than most criminal defense prior to her first trial. In other words, dude, we bent over backwards. I think it's time for you guys to just shut up. Much to the surprise has been foiled. In other words, we were really forthcoming, and that didn't work for us. What the defense requests now, that the court not order the defense to produce impeachment material, will aid the balancing and the need for reciprocal disclosure completed by Rule 14, with the need for remedial discovery measures to protect the defense right to a fair retrial. Massachusetts ... The preemption of impeachment material by prosecution witness is unfair because the record clearly demonstrates that the witness discussed above, i.e. Jen McCabe, included PF one of the children, Lieutenant Lank and Jennifer McCabe, and Mr. Proctor. For those of you who weren't here, Jennifer McCabe did not disclose to anyone at any time until trial that she had been to Lieutenant Lank's home. And that was only found out because when they searched her metadata on her phone, it showed that she was there for 40 odd minutes with PF. And she claimed she was just dropping off PF, and she's friends with Mrs. Lank, and Mrs. Lank got in the car because so and so was crying. And yeah, but she had preemptively finagled her wording, as per the defense, to protect her from an impeachment or earlier occasion or likely violated sequestration order for the court. In this, it also states that some of the witnesses were supposed to be sequestered were looking at the trial online because of a comment that was made led them to believe that the sequestration was broken. The defense is requesting that the court modify the order for reciprocal discovery only to the extent necessary to prevent the prosecution witnesses from using pretrial production of impeachment evidence to tailor their response as the interest of justice require. That's really good. See ... Whether the aforementioned, and now I can't read it because of all this. Give me a minute. Whether the aforementioned violations are characterized as a violations of the discovery order or sequestration order, the court is empowered to impose sanctions ahead of Ms. Reed's retrial to remediate the threat of injustice under either scheme. ... Finally, the defense is not requesting the court for permission to engage in trial by ambush, nor to engage in theatrics. Durham ... Marshall CJ descending, the effectiveness of cross-examination often depends on being able to surprise a witness, particularly an accusing witness, with evidence that contradicts or inconsistent with his trial testimony. A second trial following the state of federal grand juries and exclusive first trial can hardly be called trial by ambush. To the contrary, the amendments requested by the defense will permit the jury to access for themselves the reliability of the witness memory or whether an accuser is truthful. The defense is simply requesting a fair and equal opportunity for each party to confront adverse witnesses with impeachment evidence without the witness being able to review such material and alter their response accordingly. In conclusions from the above reasons, Ms. Reed respectfully requests the Honorable Court to allow the motion respectfully submitted. By the way, she does have a new attorney on board. And okay, let's see who all's listed. You got Jackson, you got Yannetti, you got Robert J. Lassetti, and then you have somebody else who's come on after this. So that there is the whole thing. I'm concerned cause with Bev will not be fair and will stop the defensive only. Yeah, I don't think this has been fair with the defense from day one, but now I'm really challenged over the retrial and their ability to continue. I just don't think that some of the rulings, I mean, all the rulings have gone in favor of the prosecution, nothing in favor of the defense. Yeah, bedrow. Yep. So it is a frustration. It is a frustration. And I really feel for her because, hold on. FYI reminder, today's Matt's birthday. I don't understand how so much has gone wrong for her in this case. And the thing with this is, oh, how do you beat a corrupt judge? I can tell you one way, but it would not be, I may not be sitting here tomorrow if I did. Read between those lines. I'm surprised they have not tried to get her thrown out, in all honesty. I don't understand how she's still sitting there. I don't. I don't. How is she still sitting there? I don't know. It's hard. I still am of a belief that if there's a mistrial, that it should automatically require a new judge. Yeah, exactly. I don't know how they're gonna find a jury now. I really don't. They're not changing the venue. And the thing for me also is that you have, I don't understand. I think it should be law that if there's a retrial, then they have to get a whole new judge. I don't think it's especially on something this important. Well, it's gone up to the Supreme Court, the mistrial has gone as far as it can. And then, and all that, but I think that when you have a declared mistrial, that the judge should be a different judge the second time around. Automatically, the entire court staff should be second. I understand that, we do have a new special district attorney, which to me is kind of crazy. A new special district attorney. Yeah. That Yes, they can. Okay, we're gonna come back to court.
And so you went from LAPD to.
I do.
Please have a seat. And for the record, say and spell your first and last name, please.
Steve Castro, Stevecastro.
Thank you. Detective Castro, are you currently employed?
I am.
Where are you employed?
The Englewood Police Department.
Okay. Back in 2017, what was your occupation?
I was a homicide D3 detective with the Los Angeles Police Department assigned to Operation Valley Bureau.
And overall, how long have you been a sworn peace officer?
34 and a half years.
Okay, so you went from LAPD to Englewood?
Yes.
All right. Back in the time frame of 2017, can you explain what your role was?
Yes, I was a D3 detective supervisor in charge of the entire table as a coordinator. And I was in charge of 6 detectives.
Did you at some point, was that in a homicide unit?
That's correct.
Okay. And where was that homicide unit out of? What area of Los Angeles?
We worked out of the Van Nuys station.
During that time, did you supervise some detectives that we've heard from? A Verna, a Parshall, did you supervise them?
Yes.
And then how does that work as far as your rank? We're a D3 as opposed to somebody who's in homicide as a detective?
Yes, when you become a detective, you become a D1 where you're an investigator. Then you can promote to a D2, which you're a supervisor. And then you promote to a D3, which now you're a supervisor in charge of the entire squad.
January 2017, how long had you been in LAPD, the homicide unit in the Valley?
Well, I was working in North Hollywood homicide in 2005. We became centralized in 2015. So out of Valley Bureau homicide, approximately 2 years.
And then how long overall in homicide?
18 years.
Okay. Did you respond to a radio call then of an occurrence that occurred at 5012 Queen Victoria Street, or road actually, in Woodland Hills on January 23rd, 2017?
Yes,
Did you go to that location that night?
I did.
Exhibit 9 was on the screen, page 8. Is that the location that you responded to?
Yes.
About what time did you get there?
I'd have to look at the crime scene log to be exact, but I'm thinking somewhere around 7 p.m., maybe 1900 hours, something to that effect.
And when you got there, do you recall who was there? Not every single person, but who had charge of the scene?
Well, once we arrived, we were in charge of the scene, but I remember there being, it's possible, captain there, a couple detectives, some officers that were there. The yellow tape was up.
Was that case then assigned to Detectives Parshall and Verna?
Yes.
Were they with you?
They arrived a little after me.
And then when you're at the scene, what did you proceed to do?
So when I'm at the scene, I basically delegate. We knew that on that night that the detectives, the lead detectives, were going to be Detective Parshall and Verna. They're assigned prior. That week you're on call, you designate whoever the next person is up. So they were the lead detectives, and then there's 4 other detectives, and I usually delegate to them which one's doing the crime scene, which one is helping out with interviews or looking for surveillance, things of that nature.
Speaking of surveillance, did you yourself locate some surveillance?
Yes.
Okay. What's already been marked as Exhibit 9, page 4. So circled right here with the red circle, did you recognize that while you were there in person, that location?
Yes.
There's our video camera right there.
There was.
And Exhibit 9, page 5, a close-up there, was that a video camera or surveillance type equipment that was affixed to that structure right there?
Yes.
On People's 9, page 4, can you tell us in the orient, what street is this that's running from the bottom to the top of the photograph?
I think that's Queen Victoria.
And then the street at the bottom that intersects it along the bottom right here.
Oh, I forget the street. That street goes all the way up to Ventura.
Is it Oakdale?
That's correct. Yes.
Did you make an attempt then to retrieve the video surveillance from that location?
We viewed it.
You viewed it. Who did you
Yes.
view it with?
Detective Bucknell.
Okay, so you went to that actual location and did you meet someone at the location who showed you the video?
Yes, I believe. I don't remember who it was, but yes.
Okay, and that was the day of the murder?
Yes. Or right around there. Yes.
Okay, and if I may, what's already been marked as People's 19, if I may play a video. The Queen Victoria surveillance video, sorry. Just to make sure, because on 19 we have multiple videos. If I may play that. Well, if you could just pause it for 1 second right there. So we're just pausing it right there. That photograph up there, the street that runs from left to right, what street is that? There's a car traveling on it.
That's okay.
Okay, so is that the same view that we saw earlier? And the street that if you were to go to the right, does that go up the hill to the Cemetery residence?
That is correct.
Okay, just switching back very quickly. That's the view from this camera then looking in the direction of that car that was traveling. Is that correct?
Correct.
Does that video then that you just watched in court depict what you saw that day when you viewed the video at that location?
Yes.
And was that showing the two, let's call them joggers wearing the hooded sweatshirts?
Yes.
What's been marked as People's 19, page 21. Is that a screenshot then of what we just watched on the video?
It is.
Okay. Did you note the timestamp that was on the video while you're watching it live that day on the 23rd of January 2017?
Yes.
And did you note the timestamp on it if it was accurate?
It was off.
How was it off?
Exactly what it says there. 1 hour fast.
So the timestamp showed 1 hour fast.
Correct.
Okay. So if the timestamp is 17:18 on the actual video, what is that in regular time?
That would be 5:18.
Okay. And so then you were able to determine that the video was actually at 4:18 p.m.?
Yes.
And how did you determine that?
By looking at the video and then comparing it to the real time.
Okay. All right. And then there's another video. Did you also look at a video of a car leaving this area and take that as part of your evidence?
Yes.
I was second video. It's also on People's 19. forced leaving the scene.
So June, yes, they could go to another county, but I don't think any county nearby is gonna be easy. I think it's gonna be hard no matter what they do. I'm gonna let this run to the end of its time, and then we've got a
Okay.
couple of
The
hearings
video up on
to
the
go
screen,
on.
that forced leaving, that's the same intersection we've been talking about now, leaving from the direction of the cemetery residents, leaving and going right on Oakdale, is that correct? And exhibit 19, page 23, just for reference. Is that a still shot of what we're looking at on the video? And again, 1 hour ahead.
That is correct.
So that's at 4:53 p.m.
Yes.
Did you put out some type of crime broadcast
No.
regarding this?
A crime alert.
Okay, what is that?
Yes. That a crime alert, we manufacture that at the station and we put information of what we're looking for in a certain situation. In this case, this murder.
And we have People's Exhibit 7 then. Is this an example of some of the crime alerts that you helped to create?
Correct.
What's the purpose of this?
This is for the purpose of police officers that go out and patrol. They're aware of the situation. They're aware of this flyer. They're aware of what took place and they're aware of what we're looking for.
And then what do you put on as far as the photographs? What are the photographs that you put on this crime alert?
Well, in this case, we determined these two individuals to be the suspects. The vehicle up top is the vehicle that the victim owned, not exactly his vehicle, the exact same vehicle though, but not his. And then we put a little narrative, what we're looking for.
Does this go internally then within law enforcement?
Yes.
Does it go out to the public? Did you do anything to alert the public that you need their help or assistance with these photographs of the two individuals or the car?
What I did was what we always do on a case like this, we put out a press release. And
When
that
you
was
say-
done as well.
I'm sorry, go ahead.
That was done as well.
And when you say a case like this, what do you mean?
Well, a murder in this situation, we usually put out press releases on that.
For the press release, and then did you release these photographs of the two individuals jogging, if you remember?
I don't remember if we did immediately or not. I don't recall.
Now, while you're at the scene, was there anything else specific that you did at the scene aside from looking for the videos and directing individuals to do different tasks?
Well, like I said, when we arrived there, we looked at the crime scene. We tried to identify evidence, whether it be biological, trace, technological. Door knock neighbors. I know I went there the next day and door knocked a few neighbors myself. I don't know specifically what you're asking though in regards to what else I did.
That's fine. Now, did you also receive a call from a Salma Cherry on June 25th?
Yes.
And what did he tell you?
He was giving me information of when he last spoke to the victim. He identified himself as being I don't remember, a coworker or his boss. I think it was his boss. And he had informed me that he spoke to the victim on that day of the murder.
Did he tell you if you received any voicemails from that victim, Fabio?
Yes.
What did he tell you about that?
That the victim had left a message on his, I don't remember if it was a cell phone or machine.
Okay, do you recall what time that message was?
I believe it was 4:27 p.m.
Okay. Does that assist you then in a timeline as to when the victim was obviously still alive?
Yes, he was alive at 4:27 p.m. on that day.
Now, as far as an autopsy, well, not an autopsy, but an autopsy. In Los Angeles, is it customary then for a victim to have an autopsy when there's a suspicious death or somebody was murdered or something of that nature?
Yes.
Did you attend the autopsy?
I did not.
Did you end up ultimately booking some evidence into custody from the autopsy?
I did not, but I signed a property report that was prepared by Detective Parshall, who did book evidence from the coroner's office.
So did Detective Parshall then bring you the victim's what we call a bloodstain card, item 72?
Yes.
What is that?
That is a bloodstain card that is obtained by the coroner's office as a reference from the victim.
So the victim's blood.
Correct.
Okay. And then item 73, victim's clothing, was that booked, or you signed off on that to be booked by Detective Parshall as well?
I did.
And then item 74, victim's haircut.
As well, yes.
And you signed off on that as well?
I did.
On March 20th, 2017, did you receive a call from Feidy, F-E-I-D-Y, who represents Cody? We've talked about Cody as a company regarding Fabio's life insurance policy.
I did.
And what were you informed about that?
I was informed. I was informed that there was a life insurance policy that was on the victim.
Okay, did they tell you how much it was for?
Yes. 1.6 million, I believe.
And did they inform you who the beneficiaries were of this life insurance policy?
They did.
Who did they tell you?
They said it was the victim's son, wife, and 2 daughters.
Okay. Now, as far as if anyone had been cleared, did you have any conversation about if people needed to be cleared in order to receive life insurance?
Yes.
What was that conversation?
The conversation was that I instructed the insurance company not to release any funds pending further investigation until everyone's cleared.
And is that customary in the homicide investigations that you've been part of?
Yes.
On March 22nd, 2017, this is following the death of Fabio, did you receive a voicemail from the defendant inquiring about insurance?
Yes,
And by the way, did you ever meet face to face with the defendant?
I did.
Okay, do you see her in court?
Yes.
Can you please identify where she's sitting and what she's wearing?
She's sitting with a white sweater to the right of counsel.
And was there anything unusual about this particular voicemail?
Yes.
Can you please explain that?
It was a voice message from the defendant, and she was inquiring. She was upset why her insurance funds were not being released at the time. She wanted to know why. She expressed that she had financial issues and demanded a phone call back.
And was this voicemail to you or someone else?
It was to me, but she wanted a call back from myself or Detective Parshall.
At this point, were you the lead detective on the case handling it?
I was the supervisor of the case.
Okay. So during the call, did she complain about any of the detectives on the case that reported to you?
I don't recall if she specifically complained about the detective. She was upset that the money from the insurance company was being withheld.
After you got that voicemail, then what did you do?
Well, I thought it was pretty significant, so I called Detective Parshall over, and I wanted him to listen to the best message as well.
And why did you go to Detective Parshall specifically?
Because Detective Parshall was the lead detective, and I wanted him to be aware of this voice message.
Now, was this voice message recorded in any way?
It was recorded on the messages in the main line for Valley Bureau Homicide.
Okay. Did you memorialize then this message in writing on April 27th, 2017?
I did.
Why did you do that?
Because it was a pretty significant message. I had never received a message like that from a beneficiary.
And again, did it come on your particular voicemail?
Yes.
Is there a reason why, did you save that voicemail?
I did not save the voice message.
Is there any reason why you didn't save it, if you recall?
All I remember is calling over Detective Parshall, and I told him, listen to this message, and he did. I go, do you want me to contact her? And I'll take the heat for delaying the funds, because I know he had a pretty good rapport with the defendant.
Okay. Did you attend the memorial for Wella, or held by Wella or Fabio on May 22nd, 2017 in Woodland Hills?
I did.
Did you go with anyone in particular?
Yes.
Who did you go with?
Detective Parshall.
Was there a reason why you went to the memorial?
I believe we were invited to begin with, and I believe Detective Parshall's partner at the time was not available.
Do you know who you were invited by?
The defendant.
So when you went to the memorial, can you describe what it was?
Yes, it was a memorial. Very nice, actually. A lot of rooms. They had a board where people would write. It's more of a celebration of life type of thing. Their memories of the defendant. Nice gathering. Things of that nature. It was nice.
Exhibit 90 is on the screen, page 3. Is that what you described as part of the board where people wrote messages?
Yes, it was a wall. Yes.
And then showing people's 90, page 4, again, this exhibit was where people could write.
Yes.
And not visible in the photograph that's on the screen, but were there photos of Fabio around this memorial?
Yes.
Exhibit 90, page 5. Did you see those individuals there?
I saw the defendant there, and I possibly saw the two women with her. I don't specifically recall them.
Okay.
Of course, the defendant
Did
was
you
there.
talk to the defendant at this memorial?
Yes.
What did you talk about?
Well, she gave us a tour, basically, and showing us around and things of that nature.
Did she tell you anything about her relationship with Fabio?
Yes. How special it was, how in love she was, how he was her soulmate, how hard it would be to continue her life, things like that.
Now, during this memorial, did she address the audience or the people that were there?
She did.
And what did you see her do?
There was a gathering of people, and she addressed the entire audience and spoke about Fabio.
Okay, did she sing anything?
She did.
What did she sing?
I believe it was "I Did It My Way."
And was it just her up on the stage singing that?
I believe so. I don't know for sure.
Not one of my favorite songs.
After the memorial, then, what kind of role did you continue to have, if any, with the defendant specifically?
I believe that was the last day I spoke to her and saw her myself.
Were you involved at all in the arrest that occurred then on June 14th, 2017, which would be, a month or so after this event?
No.
Thank you. I have no more questions.
Proceed, counsel sidebar.
Something's not nice. Something's not right. They may end for the day. This is the end of that day, I believe, if I'm right. And we have some hearings to go watch. We've got some hearings going on.
Good afternoon.
This memorial that you attended in May, that was on the 23rd?
I believe so.
And Ms. Cementilli invited you to the memorial?
I know she invited Detective Parshall and his partner, and like I said, he was not available, so I attended.
Okay. And when Ms. Cementilli was on stage, she was also with her daughters. You were familiar with her daughters?
She could have been. I don't recall that.
Okay. So you don't recall whether she was up on stage singing the song with her daughters or not?
I know she was up there singing the song. I don't remember if her daughters were with her. They could have been.
Okay. And
was it good or bad? I want to know.
You said she took you around to show you the workplace?
Yes.
She showed you Fabio's office?
She did.
And that's where you had your discussions with her?
We spoke, yes. I don't know if it was exactly there. It could have been.
Okay, fair enough. Bringing you back to the night the case was first assigned, the night of the killing on January 23rd.
Yes.
You described securing a video of two suspects, the joggers, I think that was referred to as. Do you recall doing that?
I do.
Okay. Where did you go? What was the location of, I think Ms. Stagel referred to it as a structure. What was the location you retrieved the video from?
The residence was 5019 Queen Victoria.
Okay. And did you speak to a homeowner?
I believe we did. I just don't have that recollection, but I believe we did.
Okay. And did you make any report of retrieving it from the homeowner?
I did not, because we didn't retrieve it. We viewed the video.
So you just viewed it that night. You didn't actually take a copy of it yet.
That's correct.
Okay. And did there come a point in time where you did retrieve the video, a copy?
A copy of that video was retrieved, but not by myself.
Okay. Do you know who retrieved that?
Yes. I don't know specifically the person's name. It was our TID unit, technical division forensics,
Got
that go out to the scene.
Got it. Okay. You discussed earlier, you testified earlier about receiving a call from a representative of the company. Do you recall that, about life insurance?
Yes.
And that person that called you was somebody named Feide?
That rings a bell. Yes.
Okay. And that person informed you of the beneficiaries to the life insurance policy. The proceeds would be shared, correct?
Yes.
And they would be shared by the son, the two daughters, and Monica, correct?
Yes.
That was your understanding.
That was my understanding. Yes.
And you were working in a supervisory role, but you did not have any day-to-day responsibilities in the case?
Day-to-day responsibilities? No, I did not.
Okay. And am I correct that after June 14th, 2017, you never had any contact with Monica Cementilli?
No.
Nothing further. Thank you.
Oh, thank you.
Thank you, Detective. You're excused.
Thank
Well, you look like you need a break.
Oh, I'm sorry.
Whoops,
Mom.
go ahead.
I apologize.
No break yet.
I absolutely apologize.
Detective, this voicemail you were describing earlier, you said it came to the main voicemail for the detectives?
On my line, yes.
On your personal?
Yes, for squad 3.
Okay, so it was a voicemail you were saying was left on your line,
Correct.
and you thought this voicemail was significant?
I did.
And you kept a copy of it?
I did not.
Is there a reason you didn't keep a copy of it?
In hindsight, I probably should have, but what I did is like I said, I brought it to the attention of the lead detective. I had him listen to it, and I asked him if he wanted me to address the situation with the defendant. He said he would take care of it.
Okay, but you never recorded it?
I didn't record it. It was on the phone, but I did not make a copy of it.
And it was deleted at some point?
It must have been, yes.
Okay. And did you receive any other communication, voicemails, letters, anything like that from Ms. Simontilli?
Not that I can recall.
Okay. Didn't you receive communication where you were copied on an email from Ms. Simontilli on June 1st, 2017?
It's possible. I don't have recollection of it, but it's possible.
Okay. Your Honor, may I please mark as defense
Yeah.
612?
Defense, example,
Two-page email from Monica Simontilli to Jean Marshall, CC to Steve Castro.
Yes.
That this is an exhibit. She's asking if you remember it first.
I want to contact her office and tell them to get her classes and get rid of the
Showing you,
I cringe every time I hear
showing you this email. Did you ever receive by this email from Monica Simontilli on June 1, 2017?
I may have. I just don't have recollection of it, but I may have, yes.
Okay. Is that your email address, 26287@lapd.online?
Correct.
And in this email, do you receive your emails at the station?
Yes.
And during this period, you were receiving all your emails?
Yes.
Okay. And am I correct that in this email, Monica Simontilli is communicating about when you will be meeting to hopefully get some new information?
Yep. Do you mind if I read it?
Not at all.
I feel like every time I hear that come out of her mouth, it's fingernails on a chalkboard. I'm not trying to be pissy, but it feels like that to me. And I had a hater on me yesterday about it, and I don't care. It is poor English speaking skills. It is not what I would expect for an attorney. You know, we have to, it's kind of interesting now that every college student has to take a class in speech and speaking, public speaking. And that is the first thing they get rid of. It's okay to do an every once in a while, but girl, you failing on it now. There it goes.
The email sent by Ms. Simontilli, she references a meeting that was scheduled for a couple of weeks, that she says hopefully there'll be some new information.
She does talk about that, yes.
And she talks about phone records for her and the girls, and that she could easily access them and to let her know dates.
Yes.
And she talks to you about that she's going to be away from June 9th to the 13th, but her realtor will be at the home to show the home.
Yes, he says this to Detective Marshall. She CC's me. Yes.
She CC's you on your
Correct.
And she also talks about that Fabio's employer has continued to pay his salary, but that kindness is limited to the end of this month, correct?
Yes.
And this is an email sent in April, correct?
Can
I'm
you
sorry,
scroll?
June 1.
I can't see it, but I'll take your word for it, yes.
Nope, let me be
Okay.
sure.
June 1st, 2017, yes.
So she's referencing the salary extension ending in the month of June.
Yes.
And she is talking about that she's forced to liquidate things, what we can in an untimely manner.
Yes.
And she tells you that it's been over 4 months since you commenced the investigation, and she fully understands that it's both lengthy and complex.
Yes.
And that any assistance you could provide to us would be greatly appreciated and would remove tremendous worry and burden.
Yes.
And then she finally asked you if there's anything more that they can do to accelerate the insurance claim process and what you need to facilitate this.
Yes, she talks about helping on this email.
Yes. And that was, again, an email from Monica Simontilli to Jean Parshall, CC to you on June 1, 2017.
Yes.
Thank you.
Go to a second.
Okay, so just to put it in perspective, Detective, on March 22nd, 2017 was a voicemail when she was upset about the life insurance and caused you enough concern to go to Parshall, correct?
Yes,
She didn't mention anything else about any other topic but the life insurance.
that is correct.
Okay. So then in June, 3 months later, she sends a letter not to you but to Parshall, an email. Is that correct?
That is correct.
Defense 612, and then she concludes the letter once again at the very end, saying, let us know what more we can do to accelerate the insurance claim process and what you need to facilitate this. So once again, she's asking about insurance.
She is.
Okay, thank you.
And she was sending this email, to your understanding, 5 months after her husband had been killed. Is that right?
That's about right.
Thank
June
you.
1st.
All right, so we're gonna take a big vacation. Due to the your excuse. Thank you. Due to the holidays and all that kind of stuff, we will not be in session again until next Tuesday, which is the 18th at 9 a.m. A couple things I want to tell you. First is the admonition, not to discuss this case among yourselves or with anyone else or form expressing opinions of the cause submitted to you. Next, it's not a Friday, so I can't tell you, this is this or that. But don't forget that you're jurors on this case. Come next Tuesday, don't forget to come to court. Have a good long time.
Okay, so we can go into the other trial now. That's good. So we'll catch up on that other trial. Y'all, yeah, I did it. I will tell you that I know I'm coming across as a little bitch when it comes to this woman, but please answer this question with the thumbs up. Are you guys bothered by the amount of ums that come out of her mouth? Because do you know what this is starting to remind me of? Alice in Wonderland, where the queen calls her person, I know I'm being snotty. Okay, let me put this down, close the beads so I do not spill them. Lord knows I've done that enough. How many times have I spilt beads? Twice, 3 times. 2 or 3 times I've spilt beads. Okay, here's some good news. We're saying goodbye to this trial till next Tuesday. We have a hearing now. I'm trying to get everything organized. We got a hearing in the Simpson trial. And this is from my neck of the woods, y'all. It is. It is. It's from my neck of the woods. So let me get it on screen. This is a trial that I hope to follow closely. And I hope to be in court for the trial. This is the Simpson case where his woman. All right, this hearing is over the Simpson, Brad Simpson here, and his wife has been missing and declared unalived, deceased, because she has not turned up. The city has looked for her like crazy, but what he did was he drove to a small town, drove through San Antonio up I-10 to a small town called Bernie, which is between me
and San Antonio. I go to Bernie all the time. And then he came back, and they think he dumped her remains in a creek or river between here and there. Oh, you serious looking dude. And there he is. Burr County Jail, Whacking Hut. Remember I mentioned Whacking Hut last night? Those who were on with me, Burr County Jail is a little different than Whacking Hut. But Whacking Hut is where they do detain people. He may be in Whacking Hut. Whacking Hut, let me see if I can pull a picture of it. It is skanky inside, y'all. Oh, now it's called the Central Texas Detention Facility, formerly known as Whacking Hut Facility. It migration detainee entries is 273,220. Average daily migrant detainee population 28,289. And they have a capacity of 688. They are way overcrowded, y'all. Way overcrowded. Way overcrowded. I will tell you, it is a place you do not wish to be. It looks like a big, oh, here's the facility. Okay, I'm going to click on this picture, open it up. View image, save. Okay, this is the facility. And why I said it looked like a big circle is there used to be some kind of a fence detaining that ran across here that when you walked around, it looked like a circle, but it's actually a three-pronged thing with this here. So you can see how it looks like a circle there. And it is so skanky, so dirty. I used to have to park right here in this parking lot. I go in here, go in through their facility, go in through the security check and all that with youngins, age 4 and 9. It is nasty, y'all. When I mean skanky, I mean skanky. Let's get back to this. I'm going to skim until the judge comes in.
CR 0126 and 2024 CR Okay, and sir, are you Brad Chandler Simpson? Okay, so we had this case originally set for today, I thought for the motion to quash, but it's my understanding that we're not going to argue that today, correct?
So, yes, the discovery is not yet complete. And I'd like to have all or nearly all of the evidence before proceeding that particular.
Correct. Okay, now, the other reason for this type of hearing is just to make sure where are we on discovery that okay, and counsel, anything you need to add on that as far as receiving discovery?
I think Texas Rangers dropped off of a discovery to the state just before the new year. Turned out the state all the original copies of that discovery. So state that discovery back to Texas Rangers. I don't really know why.
I know, we're not getting good audio. I'm trying to read, but
Okay, I guess you're exercising your due diligence of trying to get the Texas Rangers to give you that.
oh, if you feel it, he can get the Texas Rangers in on it. Something about the
So, does the defense have any other, okay, so with that in mind, in light of the fact that you're getting this discovery right now, there's no sense in coming back in 30 days, let's do, you want 60 days or
30 days finding fact that they are getting their evidence.
So we'll reset it for 30 days, just to make sure that things are moving along, okay? So we set 30 days, and give them the dates, and then we'll see you again. Okay? Thank you very much.
All right, 30 days. Okay, so they will see him in 30 days. Oop. Okay, so basically what that was about, they were supposed to be in there for another hearing. That didn't happen. Motion to squash did not happen, but the judge was making it clear that the discovery was proceeding correctly and as it was supposed to. They will reconvene in 30 days. Also, if you notice, he was in a red uniform and not an orange because the standard inmate in Texas wears orange scrubs. He was in red. Do you know why? Red represents a inmate that is a high risk, a lot of times due to self-harm or self-behavior. Due to his own, not necessarily due with not high risk because of what he's charged with, but because of his own behavior. So let me preload the next trial, and when this is in jury watch, we'll start watching the Rose trial. My Lord, are we playing the merry-go-round today? Hey, you guys, thank you for joining me. Y'all are awfully quiet.
It's bad when it's one of the security officers. Huh?
Somebody's talking about blood sugar being high.
Everyone stand, please.
They bring the jury.
Oh, wow. Okay, what do we do now?
And that, of course, the burden never shifts to Evelyn.
Okay, here we go.
I'm going to leave this up if that's okay, Your Honor. Thank you. So we've finally reached the point in trial for closing arguments. And what this essentially means is it's an opportunity for the state of Tennessee to go through, talk about the evidence a little bit, reflect on some of the witnesses, because it's been a pretty long, almost 2 weeks. The state will go first, then one of the defense attorneys will have an opportunity to go, then the state will go again. And Matt, I'll talk a little more about that in a second, but that's because the state carries the burden of proof. So I think each of you should have a jury instruction pamphlet in front of you. I'm going to ask you if you flip to page number 6, it covers the burden of proof. And it seems like it's a common misnomer for the burden of proof to appear to be higher than it actually is for the state of Tennessee. And don't get me wrong, it is a high burden, and we gladly carry that burden every step of the way. But when you read about reasonable doubt, and that, of course, the burden never shifts to the defense. The burden is always on the state of Tennessee. It is a burden. It's not absolute certainty. It does not require you to say, I don't know 100% what happened. That is not what is required by the law. It is not absolute certainty. It's essentially, can you go to bed and let your mind rest easy? Can you, actually, I'm going to do one other thing real quick. What I'm asking you to do is essentially use your own common sense. That's one of the most important things. Okay. And I'm going to give an example of what I mean by this, if I can.
Ooh, exhibity!
It's like Wheel of Fortune. Okay. My handwriting's not the best though. But you get the idea here. It's like Wheel of Fortune. When you see a contestant on Wheel of Fortune and they know the answer to the phrase or the statement, they don't have all the letters when they see that phrase, but they know what the answer is. And if the state has done that, we have met our burden. And it's important to note that it's not beyond a shadow of a doubt. It's not absolute certainty. That is not what is required by the law, by the state of Tennessee. So that brings me to some of the arguments that Mr. Scott has made through this trial. They might be on that same page. Probably should have written it. Here it is, page 5. In your instructions, in the second paragraph, it states, statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. And I beg you to remember that. When Mr. Scott gets back up and makes his arguments, remember that. The things that come out of his mouth and that came out of his mouth during trial, that is not the evidence. He tried to get you to speculate on so many things during this trial. He wanted to throw out strange theories with aluminum foil. He wanted to throw out a term that doesn't even matter anymore, SIDS. That came from his mouth, not either of the doctors, but from Mr. Scott. He's asking you to speculate. That is not evidence. I beg you to only think about the items that were put into evidence, the photographs, the recordings, and what came from the witness stand. Do not let them sway you from what actually happened in this case. he kept mentioning cadaver dogs. He wanted you to think about that. But if you remember the cadaver dogs, Tommy Boswell, on his property, what did we hear him say? The cadaver dogs didn't even go up there by the playhouse. He wants you to believe maybe the body wasn't there at that time. He's trying to throw you off, but he didn't show anything. There's no proof. There's no evidence.
Ladies and gentlemen, I want to remind you once again, and it's in here in these instructions, that the defendant has no burden to prove anything during this trial. The burden is wholly on the state of Tennessee. Okay? Go ahead, Jim.
Thank you. And I believe I said that. The state, we gladly carry this burden. But again, what comes out of Mr. Scott's mouth is not evidence. You heard nothing from the witness stand about cadaver dogs. There's no piece of evidence about cadaver dogs. And Mr. Scott said in his opening statement, humans make mistakes. Do you remember that? Dogs also can make mistakes. And if you remember, Agent Fraley and Agent Gratz, both with the TBI, what did they say? They didn't smell anything in that playhouse until they lifted the black bag, and immediately the smell of decomposition hit them. I submit to you, cadaver dogs, what do they work off of? The smell of decomposition. Don't let that fool you.
That is true.
Mr. Scott also talked a lot about Hunter Wood. We heard a lot about Mr. Wood in this trial. Again, did we hear any witness from the witness stand that ever saw Evelyn with Hunter Wood? There wasn't a witness that ever saw Evelyn with Hunter Wood. And if you remember the text messages that we saw yesterday from essentially Hunter's own mouth, it's pretty clear that he's yet another victim of Megan Boswell. She was feeding him the same lines that she was feeding every other person in this case. Mr. Scott brought up the theory of an accident, or the word SIDS. Well, you heard Dr. Malushnik say that in the past 10 years in the state of Tennessee, a child 12 months or older has not passed away from SIDS or sudden unexplained death. Those are statistics from the state of Tennessee. But somehow Mr. Scott wants you to believe that somehow that's how this baby died, even though she has foil wrapped around her head, a blanket wrapped around that, inside a trash bag, upside down in a trash can. Let's go through our timeline just for a minute. What do we know? We know that Evelyn was okay until November of 2019. We know that Evelyn was seen at Thanksgiving by family. And then Megan Boswell started a new job at the Chicken Shack. What do we know after that? Megan Boswell meets Hunter Wood. And we know that Sue Whitson is probably the last person to ever see Evelyn alive again. You remember the picture that Sue took? This is very likely the very last picture of Evelyn Boswell alive. Not taken by Megan Boswell, but taken by the babysitter. Sue Whitson testified that the last time she babysat was the end of November, early December, which just so happened to coincide with when Megan Boswell met Hunter Wood, a guy that she was hoping might change her life. But Evelyn was in the way. What did we hear? Do you remember Megan's friend, Maddie Broom? We heard a little bit about her. Her brother, Stephen Lawrence, tried to help Megan. She drove her to a few of the interviews. And if you remember, Megan was apartment shopping on December 8th. And on that date, Evelyn was not with her. And so Stephen asked her later, after it's been reported that Evelyn's missing, he says, was Evelyn gone by then? And what did Megan say? Yes, Evelyn was gone by then. So that takes our window from December 3rd, essentially when Megan Boswell started working at the Chicken Shack, to December 8th. Evelyn Boswell's 12-month well visit. Do you remember that? Scheduled for December 5th. Megan doesn't call and cancel. She just no-shows. And Casey Saltz, the receptionist there, had to reach out and ask Megan, and Megan gave some excuse, I can't remember what it was, as to why she couldn't bring her. So they rescheduled for the next day. Did Megan show up with Evelyn the next day? No, she didn't. I submit to you, that's because Evelyn was already gone at that point. Casey texts Megan again, and Megan has yet another excuse. The appointment's rescheduled one more time for December 11th, and conveniently, Megan then says, oh, I've decided to change pediatricians. And as we can all imagine, when you change pediatricians, we all know that children have vaccine records and all of the things that come with being, especially that first 12 months of life. They've got a lot of appointments and a lot of vaccinations. So it'd be really, really important to transfer that information to the new pediatrician. Did Megan Boswell do that? No, she didn't. They never got a request from another pediatrician. That was just another line that Megan Boswell told to start trying, I say trying, to cover her tracks. We also know that on December 7th, you saw a text message yesterday from a girl named Haley Marie, and that is the very first time that Megan tells the story her dad has her. December 7th. Keep in mind, Sue Whitson saw Evelyn alive for the last time, and then Megan just stopped showing up. And then by December 7th, she's concocted her plan. And it really explains why so much time goes by. Because I know that's a question we have all had. 2.5 months goes by. 2.5 months. But now we know. We know why. Because Megan Boswell was telling every single person in her family and her closest friends that Evelyn was with her father. So what does a rational person think? Okay, we're glad. I think Tommy even said that from the stand. I was proud of him for stepping up. I was proud of him for stepping up and taking responsibility. But, time continues to pass, and you've heard witnesses, and particularly Bailey and Audrey, Megan's closest friends. They were all starting to talk and to think, like, something doesn't feel right. Just doesn't feel right. But no one could have known how wrong this was at the time. February 2020, finally, Tommy Boswell says, I've had enough. I want to see my granddaughter. Show her to me by tomorrow, or I'm reporting it to DCS. Well, Megan couldn't do that. Megan knew she couldn't do that because she knew where Evelyn was. We all know where Evelyn was. And so Megan did not produce Evelyn that day. And Tommy finally gets the ball rolling on trying to find this little girl. And they first show up at Hunter Wood's house on the lake in a nice neighborhood. And Megan Boswell's there. But there's no baby. There's no Evelyn. And you remember, the only thing Megan, you remember James Lewis from DCS, the only thing Megan was really able to show was this box from Hunter's bedroom. And you remember what Megan called that box? A memory a memory box. Now, why would you call something a memory box if you are alleging that your child is still alive?
Because
this is all Megan Boswell had of Evelyn in that house that she was trying to show DCS that Evelyn was living in. She couldn't show him diapers. She couldn't show him a pack and play. She showed him one outfit that she held up on a hanger, not an outfit that Evelyn had ever worn. There was no evidence that a child had ever been in that house.
I had a memory box with each one of my children. So there you go.
I'm going to touch on something briefly. If you remember Paul Durant yesterday, going back, I'm trying to just give you a little bit of a timeline. If you remember, he talked about Ethan Perry in the military because Megan Boswell led him to believe that he was the father, even though he had his doubts. She convinced him that he was the father of Evelyn. We know he was not the father. We know that. And he said she was sharing photos daily, constantly sharing photos. Until what day? Do you remember the date? December 3rd. On December 3rd, Megan Boswell stopped sharing photographs of Evelyn. And she continues to send pictures, but if you remember, Agent Durant he's a smart guy. And so he was able to check her full Facebook extraction. And so she continued to send pictures to Ethan, but they weren't recent pictures. It was just another way that she could try to keep this facade going just as long as she could. Mr. Scott wants you to believe that Megan Boswell had a rough life. She was in foster care. But Megan Boswell was in foster care because of Megan Boswell, because she would not go to school. She went to foster care because she was truant. And when she left foster care, she went and lived with her dad. And of course, Evelyn was a baby at this point. I think the testimony was from February to March of 2019. And then her dad said, I'm going to get her a trailer, set her up. He bought her a brand new car, buys her a trailer. He's giving her everything she needs to raise this child. And she goes and lives with her mommy, her grandmother, from April until October of 2019. And then finally into the trailer from October to December. I think it's fair to say that she did not live in that trailer with Evelyn for very long. But in that short period of time, this is what she was able to do to that trailer. Can we look at that for a second? That's what she had her child living in. If that's not neglect, she does this in 2 months. Ladies and gentlemen, I beg you to look at these pictures when you go back in the jury room. That, in 2 months, is what the defendant was able to do to the home her dad provided for her and her child. And within 2 months, Evelyn was dead. And I stated there are, maybe it's just my opinion, there are a lot of victims in this case. Bailey Hawkins, her very best friend. Did you see how difficult it was for Bailey to testify? To look at someone that she trusted, that she loved. Audrey Gibbs, same thing. They are also victims of Megan Boswell. And they will also suffer for the rest of their lives because of what Megan Boswell, the web that she created for them all to get caught in. Erica Stacy, who cared about Megan and Evelyn so much, is a victim. Gail Kite, the foster mother, she's a victim. Ethan Perry, who's serving his country, doing absolutely nothing other than his job, gets pulled up into Megan Boswell's web because Megan Boswell is only worried about Megan Boswell.
Let me tell you, when you get pulled in by the military police,
and I'll submit to you that Hunter Wood,
police, it's worse with military.
The person that they would like to blame somehow is also a victim of Megan Boswell.
Yep.
She starts with first blaming Ethan Perry. She does that for a few days. And when she quickly realizes, gosh, law enforcement can figure out that I'm not telling the truth here, I guess I better tell something different. Then she goes to her mom. She blames her mom, her own mother. She's willing to blame all the time knowing. I mean, we know, let's find the picture. We know where Evelyn was.
What happened?
Guarantee you, look at all this stuff. They want you to believe that Hunter Wood backed Megan Boswell's car up to that shed that day. Tommy came home. It was in the middle of the day. Where's the diagram? Do you remember the diagram of the scene? Look at this diagram. They somehow want you to believe that Hunter Wood pulls up this driveway and comes to this shed right here, right in front of Amani's house. Tommy's house up on the hill in the middle of the day. Is that reasonable? What is reasonable?
No.
How about that Megan Boswell is the one who drove her own vehicle, the vehicle her dad bought for her, up to that shed because Megan Boswell is the one who had a key fob. Remember, there's a gate there that only opens with a key fob. That's the only way a car is coming through that driveway. And Megan Boswell lived there. You just heard that she lived at her dad's house and at Amami's house. And so they're not going to be surprised if Megan Boswell is on the property. She's the one who dumped Evelyn's property there. She's the one who took the trash can there. Not Hunter, not anyone else. Megan Boswell. Do you remember there was more than one text message? And of course, keep in mind the whole time these text messages are coming through, that's where Evelyn is, okay? Just think about that for a second. I'm not going to take the time to go through these because you can do that. You can take all of this back with you into the jury room. I encourage you to go back and read all of these text messages and remember the dates that we've talked about. But while Evelyn Boswell is sitting in this trash can and people are asking Megan, how's Evelyn? What does Megan say more than once? Mean as fuck. First of all, she's a 12-month-old child. And every other witness said that she was a lovely child to be around. And it's not a very nice statement to begin with, but it's definitely not a very nice statement when your kid is shoved down into a trash can upside down. And you know that. Agent Fraley was on the stand and you heard Megan Boswell admit that she knew Evelyn was dead. She's telling all of those stories to law enforcement. And she told more than one person, Evelyn's mean as fuck. And when Agent Grass asked her about it, she goes, what's your point? What's your point? And that's an interview with Agent Grass that you can also go back and watch if you'd like to do that. So we saw the defendant enjoyed crying during this trial because she has an audience and she really enjoys that. But did we see her crying any other time? Did we see her crying from the witnesses on the witness stand and what they told us about her? Did we see her crying in the evidence that came in? No, Megan wasn't crying. Do you think she was crying when she filled out this apartment application with Hunter Wood, where they list 3 occupants are going to live in the apartment? And at first glance, we're like, oh, Megan, Hunter, and Evelyn. But that's not what the defendant told David Gratz. Do you remember what she told him? She said the 3rd occupant is the baby she's pregnant with. because Hunter doesn't want Evelyn to live with him. Of course, we could also look at the date on that application, January 4th of 2020. And we also know another reason that Evelyn would not be living with him. Was Megan crying here? In 2020, when she posts on Instagram, so excited for our new home. Think Megan was crying when she posted that? To me, it looks like maybe Megan's just moving on with her life. As if Evelyn never even existed. What about here? Also posted in 2020. Keep in mind, Evelyn's still upside down in a trash can because Megan's not told anyone where she is. She's still spinning her lies. Do you think she's sad here when she's picking out furniture for their new house? But she's sad today? She has the gall to sit here and cry today and pretend she can't look at the pictures of what she did to her child? What about this one? Proud of my baby. New 2020 High Country. Was she sad then? What about in December? Weeks after Evelyn has been brutally murdered. What is Megan Boswell doing? Does she look, maybe we should zoom in. Does she look sad here? Maybe she is. Sure doesn't look like it. Her kid's upside down in a trash can. And she's going to the aquarium with her new boyfriend. What about here? She doesn't look very sad to me. Hiking in Blowing Rock in 2020. No Evelyn. Evelyn's missing, still missing at this time. There's Megan hiking with her new boyfriend, moving on with her life. Not crying. Maybe Megan Boswell didn't have an end game. Maybe she didn't know. Maybe she hoped that Evelyn would never be found. But she had to know at some point these stories were going to catch up with her. Ladies and gentlemen, and I'm asking you today, 5 years later, February 2025, to show Megan Boswell that her stories have caught up with her. The evidence shows the defendant. This person is the only person responsible for her child being dead. You heard it straight from Dr. Malushnik. Evelyn shouldn't be dead. Evelyn should not be dead. I believe the defense brought up SIDS, reflux, rollover. I believe they even brought up a tongue tie as being a possible cause of death for Evelyn. How does that result? Any of those things? You know, he said in the beginning, the state can't even prove how she died. Are you kidding me? How does that end up with a baby in a trash can? The DNA, let's talk about the DNA for a second. You've got the gloves that are in the trash can. And the defense somehow wants you to believe that gloves will keep fingerprints from happening. And then I guess whoever did that then took the gloves off, cut them up because they're cut up in small pieces and you can look at them when you get back there, and then dispose of them in the same trash can that the baby's in. That doesn't make sense. That doesn't make sense. And funny enough, guess what is there? Is DNA that matches Megan Boswell, that matches Evelyn. Go back through the testimony. There's not one piece of DNA, not one, that shows anyone, not Hunter Wood, not anyone else other than Megan Boswell is associated with that trash can, the evidence in the trash bags. And you heard Marla Gray, the DNA expert, talk about the mixture of DNA on some pillows that were found in the shed. And you also heard her say that that could even be from the person who made them in the factory, or it could be from the person who touched the pillow at Walmart when they were trying to decide if they were going to buy it. It wasn't even enough DNA to test. So don't be led to believe that because of that, there's some unknown stranger who did these things. Look at the evidence. Look at the evidence that's in front of you. We have evidence. We have shown you the evidence. Don't think about the speculation. Don't think about the what ifs. Look at the evidence. Some really, really good. If I could, can I see the trash can for just a second, please?
Oh, no.
Thank you.
Oh, no. I don't want to see that again, guys. I had a nightmare about that one night.
Whose fingerprints were on the trash can? Do you remember what Agent Hoover said from the TBI yesterday? Of course, he's removed the rim. He talked about how it's smooth under the rim. If you're going to carry a trash can, how do you pick it up to carry it under the rim? Whose fingerprints were under that rim? Megan Boswell. Megan Boswell's fingerprints were under that rim. If we look at Exhibit 17, can you see the black trash bag there? Whose fingerprints are on that trash bag? Megan Boswell's fingerprints. And you heard Dr. Malushnik say, and I think you can see for yourself, that trash bag's not just gently placed down into the trash can. It has been forcefully, and it's a hard image. It's a very difficult image to think about. But that's the evidence that we've been left with, that black trash bag was placed on top of Evelyn in the white trash bag, and it was forcefully pushed down. Compressed, I think is a word that was used during the trial. And that's how Megan Boswell's fingerprints ended up on that black trash bag. Even more damning than that is the fact that Megan Boswell's fingerprints are on the foil wrapped around Evelyn's head. I would love to know a different explanation for how Megan Boswell's fingerprints got on that foil, on that trash can, on the black trash bag, except for the fact that she murdered her baby. She put her in that trash can with food trash and debris, covered her body, essentially mummified her, and tossed her away, literally, with the trash.
Hey, Haley Mouse, you're good.
You're good.
Mr. Scott would like for you to think that the doctor's testimony, just that they shouldn't be able to just decide things in a vacuum. He kept mentioning, well, what if the child's dead on a table? And I think we all know that is not how doctors operate. Doctors operate off of medical histories and any information they can get. And that's what both doctors did in this case. They took everything, her birth records, her pediatric records, the scene itself, before they came to their conclusion. They don't operate in a vacuum. I think those were the words that Dr. Malushnik used, is they do not operate in a vacuum. And they determined what? Both doctors agree that this was a violent homicide, and that Evelyn Boswell died from some sort of asphyxiation. So, suffocation, I guess, is the easiest way to say it. So, if it was not for, say, the position of her body upside down in the trash can, that could have killed her. We'll say it wasn't that. Then maybe it was the blanket that was pulled up over. Remember that? How it was tightly pulled up over her face. That could have been what it was. Or it could have been upside down in the trash can.
Could have been
Could have also been the trash bag that she was placed inside of. where she was unable to breathe. Could have been the foil that was wrapped around her head. Could have been the trash can itself. If you remember, the doctor testified that her face was compressed up against the side of the trash can. And her body was in a reverse S curve, so where her head was so far bent back into a reverse S because of how the defendant compressed her body down into the trash can. Forcefully compressed her body down into the trash can. Her head and neck were wrapped so tightly with foil that even when they removed the foil, you could still see the impression of the foil on her face. You could still see the trash can form still to her face. Quickly, I'm going to ask you to go to your verdict form page. And it's going to be probably at the very end of your packet. Page 50 is where it starts. So these verdict forms, I'm going to show you one example. Okay. So you'll see here, this is just for count one, and I'm just giving it as an example. We, the jury, find the defendant and mark the appropriate box. So if you go back in the jury room and you agree as a whole that Megan Boswell is guilty of first-degree murder, you do not need to consider anything below that. Those are what we call lesser included offenses, and we're required by law to put those on the verdict form. And we're required by law to put those on the verdict form for you to consider. But if you unanimously agree that Megan Boswell is guilty of first-degree murder, you can check that box and move on. You are not required to go through every single one of those if you believe that she is guilty of what she's charged with in that count. And if you go through these, you will see that each count of the indictment is similar. There are lesser included offenses for each one of these.
A lot of them.
Again, I will ask you that if you can unanimously agree, you do not need to go any further on that verdict form.
There are a lot of them, y'all.
The state has to prove several elements for each charge, and those are also in your packet. Count one is premeditated first-degree murder, that the defendant unlawfully killed the victim, that the defendant acted intentionally, and that the killing was premeditated. The next page defines premeditation for you as an act that was done after the exercise of reflection and judgment. It means that the intent to kill must have been formed prior to the act itself. So that means essentially when Megan Boswell wrapped Evelyn in the blanket, and you think, well, maybe she didn't have premeditation then. She could have formed premeditation in the time where she applied the foil, or premeditation in the time that she put her in that trash bag, or premeditation in the time that she pushed the next trash bag on top of her body. Ladies and gentlemen, I submit to you, there's nothing about this case that is not premeditated. Count two and count three are what we call felony murder in the state of Tennessee. That's where we allege that a murder happened during a certain felony. And these felonies are aggravated child abuse and aggravated child neglect. Again, those go hand in hand with premeditated first-degree murder. We submit to you that not only did the defendant abuse the child, but that she neglected the child. And one of the perfect examples is how she left her in the trash can. That's neglect. Leaving her in the trash can, that's abuse. And it resulted in her death, which is felony murder. And we have to prove that the child is under the age of 8. There are many counts of false report. Page 29, I think, is where it starts. And it's counts, I believe, 7 through 17. The state must prove that the statement was made by the defendant, that it was made in response to a legitimate inquiry by law enforcement, and that it concerned a material fact about the incident within the officer's concern. If you remember, the defendant herself admits more than once that what she told the police was not true. So I submit that the state has proven each of those counts. Count 19, abuse of a corpse, page 30. The state must prove that the defendant mistreated a corpse in a manner offensive to the sensibilities of an ordinary person, that she acted without legal privilege and acted knowingly. And I think that count speaks for itself, along with count 20, which is failure to report a death. A lot about this case really has been more about Megan Boswell than about this child, Evelyn. But Evelyn mattered. She deserved to grow up. She deserved that, but her mom took that away from her. And there's no evidence that anyone else was involved. I think you can see this was a pretty good investigation. It was very thorough, and the evidence continued to point in only one direction. The evidence only pointed at one person, Megan Boswell. She failed her daughter. She had the chance to keep her safe, to protect her, to give her to someone else if she couldn't handle her. You heard from the witnessing, there were people that she could have given Evelyn to that would have given her a beautiful life. But instead, she violently murdered her daughter. She told story after story after story for 2.5 months. And maybe the worst part is that she just went on with her life as if Evelyn had never even existed. But Evelyn did exist. Evelyn is a real person. And Megan Boswell should not be able to go on as if Evelyn did not exist. There are things we will never know about what happened. None of us will ever know everything. I think it's fair to say that we do know that Evelyn was in the way. She was in the way of Megan Boswell living the life that she thought she deserved, that she wanted to live. So Megan removed her. It's as simple as that. So today, 5 years later, almost 5 years to the day that Evelyn was reported missing, we are going to ask that you hold Megan Boswell accountable for what she did for her child. I submit to you the state has proven every count and every element of every count beyond a reasonable doubt. And we are going to ask that you return a verdict of guilty.
Thank you, General. Mr. Scott, you may close.
Good afternoon. I appreciate y'all's time. Appreciate you being here. Although I know you may not be here by your own free will, but I still appreciate it. This is a hard case. There's a lot of emotion in this case. And Amber Massengill is very good at giving an emotional closing and wanting you to play on your emotions. Jury instructions will tell you this case is not about your emotions. It's not about sympathy. It's not about anything else. It's about proof and what's in the evidence. That's what this case is about. This case is more about what Megan Boswell didn't do than what she did do. Now, I'll go back through the witnesses here with you in a minute. But the state seems to be putting forth a theory that you should convict her of first-degree murder because she didn't grieve appropriately. She had fun after her child died. Now, is it far-fetched to believe that the child died in the first part of December, like she says? No, that seems to be the point where you see Megan's personality start to change. But I would suggest to you that that change occurs when the child dies. You start to hear various friends come in and they talk. I can name them for you. Let's talk about Casey Saltz. She worked at Megan's pediatrician. And she was also technically would have been Megan's foster sister, I guess. She was the daughter of Megan's foster mother. And she talked about Megan being a good mother. She acknowledged that. She witnessed that. Megan brought her to the doctor. You have an exhibit in the records. It's item 67. It came in through the pediatrician. Read that page for page. It demonstrates that Megan was a good mother to Evelyn. She took her to the doctor for well checks. She took her to the doctor when she was sick. She got medicine for her. She did what she should do. And then she misses that appointment in December. And that's when this starts. And I would submit to you, when all of this really starts, the child is dead. Now, we hear from other witnesses. We hear from Paul Miller. That is Ethan Perry's grandfather. He had no reason to believe that she wasn't a good mother. Seemed like she liked being a mom. Saw no signs of abuse or neglect.
Hi, Aaron.
We heard from Audrey Gibbs.
Exactly.
She'd been with Megan almost every day up until she moved to Knoxville in 2019.
You have to be a cold-hearted
She
witch
describes
to
Megan
not be able to.
as a good mom. There were a few things. There was once where she
I'd
had
be
her
devastated.
diaper needed to be changed. Once where they neglected to buckle the car seat. But those are mistakes. That's not child neglect. That's not child abuse. Those are mistakes. Audrey talks about Megan coming to Knoxville at the end of December sometime, and by that point she's acts disassociated. She's not normal. She's saying "I love you" over and over again to her. So again, maybe she's not grieving right. Bailey Hawkins stayed at the Econo Lodge with Megan. Megan just went to sleep, despite Bailey thought they might do things, they might talk or whatever they might do. But she just went to sleep. Again, I would suggest to you she's disassociated.
He's trying.
Bailey saw no signs of abuse, no signs of neglect. Mr. Horn questioned her. She described Evelyn as the one consistent love that Megan had. And Megan is a girl who comes from a world of fractured relationships. And Miss Massengill wants to downplay Megan's home life. Matt Price did it. There's a video in there. He talks about it. He talks about, I mean no disrespect, but I know that Boswell family. I'm aware of them. I know how you come up. Your mom and daddy using drugs. I mean, you want to talk about a home life? What's the video with Agent Fraley? Her mom was let in there in stripes, a jail uniform. What kind of home life was that?
May not have been a great home life, but that doesn't mean you have the right.
And then we get to Caitlin Jones Carter, whom you can make what you want of her testimony. Her body language tells me she's no longer Megan's friend. However, she described, aside from the one day when she saw Evelyn as dirty, that Megan had been a good mother. No signs of abuse, no signs of neglect. She said she saw Evelyn sometime in December. She tried to tie it to her school, but she really couldn't give us a specific date. So I think the best you can say is that it's sometime in December. Gail Kite. Let's talk about her. Megan's foster mom. She gets Megan when Megan comes into her foster care. Megan's 7 months pregnant. She's 17 years old. Gail describes her as looking like she's not pregnant, as being underweight. We know from the medical records and the testimony that come in from Dr. Smith, Megan suffered from intrauterine growth restriction at that time. We've heard that. So that's the shape she's in. But Gail talks about how she gets her in good shape. She has the baby. She's a loving mother. She takes care of the baby. Gail never saw abuse, never saw neglect, never had any doubts about Megan. Erica Stacy, and that's the mother of Megan's ex-boyfriend, and I think his name was, can't remember his name honestly. There's the mother of his ex-boyfriend. She described Megan as a good mother. Evelyn was always clean. And I'll point something out to you. The state wants you to believe that Megan just meets Hunter Wood and throws this child away for him. She didn't do that for, I think it's Caleb Stacy. She didn't do that for Caleb. There were other boyfriends. Now there's talk about, a lot of talk about Ethan Perry thinking he was the father. Well, the proof you've actually seen is they go about as Ethan is the father. And there's been no proof that Megan knew that he wasn't the father at that point. I'm not trying to, I mean, it just happens that sometimes people may think one person's the father and they're not. But calling him out on anything or anything else. Like, it's not like this didn't start early on that she thought Ethan was the father. She obviously thought a lot of Ethan. She drove to Texas, took Evelyn to see him. Now, he did say one thing that kind of struck me a little odd. He acted as though she just showed up in Texas. I suspect, and he finally admitted on cross-examination, that he told her where he was in Texas. You just don't hop in the car and drive to Texas and say, I'll drive around El Paso so I see his car in the parking lot, pull in. That's not what happened.
He was not expecting a visit, you idiot.
Let's talk about Randy Wood.
That was lame.
Randy Wood is the father of Hunter Wood. The state called him. The state is the one who elicited the information about Hunter Wood being hospitalized. That's the first you hear of him being hospitalized. It's the state. Now, Ms. Massengill wants you to think I have some grand conspiracy theory. I don't. I do have a statement from Megan Boswell when she talks to Agent Fraley about what happened in this case. She says, Hunter was there when Evelyn died. I wrapped her up and I swaddled her. I held her. She kept getting colder as the day went on. I didn't want her to get cold. Hunter took her and he got rid of her. Now, they want you to believe that that's just impossible.
You just nailed the coffin for her. You just put the nail in the coffin.
Why did Hunter not
I
give
can't
his
believe
DNA?
you just said that.
Ask yourself that.
I can't believe you just admitted it.
If you have nothing to hide, why wouldn't you just let them test your DNA against all the evidence they had? Turns out they couldn't have tested it, probably. But he didn't give them that chance because he had something to hide. Now, his dad said that he was schizophrenic. I asked him, is he schizophrenic and have hallucinations? He agreed with me on that. He also agreed with me when I asked him if he talked about using an aluminum foil or tin foil. And he said, yeah, he talks about some off-the-wall stuff.
That's not admitting it. He said he never heard of it. You're lying.
Likely to wrap that child in tin foil. The child's mother that has cared for the child, taken care of the child, or the boyfriend who's schizophrenic.
He's trying real hard to throw that doubt in there.
I'm not trying to vilify Hunter Wood. That's not been my intention throughout this trial. But Megan's statement is that one of them rolled over on the bed. The young mother may think that. There could have been other causes. When we get to the causes, I guess we can go ahead and we can talk about Dr. Schmidt and Dr. Malushnik. Now, Dr.
And you didn't
Schmidt
like either one of them.
asked her about several different things. She's the lady who actually performed the autopsy. And she formed an opinion of homicidal death based on the way the child was in the trash can. But she could not tell you a medical basis for the child's death, other than a diagnosis of exclusion. And the diagnosis of exclusion is simply, we don't know what else is wrong with her, so she must have smothered in this trash can. That's what they want, what she said, essentially. Now, I cross-examined her about a lot of things. I asked her about SIDS. And even though the subsequent doctor didn't agree with it, Dr. Malushnik, I didn't ask about something that didn't exist. Dr. Schmidt knew exactly what SIDS was. We talked about it. We talked about the ages, how we don't know what causes it. She answered questions about it. She said, ultimately, she could not rule that out in this case. Just like she could not say with any degree of certainty that the child was placed in the trash can alive or dead. She couldn't say that. She brought up that the child had a heart valve that leaked.
What do y'all think so far? What do you think so far about
That
this?
could have been what killed the child. We talked about laryngeal, we talked about laryngeal convulsions. Could that have caused the death of the child? She admitted it could. Now, Ms. Massagill brought up tongue tie. I brought up tongue tie. I brought up GERD. I brought up an infection she had, because all of those things can lead to the onset of SIDS. That's the research, and Dr. Schmidt agreed with that. Now, I want to tell you something about Dr. Schmidt and Dr. Malushnik. I think Dr. Schmidt she was the medical examiner in Johnson City when this happened. Dr. Malushnik is not her boss. She's not, it's not like she's somehow over her. Dr. Schmidt was the chief medical examiner at the Jenkins Autopsy Center, Forensic Center. Subsequently, for whatever reason, the state sent her report to Dr. Malushnik for another opinion. Dr. Malushnik only reviewed her report, and she finds that it's a good report. But then she wants to go further and find some type of certainty that that child was placed in the trash can. And you saw an exchange between me and her in here yesterday. It went on for 4 or 5 questions. And I kept asking her, Doctor, can you say any type of certainty? What can you say about this? Can you conclusively say that child was dead when it was wrapped in the blanket, wrapped in tinfoil, and put in the trash can? She evaded that question. She wouldn't answer that question. She finally answered that question only after it was threatened she would be in contempt if she didn't directly answer the question. And her answer was, no, I can't say conclusively. And then she threw out kind of a parting shot at me as she left.
Oh, well, wait a minute. You fought like hell at the beginning of today for that judge to throw out that comment. He threw out that comment. He told them that you could not, told the jury you couldn't, he's throwing it out. You got to dismiss it. You can't use it as part of your deliberation. Can you forget that it was said? They all raised their hands. So that would mean to me that you should not be able to bring it up and use it against them in your closing argument when that whole that exchange was thrown out. So why in the hell are you getting to use it in your closing? I would be objecting.
For that parting shot, she said the child could have been murdered some other way. Should have been. The child could have died some other unknown way. That's what the truth would have been. She presupposed that this child was alive when it went in the trash can. The doctor who did the autopsy was very clear. She could not conclude that. She said it couldn't be excluded, but it cannot be included. Dr. McLucent come in with a preconceived notion of that's what happened.
What's
Now,
good for the geese is good for the gander, my dear.
the state has to prove to you cause of death in this case. They have to prove that child was unlawfully killed. They have to prove this wasn't an accident. The proof from Dr. Schmidt leaves open a heart, it leaves open SIDS, laryngeal convulsion, it leaves open all of those things. We don't know what happened. And it also left open a rollover, which is what Megan told Agent Fraley. And now, would Megan know for sure that that's what happened? Maybe not. You wake up and you find your baby dead in bed. Could you not come to the reasonable conclusion one of us must have rolled over on it? She's 17 years old. She's not sophisticated. She's had a hard life. She's scared that she's going to get in trouble. Hunter Wood's scared that he's going to get in trouble. And that's why she does what she does. Hunter takes the baby to dispose of it. She knows about it. Is that right on her part? No, it's not. Should she have called?
See, what bothers me about his
Absolutely
closing,
should.
what bothers me about his closing is the fact that he's bringing in a lot of stuff, but they didn't put on a defense. They brought on no defense. How can you bring stuff up like this in a closing when you put no defense on and there's no understanding of what happened? You brought in no defense. How can you be bringing this stuff in? I'm not a lawyer. But if I'm sitting on the jury and I'm hearing this and I'm thinking, you brought no defense, we can't use that against you. That's fine. It's 100% responsibility of the prosecution. We get that. I understand that. But you're bringing in all these theories. You're throwing all this stuff up without even bringing in your own defense. He tried to run his defense through his cross-examinations. I saw that happening. I was hoping he would not do what he did. I wanted him to put on a defense. As tired as I'm getting with this case, I wanted to see a defense. Now, yes, it cannot be used against him, against her in a court of law. Okay, that's fine. But then you're sitting here throwing all this crap at the wall, hoping, and I think you're right, hoping that something will stick. And it's like bringing in evidence. I mean, you're bringing in stuff that wasn't even brought up in evidence. I've got a bead conundrum here going on, y'all. I'll turn this back on.
I told you that in my opening statement. Have they proved that she's a liar over and over? They have. Don't deny that. They haven't proved she's a murderer. You have more counts of false report than I can really count. I think there's 11 or 12 of them. Almost every time she's talking to law enforcement, you're considering a count of false report. With the exception of, you're not considering one for the time she talked to Agent Fraley. That's not before you. I would submit to you what happened was the conversation with Agent Fraley on the 25th of February, almost 5 years ago.
Your Honor, he's testifying in his
was a breaking
closing.
point.
You can't testify during your closing.
It's a breaking point where she finally admits.
And that's one thing these jurors need to understand, and I hope they do. Anything that's said in closing is theory and argument. It is not evidence, and you cannot use it in the deliberation.
Evelyn is dead. She's able to admit to herself. You saw all these pictures she's sending back and forth before that. That's how she's grieving. Maybe she doesn't want to accept that the child is dead. Maybe as long as she keeps talking about it, talking to the media, talking to the police, and saying that Evelyn is somewhere else, she believes that. Maybe that's how she's getting by.
This is when I
You can't
couldn't live
judge
with them.
someone for how they grieve. You don't know what goes through their head. You don't know what they were raised with. I've never lost a child. I hope none of you ever have. But how am I to tell someone when they lose their child how they grieve? How am I to do that? Amber can tell you that. Oh, she shouldn't have went here. She shouldn't have did that. How does she know that?
You don't yell at the jury.
She's not in Megan's shoes. She's not out there living in that single wide trailer. That's not her life. She's not been raised by drug addict parents, a dad that beats on her mom constantly, and seen that growing up.
I would have a fit.
She's not seen that. She can't put herself in her shoes. It's not fair to say she murdered her child because she didn't grieve right. I resent it. You should too. You should look at the evidence in this case.
Is drama helping you
Did they
guys?
prove a cause of death? That's the stopping point on the homicide case.
I don't know
they
why.
Can't do it. They brought two medical examiners in here who contradicted each other. The first one at least had read her medical records. The second one talks about how she is perfectly a healthy child. She ignored everything in her medical records. She didn't talk about it. It was obvious to me. Should have been obvious to you. She hadn't read it. She didn't care. It was her job to come here and convict Megan Boswell of murder. If you don't believe that, why would she leave here and say, well, she must have been murdered some other way? She was a biased witness, and she wasn't a credible witness.
She had her expert opinion, and that's what she was sticking
Now, let's
with.
talk about the tinfoil. How could her one fingerprint be on a piece of tinfoil? Can y'all see this roll?
Oh, God, he's got exhibit E.
Okay, my fingerprint's on this roll. I've taken this one. The next person who gets this is going to get a piece of tinfoil with my fingerprint. That's a possible way.
That is true. That's a good point.
What's another possible way? We've heard that the tinfoil had food and debris on it. So there's food and debris in the trash can. But maybe the tinfoil was already thrown away in the trash can. If it came off of a roll like that, whoever got it would have had to have reached in there and gotten several pieces. There were several pieces of tinfoil. I believe 4. There should have been fingerprints all over it.
Oh, but I can give you a demonstration as to why it can't be lifted.
One fingerprint.
You want me to do that, sir? I'll
It
be
doesn't
happy
prove she
to.
put that tinfoil on there. Now, what about DNA on the garbage can? I would just about guarantee you, each and every one of you, your DNA is on your garbage can in your kitchen.
Yeah, that's true.
Your DNA is all over the house. Your finger, I said DNA, actually it's fingerprint. Your fingerprints are all over your house. It's the kind of thing we don't think about, but you touch something, you put your prints. I think that's what you should consider. I mean, probably Evelyn's handprint on the trash can. At some point, I think in opening, I mentioned to you an unidentified palm print on the trash can. Well, I didn't know at the time it was a child's because it wasn't in the fingerprint analysis report. It's not unbelievable that it's the child's. Now, Ms. Maxwell made a statement, and I was a little perplexed with it. The state wants you, or the defense wants you to believe that wearing gloves prevents putting fingerprints on something. You heard the fingerprint experts say they can. I think we all know that from our common sense stuff. If you cover the fingerprint up, you're not going to leave it on something. Now, let's go back to the statement with Agent Fraley. February the 25th. She's talked to law enforcement over and over. And she talks about how she breaks down. She breaks. It's the breaking point. She admits she's dead. And she's telling them the truth. How do you know she's telling them the truth? Because if she's still trying to lie to them, if she's still trying to confuse them, she wouldn't have said, I don't know where the baby is. It could be at Hunter's. It could be at Tommy's. Why would you say, if you're trying to lie to them, perpetuate this lie like Miss Masseyville tells you, that the baby could be at Tommy's? Why would you do that? Ask yourself that question. She's telling them where the baby is. She thinks, I think it could have been left one of these two places. Says, I want to find it. And you'll have that video. You can watch it as many times as you want to. I hope you will watch it again. You hear Agent Fraley talk about how he'll go to the DA. She's a scared young mother. He understands that. Now, I don't have to prove this case. I wish I could, but I can't. You can't prove a negative. What I can tell you is the state has not proven their case. They've not proven the cause of death. They've not proven that the death was an unlawful killing as opposed to an accident, or some rolling over in the bed being an accident, or some kind of health-related issue. They haven't proved that. Let's talk about the gloves. I go around in circles sometimes, and I hope y'all are following me. I apologize for that. But let's talk about those gloves. Ms. Masseyville talks about the criminal tore the gloves up in the trash can. I think if you'll remember back and look to your notes, TBI cut those gloves up for testing. I could be wrong, but I think that's the case. Now, what do those gloves tell us? Do they match up to anyone? No. But they do match up to an unknown male. There's not enough profile there to match it to someone specifically identify them, but it matches it up to an unknown male. That's why there's not multiple fingerprints on the tinfoil on the child. Those gloves that match some unknown male. We know it's male DNA. We know that. Finally, let me talk just a little bit about Hunter. There's a text thread, and it's in February. It's between Megan and Hunter. And it appears like Megan's telling Hunter the same story she's telling everyone else. But remember, Megan's told Agent Fraley that Hunter doesn't want his name brought into this. He doesn't want to be involved. He told her not to tell anybody anything about the child. At this point, Hunter, he throws out a name in that text. He talks about Agent Wilhoit. He's been involved with the police. He knows the police are looking at this. This is February the 22nd. Suggest to you that text thread is, look at the texts. They're self-serving. I'm just worried about the baby. I just want the baby returned safe. That's Hunter and Megan's way of covering Hunter's involvement in this. I'm not saying Hunter killed that child. But I'm saying he did dispose of the child. That text thread, it's a convenient way if you think about it. If you're trying to have proof that you didn't do something, if you start a conversation, start texting it, say, oh no, I didn't do that. Look at my text. I texted her, she's told me this. It's a convenient thing for him. He didn't give his DNA. We know that. His dad talks about he went crazy because he was called a baby killer. Maybe he went crazy because of his participation in disposing of that body. We don't know. Everybody seems to agree he has went crazy. You saw a document admitted this morning. That's where he's being held out of court over in Virginia to be evaluated to see where he's competent for some crime he's committed. He's up at Marion right now to be evaluated. That's what we know. I hope I've answered your question. I hope my argument has helped you somehow with this case. What I would say to you, if you have questions, about any elements of these crimes, and your questions are not answered to your satisfaction, you have reasonable doubt. If you say, I don't know how that child died, that's reasonable doubt in the homicide. I don't think I have much more to say to you. I go to a Baptist church and I hate long sermons. I'm used to it. I think I've been up here for about a half an hour, but I thank you. I pray you come to the right decision. Thank you.
Thank you, Mr. Scott. General, you make close on behalf of the state.
Thank you, Judge. Ladies and gentlemen, much like Megan Boswell, Mr. Scott seems to have some very convenient explanations for what happened in this case. Lots of things that happened in this case. All of the evidence in this case that points to his client, he's got some sort of explanation for it. But the problem is, in order to buy into this, in order to believe it, you have to believe Megan Boswell. You have to believe that when she spoke to Agent Fraley on the 25th, that she was somehow, for the first and only time in this courtroom, speaking the truth. But I think each of you, as you sit here, know that's not possible. That's not possible. Megan Boswell is one of those people. You used to hear the expression, the truth ain't in them. The truth's not in Megan Boswell. She doesn't know how to tell the truth. Everything that she tells to every person in her life is for some reason. And that reason is because Megan's trying to get something out of it. She is a master manipulator. Even at 17 years old, you sit there and watch those videos. She's trying to play everybody. She's trying to play the law enforcement officers who are interviewing her. She's playing her friends, every person in her life who walks through that gate and sat up on that witness chair was in some way manipulated by Megan Boswell. Some way. Whether it was about Evelyn, whether it was about how she was going to pay for a babysitter, whether you're the father of my child, whether you're a great grandfather, whether your wife who's dying of cancer is babysitting the kid. I mean, she knows no bounds. There is no person that she will not manipulate and tell untruths about and to. No one. But Mr. Scott comes in here today and says, yeah, hey, come on, ladies and gentlemen, the 25th, you could, that was the point, which she decided, hey, I'm going to be truthful here. No, it wasn't. And we know it's not. It was just another story. She was telling law enforcement to lead them some other way. That's all it was. And if you remember, Agent Gratz testified. General Massengill was asking him the question, when did this first thing about accidents and rollovers, when did that come up? Well, it came up when the police and law enforcement finally said, we got nothing going on here. We got to give her an out. We got to give her something so we can try to find this kid. They're the ones who suggested it. And then very conveniently the next day she comes in and guess what? Oh, yeah, I forgot. Yeah, that's right. I'm sorry. I'm sorry I've been lying to you all for days and days and days now. but now I'm going to tell you the truth. But that's not what happened. That's not what happened. I submit to you, the only time that Megan Boswell may have told the truth about some small portion, if you remember during one of the interviews, Lieutenant Price, who had been very patient with her up until that point in time, finally said, come on, something happened on December 21st. And she stopped him and corrected it. Remember? She said, no, something happened before December 21st. Yeah, something did. She murdered her child. That's what happened before December 21st. Ladies and gentlemen, before I speak further about the physical evidence that ties and shows that Miss Boswell is the one who is guilty in this case and who needs to be held accountable, I want to take you back to jury selection. Last week when you all were first up here and up there, and I asked you if all of you had brought your common sense with you. And if you, all of you, as you listen to the evidence in the case, would use your common sense. And everyone agreed that you would. And so I want to remind you of that. And it reminds you to apply that to the evidence that you've heard, the testimony that you've heard in this case. Because the defense wants to say that perhaps, again, speculating, it's a possibility that Evelyn just died one day in early December. And then all of a sudden, Megan engages in this just pattern of just totally bizarre behavior that involves wrapping her child in a blanket, tightly pressing her head in aluminum foil and stuffing her in a trash can, and then engaging in this just convoluted tale to anybody who wants to inquire about what's going on with Evelyn. But it's a remarkable coincidence, isn't it, that all this occurs at the same time that she starts working at the chicken shack. And then she meets Hunter Wood. You know, that Hunter Wood, the one who lives out on the lake in the big house. And remember, this is where Megan's living before December. These are the conditions Megan's subjecting her child to before December. Then she meets Hunter Wood. Big house out by the lake. Dad owns a business that I'm working at. There's other things she's telling investigators as time goes on. Needed a break. Watching 3 kids. Remember, her mom had the 2 other young siblings. Needed a break. Was tired. When did Ethan Perry step up? I've been raising this kid for a whole year by myself. Probably a little bit of truth in there. A little bit of truth. But it's a remarkable coincidence. This kid, Evelyn, natural causes, just dies right at the same time. Apply your common
I want
sense
to know what
and ask
happened to the
yourselves
baby that she was
why.
pregnant with before she was arrested.
Would Megan Boswell then start
Not a lie.
December the 7th? She tells Bailey Hawkins, hey, it's just me. Ethan's grandma has Evelyn right now. December
Did she
7th.
have the second
Remember, she
child,
starts
or was
taking
it
the second,
fake?
7th, 5 days. 5 days later. Why does she start telling all these things that are obviously not true? I'm in a custody battle with Ethan. I don't have her. Evelyn's sick. She's got the flu. I can't bring her. Can't bring her up there to get the Christmas gifts. Let you see her. Why does she do that? Why does a mom who, by everybody's testimony, everybody's, her friend Bailey Hawkins told you, I mean, yeah, she wasn't a perfect mom, but she did well. She did well. They all did. I mean, she's posting pictures on Facebook, Instagram. Everybody. her own pediatrician, Dr. Pugh, came in here. Yeah. She's a good kid. We didn't have any concerns. Healthy, meeting milestones, an advanced child. Why does a mom who dotes over her kid, who won't even let anybody babysit, she's so protective of this child? Remember Erica Stacy? I mean, heaven's sakes. I mean, that's an ex-boyfriend's mom who is willing to babysit the kid so that her son can go on dates with her. She won't let her do it. She won't let her do it. She will not let her babysit. That's how protective she is of this child. So why? Apply your common sense. She won't do it because she can't face the truths about what she's done.
What
She can't
happened
face
in the
that
second
truth.
pregnancy? Was it a
She
lie?
can't look at that picture, and I'm not going to put it back up there for you. She can't face what she's done to that child. Discarding her like a piece of garbage. That's what she did. She can't face that truth. So she engages in just spinning all these stories to everybody. Everybody that comes with a story, she's deflecting that out because she doesn't want to face that. It is almost unbelievable to me that the defense is still arguing that Hunter Wood had some involvement in this case. I mean, truly unbelievable to me that they're making that argument. That has no credibility, number one. And two, no proof whatsoever. Not a single shred of evidence has been presented in this courtroom that ties Hunter Wood to anything dealing with the death of Evelyn Boswell. Not one thing. It's all just rank speculation. Oh, well, because he's in a mental hospital, therefore he must have done something. Right? No. How many people walked up there, took that witness stand and said,
All
oh,
right.
yeah, I remember
Kingsport
when I
News,
saw
February
Hunter,
27th
Evelyn,
of 2020
and Megan
states
together? I remember when
that
I
the
saw
Sullivan
that.
County Jail tested
None.
her
Nobody
and
said
she's
that.
not pregnant.
How many people said, oh, yeah, I remember when I saw Hunter holding Evelyn at the chicken? No, again, nobody said that. No evidence, nothing from that witness stand ever put Hunter with Evelyn. She evidently wants you to believe, again, and I'll put this picture back up there. She wants you to believe that Hunter, and remember her when she's talking to Agent Fraley, that Hunter went over to her place. That's her place. Stayed the night with her and rolled over on the child. He's got a place over, nice place over on the lake, remember. But that's what she wants you to believe. When her
I wouldn't sleep in that
she's finally
house.
telling the truth.
I'd sleep on a sidewalk before I sleep in
Apply
that.
your common sense to that. What else possibly ties Hunter to this case? To Evelyn's body being disposed? Well, maybe it's the playhouse over on Tommy's property. No.
Sorry, guys. I don't know what
Mr.
the
Scott
hell.
asked you, and I wrote it down. He asked you who was more likely to have left a print on the foil. Well, I'll tell you who's more likely to have left a print on the foil. The person whose print was found on the foil. Megan Boswell. He stands up here, and again, we've got explanations for everything. Well, maybe it was possible she tore a sheet off earlier and Doing that, she grabbed the foil and left a print. Well, there's no Hunter Wood prints on any of the foil. The bag that's stuffed on top of the body where Evelyn's found. Multiple prints on that. None of them belong to Hunter. They all belong to Megan Boswell. He wants to say, and again, it's still beyond my comprehension that we're talking about Hunter Wood here. You know, why wouldn't Hunter give a DNA sample? I don't know. Perhaps because Hunter is being mucked up in Megan's world here. My gosh. Here I am dating this girl, and all of a sudden I got TBI agents asking me about a child that's missing and no explanation for it. Maybe that's why. And again, in this particular case, you heard from Agent Gray. What does it matter? There's nothing that was tested. All those things she testified to yesterday, all of them, all those things I handed up to her, that she analyzed, not one piece of them had any identifiable DNA on it that could have been tied back to Hunter. None. Everything was Megan's or Evelyn's or limited profiles. As I remember, I asked her if I get everybody in the world's DNA to her, she wouldn't have been able to match any DNA to Hunter Wood. Nothing. Nothing. Everything connected to that body in the trash can comes back to Megan Boswell. And then, let's not forget, in the middle, while all this is going on, February 22nd, Megan's child's missing. They questioned Hunter. And they had this conversation. And Mr. Scott wants you to believe that this is some kind of contrived thing between Megan and Hunter. But what evidence did you hear that there was any sort of contrived conversations going on here? Nothing. Again, nothing. In order to believe that, you've got to believe one person, Megan Boswell. And we know you can't believe her. No. Hunter says, yeah, but where's the baby? I just want the baby to be found safely. What's her response? If she was truly trying to cover this up, a little bit better response would probably be heard. She says, Dad won't let me go anywhere because of the situation. Hunter, I can't disclose stuff to you on here about what TBI is doing. His concern, please assure me the baby will be found and brought home safely. That's not a conversation with someone that you have that has disposed of a body, that has helped get rid of your dead child. That's not a conversation. Hunter Wood is not at play here, ladies and gentlemen. Not at all. Not at all. Defense has also talked to you about these things that medical conditions that they questioned the medical examiners about yesterday. Possible things that might have caused Evelyn to just suddenly die of natural causes. A perfectly healthy child. Again, he's asking you to speculate about possibilities. But we don't decide this case on possibilities. And if you think about it, ladies and gentlemen, you didn't hear from just 2 doctors about Evelyn's condition, about what kind of a child she was. You heard from 3 doctors. Her pediatrician testified in this case too. And what did she tell you? Evelyn was a healthy child, advanced, had met all of her milestones. Any concerns about her health? No, her concern was that on December the 5th, she doesn't show up for her year checkup appointment. She's a no-show. That's her concern, not Evelyn's got tongue-tied. I'm concerned maybe she's going to die from SIDS. Not, oh, she's got some sort of reflux going on. I'm afraid she might be at risk to just suddenly die one day. That's not her concern. And remember, and Mr. Scott didn't talk about this because you don't want to talk about it. I asked Dr. Malushnik yesterday about statistics. This wasn't just her opinion. These are statistics kept by the Department of Health in Tennessee about the number of kids over 1 year of age who died in rollover deaths. Entire state of Tennessee last year, none. Entire state of Tennessee last 10 years, none. But yet they want you to believe that's a possibility in this case. She's the first one, ladies and gentlemen, evidently, the first one. No, it's not a possibility. You decide this case on the evidence that you've heard, the testimony you've heard from that witness stand. And the testimony you heard from 2 different medical examiners is that this child died from asphyxiation. That's what they told you. Both of them told you that. He said they had contrary opinions. They didn't have contrary opinions. One of them had a little stronger opinion, but they both had the same opinion. They both told you the cause of death was the same thing, asphyxia. And all the evidence in this case points to one person alone as being the person who caused that asphyxiation. Trying to get you all to believe the rollover, believe the accident, believe my child died of natural causes, and that I just flipped out and engaged in this totally bizarre behavior. But in order to do that, you have to ignore the evidence in this case. You have to ignore the forensics that place her and her alone as the perpetrator of this crime. This case is the very opposite of an accident. It was an intentional and knowing murder of a child. Megan Boswell got rid of Evelyn so that Megan could be Megan. She enjoyed it. You've seen the pictures General Massengill showed you. Hanging out on Blowing Rock, going to the aquarium, Super Bowl party. Megan Boswell sits here in this courtroom today as guilty as she was back in that first week in December. As guilty as she was on February the 18th, when she first came in there, Detective Perez, the James Lewis interview. She acted all surprised. What are y'all going to do? You going to find my child for? What do you do when a child goes missing? Remember those expressions, those questions she threw out there? She sits here in this courtroom today as guilty as she was back then because she never learned the one lesson that we all know, which is that you're responsible for your actions and your choices in life. And she sits here because she refused to learn that lesson. You've heard her interviews. She takes responsibility for nothing. But today is the day that you get to hold her responsible for those actions, for her poor choices and decisions, for her decision to get rid of Evelyn, to dispose of her like a piece of garbage. That's what she did, ladies and gentlemen. She disposed of her child like a piece of garbage. But her poor choices and decisions have a price, and they have a consequence. The state has proven to you over the course of the last week, Megan Boswell was guilty. First-degree murder, false report, tampering with evidence, and failing to report that death to authorities. We ask today that you hold her responsible for those poor decisions by finding her guilty as charged.
Thank you, John. Thank you, City Attorney. Mr. Hyatt, Mr. Selner, Mr. Arnett, you're the three alternates. If you will go with the officer. Just leave them in the seat. That'd be fine. And your notes as well. We'll just take care of them. The rest, what do you mean? Yeah, I'm going to finish the charge. All right. Now, back on page 49. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict, you will return with it to this courtroom, and your foreperson will deliver the verdict form to the court. Take with you the presentment, the exhibits, the verdict forms, the court's written instructions, and you may retire and consider your verdict as soon as the officer comes back to get you.
Everyone stand, please.
305 p.m.
Take the ones that you have. Just
Right.
leave
Leave the others.
That's the one that you put, don't worry about the ones that belong to the others. You may be seated. Thank you.
All right. We'll be in recess waiting verdict of the jury.
All right. Oh, I got to set the timer. We're in jury watch. All right. We are in jury watch.
Yay. All right, let me get over to the other trial. We're going to start the other trial. Let me see where it is. Oh, somehow it disappeared. Let me get it up and going. What do y'all think? What do you guys think? I'm going to share this. I'm going to biggen it. I got to do a thingy over here. All righty. Now we are in the, what is this trial called? There's the secrets. I hate it when things don't work like your computer. You want your computer to work on it.
Please take a seat. Thank you so much.
Wait a minute. Is this the one that where we're talking about, you guys? I need your comments. Is this the one that we're no, that's not what we want. Is this the one that we want, the twisted secrets? I need some input from you guys. Hello, is anybody home? I guess it is. I'm just going to do it. I don't know if it's the right one or not, but this is what we're going to do. Is this the rose petal? I haven't followed any of it, so I have no idea. Yeah, this is it. Okay, we're good.
Does not speak to you sometimes.
We may have decent sound out of this trial. This is that trial. Okay, here we go. New trial. And we are in verdict watch. I know absolutely nothing. Let me zoom this a little bit more. Come on.
What the facts are. You will hear the evidence, decide what the facts are, and then apply those facts to the law I give you at the close of this case. That is how you will reach your verdict. In doing so, you must follow that law, whether you agree with it or not. The evidence will consist of the testimony of witnesses, documents, and other items received into evidence as exhibits, and any fact on which the lawyers agree or stipulate. The same law that makes you 12 the finder of the facts makes me the judge of the law, and our rules of evidence control what can be received into evidence. When a lawyer asks a question or offers an exhibit into evidence and a lawyer on the other side thinks it's not permitted by the rules of evidence, that lawyer may object, and that simply means that the lawyer is requesting that I make a decision on a particular rule of evidence. South Carolina law forbids a trial judge from making a comment to a jury about a fact in a case. Therefore, because it may be necessary for me to comment on a fact in applying our rules of evidence, it may be necessary for me to talk with the lawyers out of your hearing by having a bench conference while you are present in the courtroom or by excusing you from the courtroom. The purposes of these conferences is to decide how certain evidence is to be treated under the rules of evidence and to avoid confusion and error. I ask you, be patient during these breaks. Certain things are not in evidence. Statements, arguments, questions, and comments by lawyers representing the parties in the case are not evidence. Objections are not evidence. Lawyers have a duty to their clients to object when they believe something is improper under the rules of evidence. You should not be influenced by the objection. If I sustain an objection, you must ignore the question or exhibit and must not try to guess what the answer might have been or the exhibit might have contained. If I overrule the objection, the evidence will be admitted, but do not give it special attention because of the objection. Testimony that I strike from the record or tell you to disregard is not evidence and must not be considered. Anything you see or hear about this case outside this courtroom is not evidence unless I specifically tell you otherwise during the trial. Finally, some of you may have heard the terms direct evidence and circumstantial evidence. Direct evidence is testimony by a witness about what the witness personally saw, heard, or did. Circumstantial evidence is indirect evidence, that is, it is proof of one or more facts from which one can find or infer another fact. You may consider both direct and circumstantial evidence. The law permits you to give equal weight to both, but it is for you to decide how much weight to give to any evidence. In deciding what the facts are, you may have to decide what testimony you believe and what testimony you do not believe. You may believe everything a witness says or only part of it or none of it. In deciding what to believe, you may consider a number of factors, including the following: the witness's ability to see or hear or know the things the witness testifies to, the quality of the witness's memory, the witness's manner while testifying, whether the witness has an interest in the outcome of the case or any motive, bias, or prejudice, whether the witness is contradicted by anything the witness said or wrote before trial or by other evidence, and lastly, how reasonable the witness's testimony is when considered in light of other evidence which you believe. It is my responsibility to rule as a matter of law as to whether certain testimony is admissible. But once the testimony is admitted, whether or not you believe it is solely for you to determine. To ensure fairness, you as jurors must not talk among yourselves about this case or about anyone involved with it until the end of the case when you go to the jury room to decide your verdict.
We're going to zoom through this. We're going to go straight to opening. Okay, we're going to go straight to opening. We've heard enough of this. We know what the...
My name is Walt Wilkins. Myself, along with Jake Hofreth, we are the prosecutors in this case. This is Detective Jared Sparkman and Master Deputy Blake Wolf.
Yes, courtroom.
They're the co-lead investigators in this case. I want to thank you for your service and thank you for giving us the opportunity to present this case to you. The state has the obligation to prove the charges beyond a reasonable doubt. And that's the standard that you're going to hear from the judge. You're going to hear throughout your deliberations and throughout this trial. We have to prove the case beyond a reasonable doubt. And there's a lot of folks in this courtroom right here that you see. So we are the prosecution. We represent the state. We have the honor of representing the state in this particular case. The defendant sits over there. That is Zachary Hughes along with his attorneys, and they represent him in this particular case. But there's many more other individuals in this case. We have the court reporter. She's very important. She is taking down everything that we're saying, recorded, so we can have a record of this entire case at its conclusion. And so that's what she'll be doing, and she'll also be marking exhibits. So if you see her over there writing on things, that's what she's doing. She's marking the exhibits in which we will identify things that we will be presenting to you for your review. This is Madam Clerk. She's involved with a lot of paperwork and handles all the evidence that we submit into the court. So she'll be handling all the exhibits that you will get to review upon your deliberation. And of course, we have the judge up here. And if you'll notice, the judge is a pretty important person. He's got a black robe. He gets to sit a little higher than the rest of us. And there's a reason for that, because he is the referee in this case. And he's going to be calling balls and strikes. He's going to be telling us what the law is. And when one of the parties has an objection, he's going to say whether you're right or whether you're wrong. And because there are rules in this courtroom, ladies and gentlemen, the rules are officiated by the judge to make sure that we maintain the rules and decorum in this courtroom and the evidence is presented to you in the proper way. But the most important people in this room, ladies and gentlemen, are you. As the judge said, you're the triers of fact. You decide what the facts are. And the great thing about serving as a juror is that you don't leave your common sense at the door. You get to bring it with you in here. And you get to listen to the testimony that'll come right from this chair right here. And you get to look at the evidence that's presented in your deliberations. And you can see it along the way of how this case progresses. You'll hear different kinds of evidence. So the judge said, you hear direct evidence and circumstantial evidence. They're both very powerful pieces of evidence. They can be used in a way, any way in which you accept them. Direct evidence is simple. It's something that somebody can see, taste, or smell, something that they see. If you see somebody commit a violent crime, that's direct evidence that they saw that person there. Circumstantial evidence can be just as powerful. For example, if you look outside before you go to bed and you see your lawn nice and green, and you wake up and it's covered in snow and there are footprints walking through the snow, well, you know that somebody walked through your yard from the time you went to bed and the time you woke up. You don't know who it is, but you know somebody did because you can see footprints. You can derive information from that to form a logical conclusion. Another good example of circumstantial evidence is DNA evidence. If you have DNA in a certain location, you can derive that that person was at that location at that particular time, even though no one may be testified that they actually saw him there, but the DNA shows that he was or she was there at a particular time. Very powerful circumstantial evidence. So, ladies and gentlemen, this case is about the murder of Christina Parcell. And the state intends to prove that Zachary Hughes did, in fact, murder Christina Parcell. You have a number of charges that you're going to be deliberating on. You have harassment charges, you have a burglary first-degree charge, and you have a murder charge. Harassment is basically doing something that would intrude into the personal life of somebody, causing mental anguish. Burglary first degree means you went into somebody's home for the purpose of committing a violent crime. And then, of course, murder is an angry heart. We have to show that Zach Hughes had an angry heart. He was mad. And you can derive that information from any of the testimony, any of the evidence that we have that we present to you. So in this case, ladies and gentlemen, you're going to hear about a number of characters. The main character is Christina Parcell. She was murdered on October 13th, 2021. And she was living in the Canebrake neighborhood with her sister, Tina Parcell, and Christina's daughter, Aida Mello. They were living in that neighborhood in a house in Canebrake. And Christina Parcell had been going through a very tremendous child custody dispute with John Mello since Aida was 3 years old. At the time, Aida was 9. For almost 6 years, they had been battling custody over Aida Mello. And that custody dispute raised to a certain level beginning in October of 2020 when John Mello and Aida Mello went to Italy. And John took Aida Mello to Italy, and Christina fought to get her back. And in April of 2021, Christina obtained Aida's custody. And they came back from Italy, and that's how they ended up living in the Cambridge neighborhood. So the question is, how did Zach Hughes become involved in this case? Well, Zach Hughes had a relationship with John Mello starting in about October of 2020, around the time when he left for Italy. And that relationship grew. And it grew to the point where Zach Hughes began inserting himself into this custody battle at the behest of John Mello. And they began doing things like sending photos of her to the neighbors in an effort to shame her, an effort to show that she's a bad mother. And as the custody dispute it elevated into a situation where custody might not go in John Mello's favor. And at that point, Zach Hughes made the ultimate decision. Ladies and gentlemen, I hold in my hand the indictments from the grand jury charging Zach Hughes with harassment and burglary first and murder. And the grand jury, true bill of these cases, they came out, and these are the charging documents. And while the defendant at this point in this case is certainly clothed in innocence, once you hear the evidence from that chair, you hear the evidence that's presented to you, you're going to find beyond a reasonable doubt, and the evidence will show that Zach Hughes is a cold-blooded killer. He committed murder, he committed harassment, and he committed burglary first. Thank you.
Thank you, Your Honor. May it please the court, the defense is going to defer opening until our case. Thank you, which is your right.
What about deferring the opening?
Correct, Your Honor. The state calls Sarah Young.
I got to hear that again.
Zach Hughes.
The defense is going to defer opening until our case. Thank you, which is your right.
Okay, so they will do their opening once
Correct, Your Honor.
the
The state calls Sarah Young.
Okay, I've not seen that before. Have y'all?
Just place your left hand on the Bible, raise your right hand. Do you
Oh,
solemnly
they
swear
put it
or
on the
affirm to tell
Bible.
The truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you. Please be seated.
Oh, I haven't seen that one in a while.
Please state your name for the record.
Sarah Young,
Ms. Young, with whom are you employed?
the Greenville County Sheriff's Office.
And what do you do for the Greenville County Sheriff's Office?
I'm the 911 tape research analyst.
And what is a 911 tape research analyst?
Essentially, we pull 911 calls for the solicitor's office and the officers.
And so how does 911 operate?
Essentially, when a 911 call comes into dispatch, dispatch determines whether or not which agency the caller is needing. So whether or not they need police, fire, EMS, they'll get information from the caller and they'll transfer them to the proper agency.
And are the calls recorded?
Yes.
And when do they begin recording the call?
Automatically. As soon as someone calls in a 911, it automatically starts recording.
The moment
So
that
while
starts
it's
ringing-
ringing on, say, the caller's side, it's recording on your side?
Yes, sir.
Is that fair? And do y'all maintain all of those records?
Yes, sir.
Inside the 911 office?
Yes, sir.
And are those records kept in the ordinary course of business?
Yes, sir.
Okay. I'm going to show you. I'm going to show you what's been marked as State's Exhibit number 7 and ask you if you recognize that.
Yes, sir, I do.
Are those your initials on there?
Yes, sir.
All right. And what is this?
That is a recording of the 911 call.
is this a recording of a 911 call on October 13th, 2021?
Yes, sir.
And you have your records up there?
Yes, sir.
To help you remember?
Yes, sir.
It was a long time ago, wasn't it?
That it was.
Do you know about what time this call came in?
The call came in at 11 a.m.
At 11 a.m.?
Yes, sir.
And do you know what number called it?
Yes, sir.
What number called it?
The number we have recorded is 864-436-2499.
And do you know who was calling? Does it tell you?
The caller did not give his name.
Did not give his name.
No.
And do you know what address that it was? He was calling for?
Yes, so the address provided was 122 Canebrake Drive.
Do you know if that's in Greenville County?
Yes, sir.
Your Honor, state moves Exhibit 7 into evidence.
Give no objection, Your Honor. Without objection, states number 7 comes into evidence.
I agree with you, Aaron, but at the same time, there's a lot of people on the jury that really have no understanding and never been in a courtroom and may not know what's what, who's who. So it was a little childish in presentation, but I appreciate him explaining so they know what they're dealing with and why. I get it. Yeah, it was his tone I didn't really appreciate so much, but I didn't have a problem with what he was saying.
I'm sorry? I think I might have a debt.
Okay, let me connect you.
Walked in my fiance's house. She wouldn't answer my call. There's a very weird smell, and I can't get her to come around.
Okay, let me
Laid all over the floor.
let me connect you to EMS, sir. Hold on just a moment.
Right.
Family Fire, what's the address of the emergency?
122 Canebrake Drive.
122 Canebrake Drive, and what's another street for Canebrake Drive?
I don't know, Southgate Drive.
Okay, in Greer.
Yes.
All right, the phone number you're calling.
I'm sorry?
The phone number you're calling from?
864-436-2499.
864-436-2499. And has anyone tested positive COVID-19 or been exposed to COVID-19 positive?
No. I just walked in, I can't reach my fiance, I came in the back door, she couldn't go there. I smelled some weird smell, and it was like she bled out on the floor.
Okay, you smell a weird smell and she's flat on the floor?
Yes.
Okay, just one moment.
I think I tell you, my list I did.
Is she breathing?
No.
Okay, then we need to get her, turn her over, make sure she's flat on her back, nothing under her neck. You have something to put over her nose and mouth, and we're gonna start CPR, sir.
Oh God, not with lies.
You think she's gone?
Yeah.
Okay, and what makes you think she's gone? I'm sorry?
What do I do? I don't
Well, wait, we're gonna put her flat on her back, and then I'm gonna walk you through the steps to do that. If you think that she's, able to do the CPR, then we can. I have no problem walking you through that.
It looks like there's brain matter everywhere. It looks like there's something.
There's brain matter everywhere?
It looks like it's a thing that's something out there. I don't know.
Somebody had shot her? Okay, all right. All right, do you think that she's, not viable?
I don't know.
Okay, so tell me why you think she's dead.
So she won't respond.
Eyes are open? Okay, all right.
There's a lot of blood.
And a lot of blood, okay.
Anyway, the flowers, I somebody must have come
If you toxic, we love you, but we're glad you're taking care of yourself.
but the smell is very.
Okay. All right, give me just a moment here, sir. Give me just a moment. So it looks like somebody may have broke in and shot her in the head.
Me, I don't know.
Okay, I understand. Okay. I'm sorry, say it again. I've got some people coming, sir. Do you see anybody, still nearby, an assailant or anything? No?
No.
All right. The front door was locked? Okay.
The back door was walked on, you didn't respond to my call.
Yes.
I pulled over, and then I came back and smelled this weird smell.
Right.
And I walked in, I could see there's like a raised floor.
Yes. Okay. I have everybody coming. I'm sending the paramedics to help now. Stay on the line. I'll say exactly what to do next. Make sure to not, move anything, leave everything as it is.
Yeah.
And, if you can, go ahead and step out of the house, and that way, wait for the, paramedics and the police at the front of that. Yeah, I would go back out the way you came to, keep the scene as it is.
Yeah.
And then if they want to go through the front when they get there, then they'll let you know, but I'd go back out the same way that you came in.
Okay.
And leave everything as you found it.
Yeah, I think it's gonna, I don't think it's gonna on
Yeah, okay, leave it, just however it is right now, just walk out, you can let them know you didn't know if you turned it on or off, but just leave it as it is right this moment.
The same thing, really, really good smell.
Oh, really weird.
Like this, yeah, almost, chemical.
Like a gas or a chemical? More like a gas smell?
No, it's more like something with just a pesticide.
A pesticide smell? Okay.
Yeah.
All right, go ahead and get out the door and go to the front and wait for them at the front, of the house. Leave everything as it is. Is there anything else that I could do for you, sir?
No.
All right, I've got them all coming.
Okay.
All right, thank you. Sir, this is the sheriff's office?
Is that the recording you retrieved from 911?
Yes, sir.
Answer any questions defense counsel may have.
No question, John. Thank you.
All right. Ms. Young, step. No, we ask the witness be excused.
They be excused.
Your Honor, the state would call Deputy Chris Robinson.
Man, I love their microphones in this courtroom. Don't y'all? Man, they are nice and clean. I don't feel any weird stuff on the back end of it. Is it sharp for you guys? I literally know nothing about this trial. So if anybody wants to catch me in on something that's going on, don't hesitate to do so. Wonderful, Aaron. It just feels comfortable on my ears, which is not something I can say often.
The whole truth and nothing but the truth, so help you God.
I do.
Thank you. Please state your name for the record.
Chris Robinson,
With whom are you employed?
Greenwood County Sheriff's Office,
And where's your current rank?
Master Deputy.
Master Deputy. And what do you do for the Greenville County Sheriff's Office?
Currently on uniform patrol.
And what does that entail?
Answer your day-to-day calls, 911 calls.
How long have you been with the department?
10 years.
I'm going to refer you back to October 13th of 2021. Do you remember getting a call to the Canebrake neighborhood?
I do.
Okay. How did you get that call?
It was just a call for service at the time. Someone called 911 and I responded to that address.
Where were you located when you got that call?
Pelham Road at the QT.
How far away is that to the Canebrake?
A couple miles, maybe.
How long did it take you to get there?
Just a few minutes.
Now, did you go with your blue lights on, or did you
Absolutely. Just for the nature of the call, yeah, we responded a license siren.
So what address did you arrive to? Do you remember?
I'm not 100% there.
122 Cambridge?
That would be it, yes, sir.
And so what happened when you got there?
So once I arrived on scene, I made contact with the complainant, Mr. Post. He was standing in the driveway. I was kind of briefly spoke to him, tried to figure out kind of what was going on. He told me that he arrived home or arrived to the victim's address when she wasn't answering her phone. So he said he went in the back door, it was unlocked, and that's where he located her. So at that point, another deputy arrived on scene. So we decided to go in there and clear. We went in the back door. He said it was unlocked. They always leave it unlocked. So that's the way we made entry. Went inside immediately. As soon as we got inside, immediately smelled some kind of chemical odor. It was kind of unusual. We weren't 100% sure what it was. I could never figure it out, but we cleared the residence. I located Miss Parcell in the living room. There was blood all over the floor. Looked like there was drag marks on the floor where she was had been drugged by her feet or drugged somehow. She had multiple lacerations around her upper, her face or neck area.
All right, I'm gonna stop right there. I'm gonna take you back a little bit. Now, when you get out of your car, did you walk down the driveway?
Yes, sir.
And what cars were parked there?
There were two cars in the driveway. They were kind of parked one behind the other. One, I think it was a Mercedes, was the back one. Not remember which one the first one was.
And where did you encounter Mr. Post?
He was in front of the first car closest to the house.
And then that's where did you obtain some information from him about what was going on?
Correct. Just like I said, the basic information about, or he came home and he couldn't get her on the phone, so that's why he showed up.
And so, your next item to do was to clear the house.
Correct.
And did you do that alone, or do you?
No, Master Deputy Brookshire was there. He went inside with me. We did it together because we didn't know what was inside or who else was inside.
So at that point, you have no idea what you're walking into.
Correct.
Is that standard procedure to have two individuals clear the house?
Yes, sir.
And did y'all in fact go and clear the house in this case?
We did. We cleared the entire house. Didn't find anyone else inside besides Miss Parcell.
Were you wearing a body camera?
I was.
And was it functioning properly?
Correct.
That day?
It was.
Have you reviewed that body camera?
I have.
I'm going to show you what's been marked as State's Exhibit A and see if you recognize that.
Yes, sir.
Guys, I will show it until there's a
Those are
body
initials right there?
Yes.
it out. Then I remove it.
Is this your body camera that you were wearing that day?
Yes, sir.
When you made a call to 122 Cambridge?
Yes, sir.
Your Honor, State moves Exhibit 8 into evidence.
No objection, Your Honor. Exhibit A comes into evidence.
All right. Master Deputy, I'm going to show you this body camera and we can start and stop it. I want you to kind of walk us through what you're doing and what you see as you're going through and you're clearing the scene with Officer Brookshire.
Yes.
I don't know if they're going to show it. We'll see. I guess they are. But as you guys know, I'm not going to show it if it gets. I don't play that game.
So what is that there?
That's us arriving on scene, or me arriving on scene to 122 Cambridge.
All right, and so is that the first time you saw this location?
Yes, sir.
And are those the two cars right there that you can see the silver one in the front?
Correct. Yes, sir.
And there was a red one behind it, I believe. All right. Is that where you encountered Mr. Post?
Yes, sir, initially.
And what is Mr. Post doing?
He was making a phone call. I'm not sure exactly who he was on the phone with. And we're just I'm getting basic information from him. kind of figured out what was going on, kind of what he saw, and what.
Are you
kind of
gathering
like-
information from Mr. Post?
Yeah, just basic information, try to figure out exactly what we have.
Now you have audio on your body camera, don't you?
Yes, sir.
All right. We're not playing the audio for these purposes.
Okay. So yeah, just basic information, trying to figure out, when was the last time he talked to her, things like that. I could see that he was, dressed nicely. He wasn't, there's nothing on him like where there's been a struggle or anything like that too. So he didn't seem like he was in a hurry. So it seemed like there was, she was deceased, just according to his body language.
Well, this is going to be a real raw.
So where are you going down here? The side of the house?
Yes, sir. He pointed us to the back. This is the back door. He said that that was always unlocked, and that's where he made entry. So this is where we decided to go because we knew that this door was more than likely unlocked
And already
good
compromised.
access to the house.
So is this your first entry into the house?
Yes, sir.
Okay, guys, I'm getting ready to pull it if it happens.
Did Mr. Post tell you which door he entered into the house?
He did. He said he'd come in the back door because he said they always kept it unlocked. So, and that was the door that we decided to make.
So the
entry
door
to.
being open right there was not concerning to you?
No, because he already said he was already in it. He had already been through, and that's where he went in. So I'm just talking to Master Deputy Brookshire here. We're just kind of talking back and forth about what we see inside the house, kind of what each other is going to do, kind of your primary job responsibility, and that's all standard.
And in clearing the house, what is the purpose of clearing the house?
One, to secure any kind of evidence, and also to make sure there's no one else inside, maybe no other victims or the suspect as well.
Making sure it's safe to maintain, to be in there. Securing, seeing me.
So where is Deputy Brookshire?
He's to my right. He's holding on. There's a hallway on the right side of the
And
house.
so where did you just see right there?
Miss Parcells' body.
Okay, so that was the room where you found Christina Parcell?
Correct, in the front living room area.
And y'all continue to search the house for any suspects?
Yes, sir. We're just continuing to clear. I had him hold the hallway, and I kind of just moved up and cleared kind of behind him up to him. And then we started clearing the bedrooms down the hallway.
Guns were most likely drawn, and I just put it that way, but oh. Lead shooters were drawn.
We're just sitting there just kind of talking our way through this, kind of, hey, what do you see?
And are you conscious not to disturb any part of the crime scene as well, as best you can?
Correct. Try not to touch anything. Obviously, opening the doors or whatnot, we kind of have to push them open. But we're not kind of rummaging through anything or opening any drawers, or we're just looking for humans at this point. So the big areas where somebody could hide.
Let's continue to clear the house.
Yes, sir. I believe that was the last bedroom that we cleared at that point. I believe I come out, we secure the house so nobody goes in or out.
Now, are you corresponding with other officers outside the house as well about what's going on? Are you reporting back to anybody?
Talking on the radio, just kind of letting them know what we have at this point, getting a supervisor on the way. They always respond to these kind of incidents.
Is that the front door right there to your right?
Yes, sir.
That's not the door you entered into.
No, sir. That's the front door to the residence that leads into the front living room area that Ms. Parcell was located in. At this point, I'm just checking to make sure there's no signs of life. If we need to render any kind of medical aid. Looking for any kind of weapons to make sure it wouldn't, she did it to harm herself too.
And then now are y'all exiting
The back door.
the back door? So it's about. So did you cut your body camera off about that time? Let me ask you this. That's about when you finished clearing the house.
Correct.
All right. Your body camera still continues to operate.
Correct.
Do you remember what you did after you cleared the house?
Went back.
FYI, military plane crashes near San Diego. Recently, 2 pilots were rescued after military plane crashes. Come on, give me the header. I hate these damn commercials. They cover up the heading. Into the water near San Diego. Officials say, let me share this. Some of you, we'll get back to the trial. 2 pilots flying a military plane have been rescued, taken to the hospital after the airplane crashed into the water near Shelter Island in San Diego, California, according to the officials. San Diego Fire said the crash reported at 10:16 a.m. local time, 12:16 p.m. our time. That the military confirmed that at 10:42, only 2 pilots were aboard the plane. No fatalities were reported. The 2 pilots were taken to nearby medical center for treatment, according to the San Diego Fire Department. They are in stable condition after being underwater for a minute. U.S. Navy told local media outlets that the plane was a Boeing EA-18G Growler. The United States Coast Guard said the pilots were in stable condition after they were underwater for 1 minute, according to the news. All right. Well, congratulations on survival, and all that military training in water paid off for you. But dang, that sucks, y'all. That sucks, y'all. We are now
Post got some basic information, names.
43 minutes
kind of
into
the last
the
time you spoke with her,
duration.
things like that. And just waited on everybody else to show up.
Did y'all begin putting crime scene tape up?
Yes, sir.
Those
Just
kind of things.
yes, sir. Just locking down the house, making sure nobody goes in or out, just to keep the crime scene preserved best we could.
And as far as Mr. Post is concerned, did he appear to have any blood on him? Anything like that?
No, he was dressed pretty nicely that day. Sports coat, nice slacks.
Notice the shoes? Mama said they always notice your shoes.
You'll just answer any questions. Thanks, Councilman.
All right, cross-examination.
Yeah, please report. Just curious, Deputy Robinson, at the time this happened, were you a master deputy?
I was.
You talked a little bit about some of the comments Mr. Post made to you after you arrived on scene. You testified to that in direct examination. I want to talk about some of those comments. Master Deputy Robinson, isn't it true that roughly about a minute, 25 seconds in to your body camera, Mr. Post told you that he was there every day, or practically every day?
Objection, hearsay.
Your Honor, he's moved in the body camera. There was no exception as it relates to audio. The whole video and audio is in.
Overruled. So, if I remember correctly, yeah, I mean, he says he's there often.
Isn't it true that roughly at about 12 minutes and 45 seconds in, somewhere in there, Mr. Post told you that he did not at that point feel comfortable continuing to talk to you? Do you remember that?
I do when I was asking questions.
He has a right to an attorney. He found her.
And isn't it true that while you were talking to him, he directed you to another deputy, a deputy Dan Bevel? You might know more about the situation. Is that true? Do you remember that? At about 13 minutes and 35 seconds in, roughly.
I believe that was with a different case.
But while you were there that day, isn't it true that Mr. Post directed you to Deputy Bevel as someone who might know more about this case? Is that true?
Not about this direct case, but I guess he's been involved with the victim before.
You're allowed to get that in there?
At some point, was Mr. Post placed in the back of a patrol car that day?
He was. You know, he was the first one to find her, so standard procedure is to kind of detain him until investigators could arrive and speak with him.
And at the time, isn't it true that strike that. 1 second here.
Oh, what?
I don't have anything else.
Okay, thank you. You redirect. No redirection.
Was awkward.
Thank you.
Mr. Under State calls Bradley Post.
I'll be right back.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your name for the record.
Bradley Post.
Good afternoon, Mr. Post. Where do you currently reside?
Greenville County Detention Center.
And have you been charged with a crime?
Yes.
Do you know the victim in this case, Christina Parcell?
Yes.
How do you know her?
We dated and were engaged on and off about 6 years.
And about when did y'all start dating?
2016.
Whoa!
And in 2016, where were y'all living?
What did I miss? What did I miss? You said
I was living at my house in Rivoli Lane. She was living in her house or apartment.
I gotta go back. Forgive me. I gotta know who this is. I gotta know. Why is the 13th juror poll coming up? Ha, 93% think that the verdict should be guilty in the baby Evelyn trial on court TV with almost 15,500 votes.
Good afternoon, Mr. Post.
Wow.
Where do you currently reside?
Wow, we're pretty good.
Greenville County Detention Center.
Oh.
And have you been charged with a crime?
Yes.
What was that?
Do you know the victim in this case, Christina Parcell?
Yes.
How do you know her?
We dated and were engaged on and off about 6 years.
Oh.
And about when did y'all start dating?
2016.
And in 2016, where were y'all living?
I was living at my house in Rivoli Lane. She was living in her house or apartment. I don't remember what she had at the time.
Were you aware of a child custody dispute between Christina Parcell and John Mello?
Yes.
And was this custody dispute ongoing from 2016 up until 2021?
Yes.
And how were you involved in the child custody?
Whoa.
I would listen to her talk. Sometimes I'd assist her to go to an attorney, whatever, but, she'd just tell me about what it was.
Was it contentious?
I'm not sure what you mean.
Was there a lot going on in it?
Yes.
Was John Mello fighting very hard from his perspective?
Yes.
And Christina was fighting as well?
Yes.
Now, do you know where Christina was living on October 13th, 2021?
On Cambridge Drive.
Is that 122 Cambridge?
Yes.
And do you know who was living at that house at that time?
Yes.
Who was living there?
Her sister and her daughter and her.
Okay, what is her sister's name?
Tina.
Tina Parcell?
Yes.
And did you have the occasion to go to that house?
Yes.
And would Christina Parcell go to your house on Rivoli Lane?
Yes, sometimes.
And what kind of car was Christina driving at that time?
Lexus.
And who owned that car?
It was mine.
All right. Did you offer her to be able to drive that car?
Yes.
And did Christina Parcell have a cell phone?
Yes.
And did you assist her with the payments on that cell phone?
She had actually 2 cell phones. She had her own sometimes and mine also. Yes.
Did y'all communicate
Yes.
between those 2 phones? Do you know about when Christina moved to Cambridge?
I would have to think about it. I'm thinking maybe April, May, somewhere in that time frame.
And did you have the occasion, as part of the child custody dispute, did Christina Parcell have to go to Italy?
Yes.
And do you know the circumstances surrounding why she would have to go to Italy to get her child? Can you tell the jury what your understanding of those circumstances were?
Mr. Mello kidnapped the daughter and left the country.
Do you know about when that was? If you can't remember, it's not.
It's probably 6 months before April, whatever that works out to be.
Okay, and as a result of that, what did Christina do when Aida moved to Italy with John Mello?
She found out where he was located. She contacted her congressman and the State Department and the FBI.
And did she attempt to obtain the return of Aida back to the United States?
Yes,
How did she do that?
through the State Department. I think it was the Hague Agreement.
And did Christina actually fly over to Italy?
Yes,
Do you know how many times?
twice.
And were you assisting her and helping her throughout this process?
What do you mean?
Financially, were you helping her?
Some, but she was receiving contributions and reimbursements from those organizations that help women like that.
Women obtain the return of their children who've been
That's correct.
taken abroad.
Yes.
And so did you emotionally support her? Are you involved? Did she tell you what's going on?
Yes.
And so do you remember did Christina ever get the return of her daughter?
Yes.
Do you remember when that was?
April, May timeframe of the year.
Of 2021?
Yes.
I'm going to take you back to October 13th of 2021. Do you remember that day?
I do.
Can you tell us what you did that day, starting in the morning?
Well, she had a job interview and
She is Christina Parcell?
Yes, Christina Parcell had a job interview. Typically, when she had something critical, I would call and try to make sure she was up. She was. And then when she was driving to the interview, she called me and we talked for a while. And then she was a couple minutes from her interview, and so she hung up.
As far as you know, did she go to that interview?
Yes.
And then when she was at that interview, what did you do?
Generic things, common things around the house, had to clean up and do laundry and dishes and things like that.
And then did you ever attempt to contact Christina?
Yes.
About when did you attempt to try and contact her?
I think it's around 11 o'clock, plus or minus somewhere in there.
And so how did you do that?
By phone?
And were you successful?
No.
So as a result of your unsuccessful attempt to contact her, what'd you do?
I thought I should probably go over and see how she's doing.
And did you do that?
I did.
How did you get there?
I drove my car,
What kind of car did you drive?
Mercedes,
Is it red?
The man
Yes.
that was dressed so
When you
nice.
drove over there, where'd you park it?
in their driveway.
And when you arrived to 122 Canebrake, what did you do?
I went to the front door and rang the doorbell.
And were you able to enter?
No, she didn't answer.
So then what did you do?
I walked around the back door because frequently they'd leave the back door unlocked. And I walked into the back door.
This jury just saw the body camera of Chris Robinson. Did you see him go in the house?
See who?
Deputy Chris Robinson, the officer who you spoke to, the first person you spoke to on scene.
I may have, but I don't recall who he was because there were several people
And the
there.
door that he used, was it the door that you used to enter? Do you know what door he used?
I think they went to the front door. No, they might have gone to the back door. That's right.
And is that the door that you used to enter
Yes,
the house?
yes.
So you did enter the house?
Right. Again, I'm not sure whether it was the front door or the back door that they entered.
And so what did you do when you walked inside the house?
It was dark, quiet, and so I walked back to, down the hallway to see if she was in the bathroom or the shower, and it was all dark. And I looked on the floor, and right at the entrance of the living room and off that hallway, there were petals from like a rose. And as I looked into the room, and I saw her on her back.
And when you saw her on her back, was there a lot of blood around the room?
Yes.
What did you do?
I walked over and yelled at her and then called 911.
And when you called 911, what were you requesting?
I told them who I was and where I was, and we needed, I guess, an ambulance or and the police assistance.
At this time, on October 13th, did you know where John Nola was located?
I assumed he was in Italy.
All right. Mr. Post, I'm going to show you some envelopes. I'm going to refer you sort of back to around June of that same year, 2021. And I'm going to show you some envelopes and ask you if you recognize these envelopes. And I'm going to show you State's Exhibits 1, 2, 3, 4, 5, and 6. I'll start with Exhibit 1. I want to make sure the jury can hear me, okay?
Yes.
I'm going to stand this way. I'm going to start with Exhibit 1. And do you recognize that document?
Yes.
Okay. Tell this jury about how you came in contact with this document.
It was mailed to me.
Say it again. I think
It was mailed to me.
Okay. And is your name on it?
Yes.
And the return address is a P.O. box. Whose P.O. box is that?
It's also my P.O. box.
And when about was it mailed to you?
June 30th. June 30th.
Did you receive other envelopes as well?
Yes.
Okay. Tell this jury about how that happened.
Be a little more specific.
So tell this jury you received an envelope. What did you do once you received it? And did you receive other envelopes? Question.
I received the envelope. I opened it because it was very suspicious, with my return address. And I looked at it, and then I called my attorney.
Why did you call your attorney?
Because of the contents inside.
Can you describe the contents?
Yes, there were naked pictures of Miss Parcell. And if I remember right, there was a mailing list of which would kind of indicate that they were going to be sent also to those locations.
I'm going to show you State's Exhibit 2. Is that a similar envelope as well?
Yes.
And did you open all these envelopes?
No, I did not.
On State's Exhibit 2, what is the address that it was mailed to?
It was mailed to me, but my name was misspelled.
And then I'm going to show you State's Exhibit 3. Another envelope.
Yes.
And is it a similar envelope to the other ones that you received?
Yes.
And what is the address on that?
I'm 24. It's 25. It was my neighbor's.
So 25 is your neighbor's house.
Yes.
I'm going to show you State's Exhibit 4. Do you recognize that envelope?
Yes.
Where was that envelope?
It was sent to an establishment that I spent a lot of time with.
And what is the return address on there?
It's mine.
How did you obtain this one if it was sent to another establishment?
I had known since the very first one that others may be sent to people. And so since I knew the owner very well, I told him that he may be receiving an envelope with those dimensions. And I said, if he does, I'd appreciate a call back.
And State's Exhibit 5. Is that another envelope?
Yes.
And what is the address there?
My address.
And the return address is,
My P.O. Box,
and States Exhibit 6.
yes.
What address is that one?
It's 22, which is another neighbor.
So after you received and collected all of these envelopes, what did you do with them?
I talked to my attorney and we set up a meeting.
All right. And after you talked to your attorney and set up a meeting, what did he suggest y'all do?
That we would meet with the county investigator, we did with Mr. Bevel, and also to talk to the post office since they were sent through the mail.
And did you in fact have that meeting with law enforcement?
Yes.
And what was the purpose of that meeting?
Was to give them what we call evidence, or the things that we were sent, and ask them what we should do next.
And were you in essence filing a complaint with law enforcement for a potential crime?
I don't understand the question.
Were you going to law enforcement in an effort to give them evidence of a potential crime?
Yes.
And when you're meeting with law enforcement, you say Detective Daniel Bevel and Mike Nicholson with the Postal Inspector's Office. Did you tell them how you obtained these items?
Yes.
And did you discuss who you thought might send them?
Yes.
And who did you tell law enforcement that might send these photos or had possession of these photos?
Well, we thought we knew who, of course, was behind them, but we weren't sure who sent them because he was supposedly out of the country.
So who did you tell the detectives had possession of those photos of Christina Parcell without any clothes on?
Mr. Mello?
That's John Mello?
Yes.
And that is who she was engaging in a child custody dispute with over Ida Mello?
Yes.
Now, finally, Mr. Post,
In case, y'all.
I'm going to ask you, have you ever met Zachary Hughes?
No.
Have you ever talked to Zachary Hughes?
No.
Have you ever corresponded him with, in any way, shape, or form, through email, social media, or the like?
No.
When was the first time you knew who Zachary Hughes was?
When my attorney set a meeting to come see me, and he showed me a picture and said this person was arrested for the murder.
For the murder of Christina Parcell?
That's correct.
And a couple more questions, Mr. Post. You and Christina Parcell were engaged.
Yes,
Did you give her a diamond ring?
I did.
Was she wearing it that day on October 13th, 2021?
Yes.
And on that day, did you provide her or give her any flowers the day before or that day?
No.
Didn't give her any roses or anything like that, did you?
No.
Now we probably wish he had.
Mr. Post, did you just answer any questions that the defense counsel asked for you?
This ought to
Thank
be
you, Honor.
good. This ought to be real good.
Mr. Post, just first question, you just mentioned that you were engaged and that she was wearing the ring. Do you remember telling law enforcement on the day this happened that she wasn't wearing a ring?
No, I wouldn't say that.
Okay, you don't recall saying that?
No.
You remember, now you're saying you remember seeing her with the ring?
Yes.
Okay. You were also asked if you've been charged with a crime. It's actually 9 charges, is it not?
Correct.
Ask you about some background questions about yourself. So how old are you?
69,
What is your date of birth?
12856,
And where are you from?
Ohio.
When did you move to South Carolina?
July of, I think, 89.
What brought you to South Carolina?
Employment.
Are you married?
Was I married at the
Were you
time?
married?
Yes.
And how many times have you been married?
Twice.
Do you have any children?
No.
How were you making a living in October of 2021?
I was retired, so it was from my investments and interest.
And also from selling a business?
Yes.
Okay. And did you make a lot of money from selling the business?
I don't know what your definition of a lot of money is.
What's your definition? I mean, did you have millions of dollars?
It's absolutely relevant, Your Honor.
All right, so when did you actually meet Christina Parcell?
I met her at her father's cigar shop. Gosh, I can't, 20 years prior.
And you actually dated for a period of time back then?
Again, that's the definition of date. Yes, we went to lunch or dinner, but it was only a couple of weeks and that was it.
And why did you all break up at that time?
It just, wasn't chemistry and we both had other things to do.
All right, and then you reconnected then in about 2016, isn't that right?
That's correct.
And you began dating again at that time?
Soon after.
Had you seen her much in the years between?
No.
Had you seen her at all?
Prior 10 years, no, I didn't even hear her name.
And then you began dating at this time. Now, Parcell, Ms. Parcell had a daughter at that time, is that right?
That's correct.
You've already testified her name was Aida. Is that right?
That's correct.
And how old was Aida when they began dating?
I don't know if I defined it when I dating, but when I saw her for the first time in 2016, I think she was 3.
Okay. And she gave up custody of Aida shortly after y'all started dating?
I don't know the exact date, but she did change the custody arrangement.
And you at this time did not know Aida's father, John Mellon? Correct.
I knew of him because I was told, but no, prior to coming, no, I didn't.
Prior to meeting or getting back together with Ms. Parcell, you did not?
Correct.
know Mr. Mellon. Okay. And did you break up during the period of time between 2016 and 2021?
Yes.
How many times would you say you broke up?
I want to know what he's
I really don't know
right
many.
there.
Okay. More than 5?
Maybe not. Somewhere I never counted it.
And that was at least in part because of the turbulence that was caused by the custody battle between Ms. Parcell and John Mellon?
It was part of it because it was becoming front and center of her life, so it affected a lot.
Okay, but you would continue to get back together. There's multiple times you broke up.
Eventually, yes.
Yep. How long have you lived at 24 Rivoli Lane?
7, 8 years.
And you mentioned Ms. Parcell and Aida were living with her sister, Tina, on Canebrake Drive.
That's correct.
Okay, where did they live before that?
For an hour and
Off
13
of
minutes.
Woodruff.
Okay. And the 3 lived together there too?
Yes.
And did you live with anyone at Rivoli Lane?
I don't understand the question.
Did anyone live with you at Rivoli Lane?
No.
Lived there alone. I guess there was one exception then when Ms. Parcell moved in with you from October 20 until Aida returned?
She didn't really move in. She would stay with me because she always had a house or an apartment that was hers.
Okay. When did you and Ms. Parcell get engaged?
I honestly don't remember.
Okay. And did you remember getting engaged at least for the second time at the airport, is that right?
That's correct.
And that was when Ms. Parcell returned with Aida?
That's correct.
And there was quite a group around there when you got engaged, right?
That's correct.
Who all was there?
Friends, her parents. Some of the friends I knew, some of the friends I didn't.
Okay, and this was the Greenville-Spartanburg Airport?
That's correct.
Okay, when Ms. Parcell returned from Italy with Aida?
Yes.
You mentioned letting Ms. Parcell use your Lexus. You would help her financially in other ways as well, right?
She used my car when hers was broken or she needed to get one because she had her own car.
And you would pay her credit card bill sometimes?
Sometimes.
You actually gave her a credit card of your own?
Yes, whenever she was buying for me and buying my groceries, yes.
Okay. Do you recall being able to have power of attorney over her bank account at the Bank of Travel Trust?
I don't recall giving power of attorney.
You don't recall having her power of attorney?
I don't recall it.
Now, you had a clone of her phone as well, correct?
That's correct.
So, this phone that you had of hers would keep track of everything that was going on in her phone. In other words, it was an actual clone. You could see her incoming and outgoing emails and texts and all of that. Is that not right?
No, it wasn't an exact clone. There were certain applications that we could see. It was mainly for her bills and to make sure that she got home at night.
Okay, but you mentioned also you would use an app called Life 360 to keep track of her too, right?
Yes, and that was on my phone.
Okay, so that was on your phone. That wasn't on it. So the clone phone was for keeping track of
Both have
what
to
she's
have.
doing with her.
I don't, it might have been, but I don't remember if it was on that one. Just like I said, she had two phones at several times, hers and mine.
And what methods did you use to communicate back and forth by texting and that sort of?
You know, call, text, email.
Okay, do you remember what platform you would use to communicate?
At the end, we were using one called Signal, knowing that her future, with Mr. Mello, there was something going to happen. And so we used Signal, which we didn't use very long because it was very difficult to use.
And you mentioned that Ms. Parcell gave up custody of Ida a few months after y'all started dating,
Yes,
and she gave up custody to John Mello.
that's correct.
And then at some point, she changed her mind and decided she wanted custody, correct?
Yes.
And around how old was Ida when she did that?
When she turned over the custody,
No, when she, I think you already told us that Ida was 3 or 4, I think 3 when she gave up custody.
yes,
How old was Ida when she tried to get custody back?
I don't recall.
Was it years, months after she gave up custody?
I don't recall the time. I just remember the instances that caused her to do it.
Okay, and that was because of her contentious relationship with Mr. Mello.
Yes.
Now, when John Mello took Aida to Italy, testified somewhat about that already, but that was around October of 2020, correct?
I think so, but I'm
Does
not
that sound
sure.
right? I'm sorry, I didn't mean to talk over you. Does October 2020 sound right?
Yeah, I'd have to get a calendar and work backwards, but yeah.
And you mentioned that when she finally came back, it was in April
Yes.
of 21.
Yes.
And they were in the Canebrake house at that point?
I think they were in the apartment and then moved to the Canebrake house almost immediately.
Okay. Now, you used the term kidnap. You are aware that John Mello was exonerated for that?
Afterwards,
Right.
but not when he was there. He was found guilty by Italy, the state of Italy, and had to return her.
Okay, well, maybe we're using distinctions here, but he was found to have to give her over to Christina, but he wasn't found guilty of any crimes.
That I don't know.
He didn't go to jail.
That I don't know.
Okay. But when he came back here, you were aware that he was exonerated for taking Aida to Italy, right?
After Miss Purcell was dead, yes.
Okay, well, that has nothing to do with it. He was
Has
exonerated.
everything to do with it.
He was exonerated for having taken Aida to
Woo!
because he had custody.
No,
of
we're
Aida.
getting a little spicy.
Ask your question again.
Your objection is outside the scope of his knowledge.
This is what they were asking. So John Mello had custody of Aida when he took her to Italy.
Yes. That didn't mean she could be taken out of the country without the mother knowing.
Okay, well, you know, the court's exonerated him for that.
But you know that the Hague Agreement returned her.
Well, I'm talking about in South Carolina. So for him taking Aida to Italy, since he had custody, he was exonerated for having taken her to Italy.
Eventually, yes.
Okay. And when he took her to Italy, you and Ms. Parcell spent some time trying to find where they were by looking at Facebook and Google and things like that. Is that right?
In context of what you're saying, I don't agree with, but yes, it was quickly found where he was.
Okay. Well, you can explain the answer if you need to.
Mr. Mello likes to use Facebook, and he posted a picture of his daughter to kind of show off that he had her in Italy. In the background, there was a poster that showed where he was.
Okay. And then at that point is when Ms. Parcell took all the steps that you talked about trying to get her to go back. Correct?
Correct.
And you did mention that you helped her with that.
When I could.
And you were helping pay her legal bills. And I know you had an agreement where she was going to eventually pay you back, but you were giving her money for attorneys.
From times when she needed it because she was working.
Okay. She made 2 trips to Italy. Isn't that right?
That's correct.
And the first time she was gone a couple of weeks.
I don't recall being that long, but it was more than a week.
And Lutina, her sister, went with her the first time.
Yes.
And then the second time she went back by herself.
Correct.
And that's when she returned from with Aida. And then you proposed to her.
Yes.
Okay, now, I want to ask you a little bit about the packages. So, State's Exhibit number 1 is the one that's dated the 30th of June of 2021. And that's the first one that you received, is that right?
I think so. I just have to look at the dates, but yes, the earliest.
Okay. This was mailed to your house. And there also were some that were mailed to other locations, but intended for you. Is that right?
I don't think it was immediately, no. That was sent like a warning.
Okay. Well, that was sent first, but where was the other one sent that was intended for you?
To my neighbors and to a place that I frequented.
Okay. And that was a cigar bar called Outlands?
Yes.
The contents of that have been described, you described as photographs of Miss Parcell.
Yes.
And you said they were naked photographs, right?
Yes.
Do you recall any of the other materials that were in there?
I think there was like a potential mailing list of where else it was being sent, like a threat.
And do you recall one of the pieces of paper that was sent to you being a website purportedly from her?
I don't recall it was there, but I was shown that it was.
Okay. And it's a website labeled Escort Advertising and Discussion?
I don't know.
Did you not look at it at that time?
I don't recall, no.
Okay. Were you aware of all of this about her past when?
What are you referring to her past? It was the pictures that Mr. Mello had taken that they were using.
We're talking about the website.
Same thing on the website. I was told it was the same pictures.
That was what you were told.
That's what I was told.
Okay. Well, the website doesn't have pictures associated with it, right?
No, I don't know.
Okay. Did you read the contents of it?
No.
Lady,
Why did you not read those? Why did you not read the information?
never let anyone take pictures of you undressed unless you are willing to have it all over the internet. Because the moment they want to blackmail you, get mad at you, do something, be jerks, whatever, those pictures, don't believe them that they don't have any other copies, because you bet they have more than one copy. And once those pictures hit the internet, they can never come down. And it is also known that when some people break up and they want to get back at their significant others, men have done this where they will go to an escort site. They will create a profile for their girlfriend that she wants to be a worker or be on that website. And they will use those naked pictures they took of you and create an entire account in your name
And honey boo boo, you're screwed. Literally. Just saying.
Make sure that was in the package that was sent.
Because I knew it was a threat. He was constantly trying to separate us and get me to not assist her.
Don't ever, young girls, do not let boys or do not take pictures of yourselves. And if you are a minor and you've taken a picture of your private part and you have something to your boyfriend, you have produced and you have facilitated the production and distribution of CP. And then when your boyfriend decides to send it to his guy friends, he is now sharing CP. And all of you can go to jail for a very long time. So yes, I know what I'm talking about. And I know a lot of kids that have gone to jail because of it. Just saying. Parents, if you find images like that on your child's phone, you better get a lawyer. I've been through it with somebody. And they thought, oh, they didn't hear anything of it for months. And then all of a sudden, bam, their son was arrested for having his ex-girlfriend's pictures on his phone that she had sent him. And he had shared it with some friends of his. And both of them went to jail. Just saying. It is, people have no idea how serious this is. And it is true. Once it's out there, it doesn't come back. There's no way to expunge it from the web. So, what in the? I am really struggling here for a second, y'all. I might need to stop doing this. My thread is knotting up too much.
Nothing from the state, Your Honor.
I stabbed my
Okay, let's go. We just want to have this one remain under subpoena. Yes, sir.
No objection.
Interesting characters. I want to know why he's in jail. Why is he in jail? Does anybody know what he actually is charged with? Do we know? Any way to find out? I might see if I can do some research on him tonight. Tonight, we're taking my son over to his favorite fish restaurant for his boot day. His boot day. Yes, I can't believe my son is 25 years old today. And I'm that old. I'm pretty surprised. It went by fast, y'all. It goes by fast. I know people say all the time. They say it all the time. They used to tell me as a young mother, it goes by fast. And I'm like, no, it doesn't. Yeah, it really does.
I do.
Jocelyn McInnes. All right, Ms. McInnes, with whom are you employed?
Right now with Fetch Pet Insurance.
And what did you do back in October of 2021?
I was working at Valley Walk Animal Hospital as practice manager.
And what does a practice manager do?
Just manages day-to-day operations, hiring, firings, inventory, stuff like that.
And where is that practice located?
In Greer, South Carolina.
And on October 13th, 2021, did you have the occasion to interview Christina Parcell?
Yes, I did.
Do you know about what time she arrived and you interviewed her?
It was 8:30 that morning.
And how do you know that?
I did watch the video footage
verifying it, but I also had it on my calendar from back then to verify too.
So, yeah, so the actual interview was interviewed from inside y'all's cameras?
Yes, it was.
And you went back and reviewed that video?
Yes, I did.
And so what time did Christina Parcell arrive to the veterinary clinic?
Right around 8:30.
All right. And what was she interviewing for?
For a veterinary technician role.
And what does a vet technician do?
Basically, like what a nurse does for a doctor, just draws blood, vaccines, stuff like that.
And about what time did that interview conclude?
She left at 8:47.
That's all I have for this week.
That's a quick interview, y'all.
Just very briefly, Ms. McInnes, is that right?
Yes.
Just a couple of questions for you. Was that a full-time position that she was interviewing for?
Yes, it was.
Okay. Were you aware that she was already employed?
Yes, I was at the time.
Okay.
That was one of the questions I asked her.
Okay. Do you know why she was looking for another job?
I didn't ask her that.
Really not supposed to, I don't think.
But it was a full-time position that she was looking for.
Yes.
All right. That's all I have. Thank you, Your Honor, and she can be released from proceedings. Anything else? No, Your Honor.
We are going to stop and have a lunch break, and I'm going to ask for y'all to return at 2 o'clock. I told you I'm going to be a broken record, but just like I said yesterday, you are prohibited from watching any TV coverage of this trial, doing any kind of investigation, any research of anyone involved in this case by any means. You're not to look at any social media. I told you yesterday, if you've got notifications on your phone, hopefully you've turned those off, but please do so. And I just respectfully ask that. As I told you, I am going to randomly ask if you have had watched or seen anything during the course of this trial. Again, I remind you, it is important to the integrity of this trial, the justice and fairness to the defendant and the state that you only consider evidence which comes in through this courtroom. And again, you're not to discuss this case among yourselves until I tell you that you can do so, okay? I hope you enjoy your lunch, and I'll see you back at 2 o'clock.
Oh, let me get that stitch in. Let me move the beads so I don't knock them over. Okay, so this one. Okay, let me see if I can go back and find the next half. Part 2. What was the name of this trial? Okay, that's day 1. Part 1. I guess this is part 2, pretrial motions. I got to get it on a flat screen, a horizontal screen. I'm just not able to do it that way. Okay, so we saw part 1. Is there part 2? I'm looking for part 2, day 2.
Ms. Gorman, can you tell this jury where you reside?
117 Caneburg Drive.
I'm looking. So we're going to go to day 2. It's the only thing I can do.
leading into the backyard.
Specifically related to as a forensic technician when you were with the Greenville County Sheriff's Office?
So we respond to crime scenes within the county limits. Depending on the crime scene, we can do things such as take photographs, process for fingerprints, collect evidence, just depending on what that specific scene is.
So it's safe to say that collection of evidence on specific crime scenes is one of your primary roles?
Correct.
And then same thing would be taking pictures in accordance with that?
Yes.
Were you in that role on October 13th of 2021?
I was.
And how are you involved with the present case specifically related to the crime scene on October 13th of 2021?
I was the primary crime scene investigator for this case.
So you were tasked with processing the home at 122 Canebrake?
I was.
And in your role as a forensic technician, are you subjected to trainings and continued education for that role?
Yes, I have my bachelor's in science and forensic and investigative science. In the past, I've held certifications in bloodstain pattern analysis and fingerprint analysis, and I am currently part of a specialized unit called the Major Crime Scene Team in Albuquerque that responds to all homicides and officer-involved incidents.
Approximately how many crime scenes do you process in a given year?
I would say over 400.
So can you describe for this jury, specifically related to October 13th of 2021, what your process was on arriving at 122 Canebrake and steps you took with your specific role?
So when I arrived on scene, I met with officers and detectives on scene just to get a brief run through of what was going on. After that point, myself and officers did an initial walkthrough of the scene just to see the layout of the house and where things were located.
So when you were doing the layout of the house and going through there, did you take photographs of the outside of the house?
Yes.
And if I show those to you, would you recognize them?
I would.
Let's show defense counsel what is State's Exhibit 69 through 84. First witness was 69 through 84. Could you take your time, review those, and let me know if those are the pictures that you took of the outside of the Canebrake home?
Yes, these are the photographs that I took of the exterior.
So that was what the Canebrake home looked like when you arrived on the scene October 13th of 2021?
Yes.
Your Honor, at this time, the state would move into evidence State's Exhibit 69 through 84.
Counsel? No objection, Your Honor.
All right. 69 through 84 comes in. Ms. Ford, I'm going to go through these with you. And if you like, I have a pointer here if you need to use it. Starting with State's Exhibit 69. Okay. What is State's Exhibit 69 a picture of?
So that is a photograph of the gray Lexus that was parked in the driveway.
Were you able to identify in the course of the investigation there who was driving the gray Lexus that day?
Yes, it was the victim.
Showing you State's Exhibit 70.
That was the red Mercedes that was parked in the driveway as well.
Who was driving that vehicle?
Mr. Post.
State's Exhibit 71.
That is the front side of the residence showing the windows along the front door.
72.
That is a close-up of the front door.
73.
That is a photograph of the exterior side of the front door handle.
74.
That is the gate on the right side of the residence. If you're standing facing it from the roadway, just showing the gate into the backyard area.
So is that, are you staring at Canebrake Drive there?
Yes.
Is that the red Mercedes in the driveway?
Yes.
75.
That is the photograph of the back or side door of the residence.
And at this time, had the initial deputies already gone through the house?
Yes.
76.
That is a photograph of the backyard.
And so would this be looking to the opposite side that we were just reviewing where the driveway,
Yeah.
away from the driveway?
Yes, away from the driveway.
77.
That is a photograph of you standing at that gate that we just viewed, looking at the end of the end of the backyard.
78.
That is just showing a close-up of the creek and what you can see from the backyard.
We're going to go to State's Exhibit 80.
That is the gate on the opposite side of the house, leading into the backyard.
That's looking into the backyard.
Yes.
81.
That is just showing another close-up of the backyard along with the second-story porch.
82.
That is a photograph of the nook that is underneath the second-story porch on the back side of the house.
Now you called it a nook.
Yes.
If I'm standing on Canebrake Drive, can I see somebody under there?
No, you cannot.
And if I'm standing let me go back to State's Exhibit 78. In the backyard there, what was the collection of houses like, I'll say, with relation to the backyard of the house?
It was
Or how close in proximity were other neighbors?
They weren't that close. They were separated by both of their own backyards, including that woodsy area and a creek.
Go to State's Exhibit 83.
So that's just another close-up of that nook area.
State's Exhibit 84.
And now we've moved out into the front yard, and that's just showing a broader photograph of that gate on the left side of the house.
So from where you're standing there, taking State's Exhibit 84, could you see into that nook there that we were just reviewing?
No, you cannot.
After reviewing the outside of the house, did you thereafter go inside the house and do the same process of taking photographs and reviewing the inside the house?
Yes.
If I showed you those photographs, would you recognize them?
Yes.
Mr. Defense Counsel, what is State's Exhibit 40, let me get this right. States 38 through 62 and states 63 and 66.
What are we waiting on? Oh, that's right. I can zoom them.
So this is a close-up of those rose petals and leaves that are leading from the doorway to the sitting room from the
Hence the rose
hallway in
petal
the house.
murder trials. Okay.
State's Exhibit 45.
So that is the view of the sitting room from the hallway, just again showing those rose petals and leaves.
So that's the hallway leading towards the front door.
Yes.
State's Exhibit 43.
So this is a photograph of the hallway while standing in the living room, just showing how some of those flower petals go into the hallway, and also the discarded pair of sunglasses that was located in the hallway as well.
State's Exhibit 47.
This is a photograph from a further point in the living room, again, just showing that entryway into the sitting room in the hallway.
So inside, that is the sitting room in that room.
Correct.
Show you State's Exhibit 51.
So this is a photograph from on top of that console table sitting in the sitting room where the victim's purse had been located. And it's just showing that some of the rose petals and stems had made it onto that table.
State's Exhibit 52.
This is showing the victim's purse that I was just referencing, and showing that the rose petals were also inside of her purse.
Ms. Ford, approximately how many murder scenes have you processed?
Say close to 150.
You ever found flowers near the body?
No.
And I'm just gonna go back really quick, 52. To the location of these flowers, were there some found inside her purse?
Yes.
Inside the items on top of the table?
Yes.
It's Exhibit 53.
So that's just another vantage point from the sitting room of all of the rose petals and the leaves that were.
So
located in
she
that
could have had
doorway.
her roses. She could have bought roses or something when flowers when she came home.
Show you State's Exhibit
Arrived,
54.
the young person was there. He unalived her. She was hitting him with the
So that is a
roses.
blood stain that was located on the wall by the curtains on that front wall of the sitting room.
Were the curtains opened or
He had
closed?
them in
The
hand.
curtains were closed.
And with them. I'm sorry, I'm not talking into the mic. I hope y'all understood what I
So
said.
that is a close-up just with scale of that blood stain. That blood stain to me appears to be what we refer to as a transfer stain, meaning that an object or thing with blood on it touched a surface that did not have blood on it.
56.
That is a close-up of one of the gray sitting chairs next to that window on the front side of the sitting room, just showing the blood drops that had gotten into the surface of that chair.
57.
This shows those blood drips that I was referring to earlier near that gray chair. The reason that those are so significant is because they are farther away from that initial pooling that we saw underneath of a couch. So what that means is that the shape of those blood drops tells me they're about 80 to 90 degrees, which means that an object with blood on it was directly over that area of the floor when that blood drop was created.
You go, girl. I like you.
58. Where is this in that room?
That is over by the wall where those curtains and windows are located.
And that's the same, you're talking about the angle with which this blood was most likely transferred. That's different than what you were saying the drag marks were in the earlier exhibits.
Yes, drip stains are created by a blood drop just falling in motion from gravity, kind of if you had a nosebleed and the blood was just falling out of your nose. Because that area of the living room was so far away from the initial blood pool, that was not caused from the incident. It was most likely caused, again, like I said, from an object or a thing.
I would object to the opinion testimony that's being offered. I mean, this witness has not been offered as an expert, nor do
Wonder when that was going to happen.
techs get offered as or qualified as experts. The pictures all speak for themselves. I would object to opinion testimony being offered.
She's testified to her experience in processing hundreds of these scenes and the training she's had. While this is not being offered as expert testimony, she's speaking to her rationally based perception of the angle that these blood droplets came from. As to Mr. Moyer's concern, it's right for cross-examination if he wants to offer a contrary opinion or pry into why she derives her opinion, but she's simply speaking to her experience.
I'm going to overrule your objection. It's no.
So as I was saying, those blood drops were most likely created from an object or a thing that was in that area.
I'll show you State's Exhibit 60.
So that is showing a clump of hair suspected to be the victim's that was found in an area of blood in the sitting room.
Is that area of blood what you described as the drag marks?
Yes.
I'll show you State's Exhibit 62.
So that is a blood stain that was located on that interior side of the front door. That is once again what we refer to as a transfer stain, meaning that an object that had blood on it touched a surface that did not.
Dang it!
Finally,
That was a deep one, y'all.
So this is a photograph of that front sitting room again, where you can see the victim that's located at the end of that drag trail. And additionally, another smaller pool of blood, just signifying that wounds were still bleeding at that time.
Please don't show it. My hands are not free to stop you. Sorry, guys. Did I wake you up? I just stabbed myself real good with the needle.
So you spoke to flowers that were found at the crime scene. Did you collect those and identify those?
I did.
If I showed you pictures of those, would you recognize them?
Yes.
Could she have purchased her own flowers on the way home or whatever for celebration?
Through 93.
Could she have not purchased her own flowers and tried to beat the guy off with the flowers? What in the world is on my shirt? What are your thoughts about that, y'all? What do you think about the rose petals? How do you think they got there? To me, it looks like they were really aggressively shaken. Like maybe she was trying to fight somebody off. Bye, go watch your hubby TV. Tell hubby we said hi.
Showing you what is State's Exhibit 85 through 93. Are those photographs that you took of the flowers, or some of the photographs that you took?
Yes, they are.
This time the state moves into evidence, State's Exhibit 85 through 93.
No objection, Your Honor.
Objection 85 to 93. Comes into evidence.
I'll show you State's Exhibit 86.
So that is a those are bundled stems with a rubber band that were located underneath of that orange pillow in the living room.
So that rubber band was on those stems?
Yes.
On collection?
Yes.
So maybe I'm right.
87?
Hopefully she
That is just a
stretched the hell
different
out of it.
view of those same stems showing the leaves.
They look like they've been beaten half to death.
So that is a close-up of one of the flowers that was found on the sitting room floor.
Yeah, she was using that to fight him off.
You said wildflower.
Yes, it is a wildflower.
That's
Correct.
not a rose?
No,
She had a
Is it
mix.
90?
that is just a close-up of that same wildflower, just showing the coloring on it.
That looks like the inside of a rose to me.
I'm going to expand on that a little bit. I'm going to show you States Exhibit 93. Are those the same stem?
No,
So the stem on the right is not a rose?
no, it's a wildflower.
States Exhibit 90.
Probably had a mix.
Just another close-up of that wildflower.
I think that's the inside of a rose, but oh well.
How many of the wildflowers did you collect?
I'm not sure.
6, say several?
Yes.
In your processing of the house and looking through everything, did you find any vases,
No, I did not.
containers for flowers?
No.
And in processing that house, I assume, did you take several collections for potentially DNA testing or blood testing?
Yes.
What about fingerprint lifting?
Yes.
Now, if someone's wearing gloves, do they leave fingerprints?
No.
Typically not.
After you process the scene, what are your next steps upon leaving Cambridge?
So I secured all the evidence that I collected, and then the next day I responded to the autopsy.
Okay. Did you take some pictures of the autopsy?
I did.
I'm going to show you States Exhibit 109 and 110.
Lord willing, they'll be smart and not show it.
Search Exhibit 109 and 110. Are these two of the photographs you took at the autopsy?
Yes.
What do they show?
They're showing the decedent's left hand, which contains her engagement ring.
Your Honor, this time the state moves into evidence, States Exhibit 109 and 110.
Without objection.
Without objection, what I'm not going to let you.
What are your duties when you're at the autopsy? What kind of things are you doing there?
So at autopsies, we take additional photographs of the victim and their injuries, as well as collecting clothing, DNA swabs, otherwise known as buccal swabs, fingernail clippings, head hair samples, and pubic hair samples.
Did you collect buccal swabs and fingernail clippings from Miss Parcell?
I did.
If I showed you those collections, would you recognize them?
Yes.
I'm going to show you States Exhibit 94, 95, 96, and 97.
I'll be right back.
Showing you 94, 95, 96, and 97. Starting with 94. What is 94?
94 is the fingernail clippings from the victim's right hand.
And could you describe for the jury, when you're taking these fingernail clippings and autopsy, what is that process like?
So we have a sterile set of nail clippers that we remove from the packaging. We then place a piece of paper towel underneath of the victim's hands. I use those fingernail clippers to clip the clippings from her left hand. And then I do the same process with a different paper towel from her right hand. Those are packaged individually. And then the fingernail clippers are packaged and submitted as well.
And is that what you did here
Yes.
with both her right and her left hand with respect to 94 and 95?
Yes.
What about 96 and 97? What are those?
So these are the buccal swabs that I collected from the victim at the autopsy.
I know we've had some testimony to that effect, but what exactly did you do there to collect those?
So we take a sterile cotton swab and we swab the inside of the person's cheek to collect those cheek cells and get DNA from them.
You collected 2 of those?
I did.
All right, this time the state moves into evidence. State's exhibit 94 through 97.
No, I object to the introduction at this time, in that the chain of custody has not been established. These are fungible items, so it would not be proper until the chain is established.
Will you be putting them in later to another witness?
We'll have testimony for another witness, but she is the collector of these items.
Well, until that time, they'll just remain armed.
Understood.
Put them in.
On taking these samples, being the fingernail samples and the buccal swabs, what thereafter do you do with them?
I take them and I submit them to our property and evidence section.
Presumably for testing?
Yes.
Your Honor, I have no further questions for this witness at this time.
Any cross-examination?
Good morning, Ms. Ford. I just have a couple of questions for you.
Okay.
Just about those flowers that were talked about quite a bit during your testimony. First off, the ones that you testified are not roses. Was any determination made as to what particular species of flowers, what kind of flowers they were?
Just wildflowers.
When you say wildflowers, what exactly do you mean by that?
Things that you could just find in someone's yard.
Okay.
Just wildly grown in a field.
Okay, and that's just based on your training, or is that based on just your experience of just knowing about flowers?
Just experience about flowers, yeah.
Okay, and the way they were positioned in the house, they were just kind of randomly scattered throughout the house, right?
They were scattered, yes.
Yes, I mean, they weren't in any kind of arrangement or pattern or anything like that.
Yep, they were just scattered.
Okay, one moment, please. Oh, and I'm sorry, just to be clear, when I said scattered, we're talking about the roses and the wildflowers. They were just randomly scattered throughout the house, right?
They were scattered throughout the front sitting room area, yes.
And so they went basically out into the hallway just a little bit, but it was mainly in that area where the deceased was found. Right?
Yes, there were some in the front of the sitting room, and then there were some located near the decedent as well.
Okay. And again, not in any kind of pattern or arrangement or anything like that.
No.
That's all. Thank you.
No redirect, Your Honor. We would ask to recall this witness at a later time.
Thank you.
Thank you, Your Honor. The state calls Eric Turner.
Please stop at the end of the bench, sir. Please place your left hand on the Bible, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Please be seated. Please state your name for the record.
Eric Turner.
And Mr. What is your rank?
I'm a deputy.
Deputy?
Yes, sir.
And who do you work with?
The Greenville County Sheriff's Office.
And what do you do for the Greenville County Sheriff's Office?
I work in the school enforcement unit. I'm a school resource officer for several elementary schools in Greenville County on the east side.
And is that typically called an SRO?
It is.
Is that a
Yes,
school
sir.
resource officer?
Yes, sir.
Deputy Turner, I'm going to refer you back to October 13th, in 2021. Were you working that day?
I was.
And were you called out for 122 canebrake?
I responded out there. Yes, sir.
Can you tell this jury how you responded?
Sure. I was in between schools. I had just left one. Let me go back. At the time, I had 4 elementary schools. So I had just left a school and was actually headed to Buena Vista, right near where the scene was. And so on my way, the call came out. I was close by. I said, hey, I'll run by there and check on it. It's right there at my school. I just want to make sure there wasn't any threat towards my school. So I responded there, notified dispatch that I was on the way.
About what time did you arrive to the location?
Within, I don't know the exact time, within just a few minutes of the call coming out, I was right behind the first arriving deputy. He was already out of his car.
And once you got there, what did you do?
I stood by with
I'll be right back,
a
y'all.
gentleman later identified as Mr. Post, and spoke with him while Deputy Robinson and his trainee went inside to check the residence.
And did you learn that the victim, Christina Parcell, had a daughter?
I did.
And what was your role in regards to her daughter?
So as soon as I found out that she had a daughter, I was like, I asked, do you know how old she is, where she goes to school? And he goes, actually, she goes to Buena Vista right there. That being my school, I immediately switched roles and went to, I've got to get to the school to make sure that the school is safe. He gave me just a little bit of background, family background. So I was under the impression, hey, there may be an issue with this child. So I stood by for just a few more minutes and then I left and went to the school to make sure that everything was okay. Prior to me leaving, I actually called our front office at the school and asked, was this student there? And she said, yes, she's here. I said, do not let her leave with anybody. I want the school locked down until I get there. I'll be there in just a minute. So the school handled their protocol, did what they were supposed to do. And then I arrived and made confirmation that she was there, she was in a classroom, and she was safe.
So, so as soon as you found out about Christina Parcell's daughter, you arrived at the school.
Yes, sir.
And when you arrived there, did you talk to anybody?
Just the administration. And they confirmed back to me, hey, she's in the classroom. She's good. I'm like, let's leave her there. I don't want anything to disturb her normal day until we figure out what's going on.
And then how did y'all decide when and how Christina Parcell's daughter was going to leave?
We kind of discussed what was going on. I told them, as far as I was concerned, just let her have a regular day. There's no need to take her out of the class, and let's just let her proceed with her day, leave as normal. I spoke with a couple of the investigators, and it was determined just she can leave with a family member like she normally does. They walk them up to, it's called the front path, goes out of the front of the school, and they walk home because they live right there. And so we just allowed that to proceed on as normal, like she does every day.
Please answer any questions.
Thank you, sir.
May it please the court. Deputy Turner, you had a body worn camera that day, did you not?
I did, sir.
And did you take steps to record some of the activities that you engaged in or around canebrake on that afternoon?
I did. As soon as I got out of the car, I believe shortly after getting out, it was on.
I forgot to bring me back on. We are 2 hours, 12 minutes, 45 seconds into deliberation.
So what time is Buena Vista let out of school typically?
2:15.
Okay. And so, maybe it's a silly question, but on that day when school was let out, Ida would be coming home, is that right?
Yes, sir.
And being a school resource officer, you're familiar with issues related to children's attendance at school, is that correct?
It's really none of my business. If the attendance clerk brings it up, I may do something about it.
Deputy Turner, if a student at Buena Vista, let's say she didn't want to go home, would the law make her go home?
Objection, Your Honor, speculation.
I'm just asking if he knows that.
I mean, it has happened before, not with me.
But if a student says, I don't want to go home, I'm not going home, must the student go home?
Again, we're going to look into it, probably contact DSS, get them involved in it, our investigators, our crimes against children investigators, and figure out what's going on, why this child doesn't want to go home, stuff like that.
Any redirect?
No redirect, Your Honor.
Now a good time to take a little break.
The next witness is going to be quiet lengthy.
Okay, thank you. You may step down, sir. Thank you, sir. Okay, ladies and gentlemen, we're gonna take a morning break. Again, no discussion about this case amongst yourselves, or anyone. And again, thank you for your service. Enjoy your break.
I just said
Reconnected.
childhood.
Sorry, guys. I said I had a hair in my eye. It was driving me back crazy. I doubt that we are going to get a verdict today. I never thought we would, just FYI. What do y'all think? My son is talking very excitedly. All right, 33% said it was going to be 1 to 2 hours. That's done. So the next group is 2 to 3 hours, and that's another 33%. And then we had 25% 4 to 7. And then more than 2 days was the rest at 8%. I would venture to say it might be tomorrow. But the reason is they have a lot of paperwork.
Thank you, Your Honor. The state calls Tina Parcell.
They have a ton of paperwork. And that's why I think it's going to take longer.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
I'll close the poll down in a second.
That picture, there's Kleenex there if you need. Just push the button on top.
I'm surprised they don't have little hard candies, sugar-free or with sugar, up there for them to have, like mints or something.
Please state your name for the record.
My name is Lutina Parcell. I go by Tina.
Ms. Parcell, where do you reside?
I would prefer not to give my home address, but I do live in Greenville County.
Greenville County?
Yes.
And what is your relationship?
That is
to Christina
fair,
Parcell?
you know.
She's my younger sister.
Today.
And so, can you tell this jury a little bit about y'all's relationship going back to the 2000s and kind of taking us through that?
Sure. I mean, she was 2 years younger than me, so we were close. We were different people, but we were, close in age, close as sisters. Early 2000s, she'd gotten married for the second time. I got married for the first time. We were both living our lives. We were close, but not intertwined, I guess would be the best way to put it. And we were friends, not best friends, but we were friends. We were still, young enough where all of your childhood, younger, older sister relation, all of that baggage hadn't quite gone away yet.
And did she ever begin a relationship with John Mello?
Yes, she began dating Mr. Mello, I believe, around December of 2008.
And in 2008, where were y'all living?
2008, I lived near downtown on Glen Street, right behind Cleveland Park. My sister lived at that time, in her home in Greer with her estranged husband.
And how long did Christina Parcell and John Mello date?
They broke up, to my understanding, October of 2015. So just under.
Where'd you get that information, June?
During that time, did she have a child?
She did. She had my niece.
And when was your niece born?
June of 2012.
And so during the time in which Christina Parcell was dating John Mello,
Yeah.
What kind of relationship did y'all have?
So they
I have a
see
hard
each other,
stop
and
at
then
6:30.
just
We're going to go
based off
celebrate my
sister's
son's birthday.
papers and all of
But if
that
trial,
sort of
if
thing.
jury's still deliberating, I'll take.
December of 2008.
You won't see me, but I'll take
The
everything
kind of
with.
person I have to put things like in place in time. So December of 2009, my dad had his first stroke when he was 51, and within a year, so April or May of the next year, my sister wrote a letter cutting off contact with our whole family, saying that she had reached a new place of spiritual love and needed to only have true and pure love in her life, etc.
And so around 2009, did you see her very often?
I would see her less and less in 2009, and then beginning in 2010, she cut off contact, and we didn't see her for 4 years.
So from about 2009 to 2013?
2010 to 2014, we didn't see her for 4 years.
And did y'all have the occasion to reconnect?
My sister reached back out to my parents July of 2014. My parents found out they had a grandchild. That my niece was 2 years old. My sister began reconnecting. She reached out to me. We met for, I don't know if it was lunch or dinner, but Freddie's Custard and Easley was the first time I kind of got to see her and my niece again for the first time in 2014.
And so during that time, did you know where Christina Parcell was living?
She lived at a house at Easley on 3rd Avenue or 3rd Street. I don't remember Avenue or Street.
And is that where she brought home her daughter?
Yes, my understanding is Aida lived with her full time. The photos I've seen of that time period, she had a room, there were photos there, and they lived together.
And so she was raising your niece during that first couple of years.
Yes, and all the court documentation follows that as well.
And during that time, did you have the occasion to meet John Mello?
Not during the first few years of my niece's life because we didn't have contact. I met him maybe a time or two from 2014 to when they broke up in 2015.
Now, did they ever live together?
No, he was living with his wife at the time.
So around 2014, 2015, you and your sister sort of reconnected.
She reconnected with the whole family, correct?
And did Christina Parcell and John Miller ever engage in disputes over who had rights to their daughter?
For years, yes.
About when did that custody dispute begin?
They broke up sometime in October of 2015, and I know that she had a family court deposition in March of 2016, so almost immediately would be the best I could put it.
So about the time y'all reconnected, she was already engaged in disputes with John Mello over the custody of their daughter.
I don't believe that they were. I don't believe they had begun in 2014 when she first started reconnecting with our family, but within that next year, shortly after they broke up.
So from that point on, were you, and I don't want to say involved, but were you aware of the dispute, and did you support your sister during that time?
Well, sure. Not financially, emotionally, or, because we had been estranged for 4 years, that is, it sounds so trite. It's a big hurt. This is my baby sister, and I'm trying to find a way to put her back in my life. So even though she was going through this custody battle, I was also kind of trying to get over my hurt feelings with her. So we interacted, but we weren't, again, tied at the hip best friends at that point.
And so as time goes on, did the custody dispute continue?
For years, yes.
And did Christina Parcell begin a relationship with Brad Post?
Yes, she did.
About what time did she begin that relationship?
Again, based on documentation I've seen in her effects, within a few months of ending things with John Mello.
So around 2015?
Yes.
And so pushing up to 2020 timeframe, did your relationship with her grow closer?
Yes, in January of 2020, my mom was diagnosed
100%
with stage 4
guilty. Yeah.
lymphoma, which is scary. And you dropped something. It's scary. It's aggressive. My sister and I met for lunch, and we're making a plan for how are we going to get my mom through this. If something happens to mom, how are we going to take care of our dad? He's had multiple strokes. And during this lunch, she looked at me and said, I really want you to be a bigger part of my life and my niece's life. And so we started consciously choosing to be more involved with each other.
And at that time, where was everybody living?
So at that time, COVID, I was sheltering in place with my estranged husband in my marital home in Greer. That's awkward, but it was. My sister, again, she rented a duplex. So when she had visitation with my niece, they would do those visitations in the duplex. And then when she was not living in the duplex, she spent her time with Brad Post.
Okay. And up until about 2020, did John Mello and Christina Parcell share custody of Aida?
Early on, I hate this phrase, but it's the only one I can really know. They had a gentleman's agreement early on about custody that suddenly nobody agreed to, so they went into court. John had primary custody. My sister had visitation, standard visitation every other weekend, weeks during the summer, time on birthday and Mother's Day, at the holidays. I think it's Richards Brown. I don't remember the name.
And so,
I
during all this
surprised.
time, was there litigation
Nothing
going on
surprises
between the
me
two?
much anymore.
Yes, multiple times.
So I'm gonna take you to about
Ain't that
October
true?
of 2020.
Yes.
Did John Mello leave the country with your niece?
Yes, he emailed my sister and said we won't be here for the next visit weekend. Can't make it to the next visit weekend, something to that effect, and missed the court-ordered scheduled visitation. Didn't know where or why necessarily until shortly after when we discovered they were out of the country.
And so in October of 2020, where was Christina living? That same duplex?
So no, in again, March going to April of 2020, I'm sheltering in place with my now ex-husband. So super great. I decided I didn't want to do that, and I'm getting an apartment for myself. And my sister had just said, I want us to be closer, and her lease on that duplex was coming due in that spring of 2020. And I told her, I'm getting an apartment. I can get a 3-bedroom apartment. I clearly am a army of one and don't need a 3-bedroom, but if I got a 3-bedroom, then you could have your visit weekends with me, and we can spend time together. We have a playground, have a pool, et cetera, et cetera. So summer going into fall of 2020, my sister had her visit weekends with my niece in my apartment. And then she, again, was living for the most part with Post non-visit weekends or non-visit weeks.
And was Christina Parcell working during this time?
Yes, she was a vet tech.
Was she a full-time vet tech or a...
No, at that time she was part-time.
So in 2020, y'all discover that your niece has left the country with John Mello.
Yes.
Did this sort of set off a new set of litigation as far as the custody dispute is concerned?
Yes, she filed a rule to show cause in family court under the then agreement that she had, because they had reached an agreement. He's in violation of that agreement. Rule to show cause was, the family court equivalent of you broke the agreement. Once we determined where he was, and she had already spoken to family court, her lawyer, Greenville County, tried to reach out to SLED, tried to reach out to the FBI. Once we discovered where they were, started investigating, how do you get someone back from a foreign country?
And was she dedicated to trying to get her daughter back?
Every day.
So what did she do?
Once we've finally figured out that there is a Hague Convention for child abduction, not just war crimes, but truly for child abduction, reached out to the State Department. Her first contact was Zach, and then the second contact was a woman named April Conway. And essentially, you go through this entire application of the circumstances. You have to provide the court orders, the existing orders, that funnels up through the State Department to, they call it the Central Authority. So the U.S. Central Authority then reaches over to their counterpart in whatever the country is, because this happens for all of these countries that are a part of the convention. And then it goes down their chain. In this case, it was Italy.
And when did she start that process?
Oh, we found out where they were late October, early November. So probably November, possibly December of 2020.
And again, how did you find out that your niece was in Italy?
Her father posted a photo on Facebook of her standing in, think like a cobblestone plaza type situation. It was nighttime. There was a banner on the wall behind her that said the name Rovigo, Italy. And once we began searching down that rabbit hole, we found an online news article.
And were you having any contact with your niece at that time?
First time my sister got to speak with my niece was Christmas Day of 2020. So it had been 2.5 months.
All right. So you mentioned this Hague Convention. Did Christina continue to pursue that, and in fact, have some hearings in Italy regarding the ultimate custody of your niece?
Yeah. So when you go through this process with the Hague, I am not an expert, but this is one of those things that kind of sticks with you. Since it goes through the Central Authority, essentially that other country, their government is acting on your behalf. So the equivalent of Walt in Italy was representing my sister. It's not that she had to hire an attorney. The state or the nation of Italy was doing it because this is all international agreements and arrangements. All communication was done to her through the State Department. So they channel up, it goes over, it comes down and back and forth. The State Department let her know that a hearing had been scheduled for February of 2021 and that she could attend either virtually or in person. And she called me to let me know. I was at work. She called me and I asked her if she wanted to go and she said yes. And I asked her if she wanted me to go with her and she said yes. So I bought 2 round trip tickets that day.
And did y'all ultimately go to Italy for a hearing?
We flew out of Atlanta on Wednesday, March 10th. We arrived in Venice, Italy at the Marco Polo Airport. The things to stick with you. We arrived around noon that Thursday. Court was the morning of Friday. We flew back to the States that Sunday.
And were you successful in getting your niece back?
We were nothing at getting my niece back. There was no decision reached in that trip in March. They said they would deliberate and they would reach out with more information.
Now, when you were there, did you get to see your niece?
Did I lay eyes on her? Yes.
Did you get to speak with her?
And again, this is just based on what happened, not I know the rules of Italy. But when we were there, they said the mother has to go in, the father has to go in, and the minor child cannot go in. He brought her to court and she was not allowed to go in the courtroom and she had to stay outside of the courtroom. I couldn't go in because I wasn't a party. She was now an unattended minor in a foreign country, which is, again, not great. And they asked if I would watch her. His attorneys asked that I not speak with her. That wasn't a court order. It was just, hey, can you sit here and watch her and not say anything?
And was John Miller there as well?
Yes, he's the one that brought my niece into court for that hearing.
So did y'all ever return back to Italy again?
My sister returned to Italy. So this was in March of 2021. She, again, received notice from the State Department it felt like forever, of course, but a few weeks later, either end of March, beginning of April, there's another hearing. Again, you can attend virtually or in person. She said, I want to go in person. I asked if she wanted me to go again, and she said, no, I'll go by myself.
And so did she fly to Italy?
She did fly to Italy, give or take tax day.
And was she successful in getting the return of your niece?
At first, there was no decision reached, and they said you can leave and come back when we decide. She opted to stay, and a few days later, I can check my records for actual dates. A few days later, they let her know that they had decided to repatriate. Italy repatriated my niece to my sister. John Mello and my niece were brought to a police station. Aida was given to my sister. My sister then had to wait a week to get a replacement passport for my niece because hers had expired when they were in Italy.
While Christina was over there, did she have to hire bodyguards?
We had 2 bodyguards when we were there. We weren't allowed to, because again, COVID, we weren't allowed to take public transportation. We weren't allowed to sit down in restaurants. So we did have 2 people that were hired to both provide some protection for that day in court, but also to get us from point A to point B while we were in court. And she had the same staff were hired when she went back.
So what day did Christina and your niece return?
April 22nd of 2021.
So when they returned, to what residence did they initially go?
They started living with me full time in the apartment that we discussed. The lease on that apartment was up in the middle of May, so I'd already started making arrangements to, live somewhere rather than renew the lease on the apartment.
And so did you eventually secure another location?
I had made an offer to buy the Canebrake home December 17th of 2020. I'd already been trying to buy that house for 4 months.
And did y'all eventually move into 122 Canebrake?
We moved into 122 Canebrake on May 14th of 2021.
So when once y'all moved in, you and who all lived there?
I was in the master bedroom, a nice tan with wood trim and a bay window. My sister was across the hall in a not great yellow bedroom. My niece was down the hall from her in what came as a hot pink bedroom. And she was thrilled about that. So it was the three of us. I had chosen this home. It was large enough. There was an ensuite. You saw it in the walkthrough. The salmon colored in the back had its own full bathroom, and that was going to be where my parents could live if they needed to in the future. So it was the three of us.
So you talked about this custody dispute, let's call it before John Miller and your niece went to Italy,
Yes.
and now we're past that. During this time frame up until May of 2020, how would you describe the dispute, this custody dispute between Christina and John?
It was active until the moment she died. There were still hearings while he was in Italy. He did not return to the United States for the, I guess it was 5 months, 3 weeks that they were here, almost 6 months. He would attempt to retain counsel, or did retain counsel, though attend a hearing on his behalf. There was a hearing with regards to when could phone calls happen.
Did y'all ever fear for your safety or anybody, or your niece's safety, or your safety?
We wouldn't let her play outside by herself. It is a beautiful neighborhood, an exceedingly safe neighborhood. I mean, kids everywhere. So it's not that the neighborhood wasn't safe. We just didn't want her to be playing by herself. We didn't want her to get taken. The front window, part of why we always left it open was so we could see the front yard if she was out there.
Did John Miller ever do anything that made y'all feel unsafe?
Can you be more specific with your question with regards to place and time?
Around that time.
Around that time, I can't say if it was John Mello or not. I know that my employer received an anonymous packet full of John Mello and my sister's family court documents, and I know my sister didn't send it.
About the end of June and July, do you remember Christina and Brad Post receiving some envelopes?
Yes. I didn't. Many envelopes. It was kind of a flurry of activity as to had all of them arrived in our neighborhood, his neighborhood, the guardian, her attorney, her employer. It was.
And were you aware of the contents of those photos?
Yes.
I mean, of those envelopes?
Yes.
What were the contents of those envelopes?
If it were something that existed in South Carolina, I would call it revenge porn, but apparently that's not illegal here.
So they were
naked pictures of my sister.
I'm going to show you what's been marked as State's Exhibit 1 for identification purposes only. And I'm going to show you State's Exhibits 1A and 1B. And I'm going to ask you if you recognize these photos. And I'm sorry to have to show you these to you.
Yes, that is my sister, Christina.
And then I'm going to show you what's marked as State's Exhibit 6, envelope State's Exhibit 6, and ask you if you recognize photos 6A, B, C, D, E, and F.
Witnesses are all my sister.
So, y'all received these about June and July of 2021.
Yes.
Now, did your sister go to the police?
Yes, she went to the police. She went to a postal inspector.
In regards to the photos, how do you know that's your sister?
I'm going to try not to be. I recognize her, having known her her entire life. I recognize her haircut. I recognize her tattoos.
And can you give this jury a time frame of when those photos were taken?
Based on the length of her hair and again the state of her tattoos, I would say somewhere between 2010 and 2011.
And was that the time in which she was dating John Mello?
That's correct.
Now, so how old would Christina Parcell be?
She was born in 1980, so 2010 she would have been 30, 2011, 31.
30, 31.
Mhm.
So now I'm going to take you to, well, when did y'all move in? When did you move into the canebrake house?
May 14th of 2021.
So from then until October 13th, 2021, what was life like?
Well, it was still COVID, but it was
Sorry
less
about that, y'all. This is
COVID-y
so hard for her
than it
to
had
do.
been. So my niece joined the swim team and played her first team sport. She had friends in the neighborhood. She miraculously was promoted from 3rd to 4th grade, even though she missed 6 months of that school year.
Wow.
I worked downtown. My mother would come and babysit if Christina and I both had to work, or maybe our schedules overlapped. And I know that this sounds odd, but I would text my sister, I'm coming home. Can you chop the onions? I'm making this for dinner, or I'm going to the grocery. I mean, it was a really standard. We're living together and we have a kid and school and etc.
So I'm going to take you to October 13th, 2021. Where were you working that day?
I worked at a company called Norris Financial Group in downtown Greenville.
And we've seen video of your car leaving. Do you remember about what time you left to go to work?
That's not my car. That was a rental. But I left, give or take, 8:30 that morning.
And went to work?
I did go to work, yes.
And when did you realize that this incident happened?
I had a voicemail. My phone hadn't rang.
Okay, guys, I know I look horrible. I had to let the hair down. My head's starting to hurt again. Okay, here's the deal. From what we're understanding, and tell me if you understand it the way I do. I understand it as if they find Megan Boswell guilty of the first-degree murder, then they don't consider anything else. Well, wait, there's 5 charges. I'm going to look it up. There's too many for me to look up. Let me look it up. I'll be right back.
But I had a voicemail. It's a thing that happens sometimes. And it was from Brad Post saying there's emergency at home. Emergency at the house. You need to come home. And so I grabbed my purse, walked into the hall, told my boss, there's an emergency at the house. I'm going to go home. And made my way to the car.
And
Okay, so for those of you who are just joining us, we are watching a different trial while we are on jury watch. This one, South Carolina versus Zachary Hughes for the unaliving of his significant other, ex-significant other. I don't know. We're just learning about this one. So Megan is charged with the following. Follow. My screen isn't following me. I'm telling it to move and it's not moving. Okay, she is charged with first-degree murder, 2 counts of felony murder. So that's 3. Aggravated child abuse, that's 4. aggravated child neglect, that's 5, and abuse of a corpse, that's 6, tampering with evidence is 7, failure to report a death under suspicion, 8, unusual or unnatural circumstances, and 11 counts of false report. She's got over 20. So, plus, under each one of these counts, there's lessers. So you have first degree, then there's lessers, then 2 counts of felony murder. Then she's got a lot of counts. So that's 19. They're saying 19 charges. Megan 23 has 19 charges, including the first degree murder. So no, it's not one charge. Somebody was trying to say it was one charge. It's not. She's got a lot of charges for them to go through. So I would be surprised, but the jury's been sequestered for what? Almost 2 weeks now. They're going to do everything they can to get this done and done today.
Before you left for work, what was going on inside the household as far as Christina and your niece?
Do you mean
About what
that?
time did they
Do you mean
wake up?
that morning? Okay. I slept a little later than normal. Who knows why? And Christina had a job interview, so she was not necessarily up earlier than normal, but trying
First
to
degree in the lesser.
get the day started and out the
And you
door
have
earlier than
2
normal.
felony.
So she took Aida to school while I was drinking my morning coffee in that middle sitting room where we called it the den. That's where we spent our time. Christina came back. She had forgotten the school communication folder that you're supposed to bring back every week. She had forgotten that. So she came back to the house to get the school communication folder and stood in the doorway and said she had a hair appointment that afternoon and it was gymnastics that afternoon. And what are we going to cook for dinner? And
I see you over there,
she
June.
said, I love you. Bye.
June,
walked out
I
the door.
see you over at Mr. Recovery Addict.
And when did you first hear about this incident?
The voicemail from Post said there was an emergency. And as I was going back to my car, he called again and I went straight to voicemail. So I called him back and he said, it's her. I think she's dead. And so I got there as fast as I could.
So did you arrive back at the house?
Give or take 11:30 that morning. Yes.
Now, in regards to your house, what door do y'all namely do you namely use to enter and exit the house? And which doors do you have keys to? Explain to this jury your front and side door.
Yeah. So I made an offer December of 2020, less than a year into COVID. And what neither I nor my realtor knew, this house was under foreclosure.
Oh,
We didn't.
I have him up because you got somebody in the courtroom.
And because of COVID.
Since we're watching 2 trials, we got a verdict watch. And if he's got somebody in that courtroom, y'all, I am going to be with my eyes over here. Hold on, I want to hear something. Oops, just I don't want to hear that music. So let's go on with this. We don't have
foreclosures were under a moratorium. So it was in foreclosure, but they, not done in foreclosure. And we kept trying to complete the sale.
Okay, so they paused their
the final number that you had to have, the close number, the actual dollars you had to have.
I keep it going.
So by the time the lease was coming up,
2
in the
hours,
apartment,
2 minutes.
I have to have a place to live. I want to buy this house. So we had what's called an occupancy prior to purchase agreement, where you're essentially renting the house from the people that own it. So we had this, so I could move in before I owned the house, but it's still a rental. So we had keys for the front door only. We didn't have a key for the back door. And since I didn't own the home, I couldn't change the locks. It was a rental. So when we came and went day in, day out, we would go through that front door. That first month, more than one occasion, we would go out the back door, go play in the yard, try and come back in the back door and get locked out because we had no key for the back door. And, like I crawled in through the garage one time to get in the house. So when we were home, we
When you
would,
say back door, is that the
Sorry.
door down the side of the driveway?
yes, I would go into the sunroom, which was my office. And so when we were home, we would leave that door
This is not
open, but
Operate.
really tried
there.
to be diligent to
Got it.
lock it up at night when leaving,
Yep.
etc.
Mine is too. I'm 254 too.
Both doors when y'all
Second
are
behind me.
going to sleep at night.
Right.
Yes, and it's just part of that nighttime routine. You go, you check the doors, you turn off the lights, slide the deadbolt on the front door because it had a little slidey lock, and then go on down the hallway.
So if you were going to get out of your car in your driveway and you were coming home from work, which door would you typically use?
Always the front door, not typically, always.
Always the front door.
Yes.
So it would be normal for if Christina Parcell arrived home from a job interview, which door would you imagine she would enter into?
She could only enter the front door.
So what about
Okay, they have told the judge they want to continue to deliberate.
the front room?
So we are.
Well, as I mentioned earlier, they were kept open.
And what was that front room's meant for?
So it's a standard ranch house where you have that front long, skinny, formal living room that nobody uses unless you're the kind of person that has furniture with plastic on it, and that's not my life. So yeah, I see that. You know what I'm talking about. But that front window got a lot of light. So, and you saw in some of the photos, my
They're
sister kept her
saying
plants
we
there.
have a
We had
verdict.
2 silver chairs. The neighborhood kids and my niece would do.
Okay, they're saying we have a verdict. Unless it's fake. We're waiting. We're waiting. Looks like they're going home. Well, that's contradictory to what I'm getting. If they're going home, that's fine. We just need to know. Well, more to discuss. So they're gonna sleep on it. No verdict. I don't know what that's RA, I love you, but that song's a killer. I'm looking at the live feed. Let me switch us over to the live feed here. I'm gonna go ahead and allow those comments to roll. So they are gonna go back to the hotel for the night. Yep, you're right. You're right, Miss June. Night, night, whoever's leaving. Someone wants to know, why did they go so overboard on the charges? Ridiculous. Too many opportunities to not agree. I always feel that way. I'm like, let's keep it simple, stupid. That's my thing. Keep it simple. And they have gone way overboard on some of these charges. But at the same time, if they can get guilt on them, that's fine too, because this poor baby was 15 months old, was unalived by putting foil over her head, wrapping her in a blanket, wrapping her in a bag, and then shoving her in a trash can with her head practically bent backwards. Yeah. Well, but they need to come on and okay. Let me play this for y'all. So we all get it.
In the trial.
Volume up and on.
You may be seated. Thank you.
All right, ladies and
I
gentlemen.
can go have dinner with my son for his birthday. Yay!
I'm going to go through these admonitions again.
You've been
You're
all-
not to communicate with other jurors or anyone else regarding any subject connected with this trial. You're not to form or express any opinion about the case until it's finally submitted to you. You're to report promptly to the court any incident involving an attempt by any person to improperly influence any member of the jury or a juror's violation of the court's admonitions. You're not to read, watch, or listen to any news reports concerning the case. You're to decide this case solely on the evidence introduced in the trial. Now, when you get back to the hotel, you're not to deliberate. You only deliberate in that room. That's 11.
Where's 12? What could be
I don't think we have Ms. Rucroft.
first?
They all left you. Okay. We'll go through this one more time now that we're all back together. You're not to communicate with other jurors or anyone else regarding any subject connected with the trial. You're not to form or express an opinion about the case until you finally decide it. You're to report promptly to the court any incident involving an attempt by any person to improperly influence any jury member or a juror's violation of the court's admonitions. You're not to read, watch, or listen to any news reports concerning the case. You're to decide this case solely on the evidence introduced in the trial. All right. Yeah, you can go with the officer. Have a good evening.
I didn't expect the verdict to be guys. But I'm glad they're not going all night long because I want to go eat me some good fish. The best fish in the Texas Hill Country is at Wahoo's. And I'm not a big fish eater, but I will eat there. And it is my son's 25th. So I really, really want to be able to celebrate with him. Now, I have another hour and 30 minutes. So we're going to go back on over to this trial. We're trying to catch up. So tomorrow we'll be here. The Cemetilli trial is on holiday until next Tuesday for their state and their courts. I don't understand it, but okay. So be it. That's a long time for a jury. That's a week, y'all. That is almost a week. That is a very long time for a jury to be away from a trial. So we're going to hop back on over here. I got to get my hands right. And we're going to say goodnight to Miss Little Baby Evelyn. And then we're going to go over here and continue this until I have to leave.
Puzzles in that room.
Hello, Cindy, y'all
She
in?
had a desk where she did her schoolwork that was in front of the smaller window, but it wasn't the TV room or the family congregation eat dinner room. We did that in the den on the other side of that wall.
And so when you left that morning for work, were those blinds open or were they closed?
We always left because it was always open. Blinds and curtains were always open to get lights in for the plants. We didn't keep a light on in that room, so we weren't concerned, say at nighttime, we weren't concerned people were going to see us through that window because we didn't do anything in that room at nighttime that people would see. We were on the other wall, so it was just always open.
So when on this incident, did you talk with law enforcement about that day? Did they interview you? Did you talk to them?
Yes, I sat in Investigator Sparkman's vehicle and he said, tell me the history of your sister. And I said, how far back do you want me to go?
Did you kind of tell them what you told the jury today?
And then
More or
some,
less?
yes.
Did you tell him anybody you thought might have done this?
I said, I absolutely believe John Mello did it.
Did you know where John Mello was located?
I knew he was supposedly in Italy, but who knows?
And Ms. Parcell, have you ever met Zach Hughes?
No.
Have you ever spoken to him?
I've spoken at him, but no, never with him.
Prior to October of 13, 2021, have you ever spoken to him?
No,
Ever seen him before?
No.
Noticed him?
No.
Have you ever seen Christina Parcell talk to him?
No.
He's never been to the house?
Oh, no. I'm not while I was there. I wasn't there 24/7, but no.
Did you know her to ever have any communications with him?
I found this week when I was reviewing all of the legal files, an email John Mello sent to my sister where he CC'd.
Y'all can approach.
Thank you, Your Honor.
Have you ever known Christina Parcell to have any interaction with?
No, absolutely no interaction, no.
Ms. Parcell, you've heard testimony here today, yesterday, that there was cocaine, small bag of cocaine found in that front sitting room. Do you ever use cocaine?
No.
Did y'all keep cocaine in the house?
No.
Did you know Christina to use cocaine?
I've never seen her do cocaine.
And we've discussed this child custody dispute. Was there a guardian appointed to your niece?
Yes, so once my niece was taken and my sister filed a rule to show cause, which essentially opens up the prior action that had been settled, the court appointed a guardian ad litem to act in the best interest of my niece.
And would the guardian keep in contact with Christina Parcell?
The guardian was in very frequent contact with Christina. The guardian did home visits of my apartment, number one, because that's where I would have been returned to. She also did a home visit of Canebrake. I'd have to check paperwork to see if Christina took drug tests during that time. There were many over the years. So
You know that she was asked to take drug tests.
Oh, many times over the years.
Did you ever know Christina to use cocaine?
No.
All right, Ms. Parcell, if you'll just answer any questions.
Y'all just missed the cutest thing ever. This young boy, cowboy, skinny cowboy hat, boots, brought in a bunch of stuff that he was selling because they're raising money for a single mom. And so I gave him a little donation, but it was for Valentine's Day. It was so cute. Oh, I love it when youngsters are out there hustling, learning how to make money and take care of business. Oh, I'm so good.
I have some questions for you today. Okay. So just want to start off with a little bit about your background with Ms. Parcell. You said Christina was about 2 years younger than you, is that right?
2 years, 4 days.
2 years, 4 days. And you all began living together, the first time was at the Woods Road apartment, is that right?
No, it was young.
I had a room in my apartment designated for her to have visitation with my niece. Yes.
Okay, so y'all were living together at the
As I testified to earlier, she had visitations with my niece under my roof at that apartment, but my sister herself typically lived with us during those times.
Okay, and it
Not-
wasn't until you all moved into the Canebrake house that y'all were living together?
No, as I testified earlier, when my sister and my niece returned from Italy, April 22nd of 2021, my niece and my sister lived with me full time. The first few weeks I was still at the apartment, but we moved into Canebrake May 14th of 2021.
Okay. I want to ask you a little bit about the custody disputes that were going on. you said you did not stay very much involved in the actual disputes at the beginning of that. Isn't that right?
No, that is not actually the character of my testimony. What I said was that my sister and I were becoming closer and essentially trying to get closer after she had cut contact with me for 4 years. So that's not something you get over quickly
Sure.
or immediately.
I understand, but that kept you from staying very much in tune with exactly what was going on at that time, right?
Well, that and John Miller threatening to have me charged with kidnapping, that also had a factor in it.
Okay. And you gave up, Christina gave up custody of Aida to John Miller, didn't you?
No, I don't believe that's actually accurate, and I would like to make sure it's accurate. As I testified earlier, she and Mr. Mello had a quote unquote gentleman's agreement. And then when my sister was not receiving the visitation she thought she was due, that's when the actual court actions began, which is not in any way, shape, or form the same as giving up custody, I believe.
Okay, but John Mello had primary custody.
I believe that the agreement was written that he had custody and she had visitation, correct?
Okay. So that was in the court documents that he had custody, and she didn't dispute that. She didn't fight that, did she?
She had fought that repeatedly, trying to get custody, and then would reach an agreement with him.
But not initially. When that first document came out for where John got custody, when John Mello got custody, she did not.
Sunny day, I already have mine.
Mr. Mello had physical custody before there was a document in that original Pickens County family court action. Mr. Mello had physical custody and was not allowing my sister to have visitation, so she took him to court and then reached an agreement where he retained custody, but he was not granted custody by the court.
Okay.
It said anything. Now gotta
So
have.
they didn't have to fight it out in the courts because she allowed him to have custody, correct?
That is the agreement which she reached. That's not the same as allowing, but
So
I
she
think my
agreed.
son has eaten more than half of.
That's what an agreement is, right? Right?
she entered that agreement, yes.
Okay, thank you.
Go well with my afternoon.
And it was not until Ida was taken to Italy by John that she began trying to get full custody. Is that true?
No, they had multiple family court cases. Sometimes she initiated, sometimes he initiated, trying to modify the agreement that they had.
And it wasn't modified until after she came back, Ida came back from Italy, right?
Honestly, I would have to check the paperwork.
Okay. Now, you had met Brad Post before he started dating Christina in 2015 or 2016, correct?
He was a customer at my father's cigar store.
And that was somewhere around 2000 or 2001 when you met him?
I couldn't tell you. He was a person that sat in my father's cigar store, so I couldn't tell you the first time I noticed him as a human being, no.
Okay, you worked for him for a period of time?
No, I did not.
You don't remember?
My
no?
sister worked for him, I did not.
Your sister did, but you never worked for him?
My father?
No, did you never work for Brad Post?
So I worked for the company. It was originally called eBridge Technologies. It was owned by Braddock Cunningham. It was a software company. That is where I worked. And then Mr. Cunningham is the one who began purchasing NC&E, Network Controls and Electric. So no, I did not work for Brad Post. I worked for Brad Cunningham, who purchased NC&E from Brad Post.
Okay, so if Brad Post said that you worked for him, that would be incorrect?
Never heard him say I worked for him, so I don't know what to tell you.
Okay, I'm saying if you did, you told this department that you worked for him for a period of time, that would not be true?
No, I worked for eBridge Technologies, which again, I don't want to say subsidiary because I didn't do any of the paperwork, but eBridge Technologies, that software company, kind of merged with Network Controls and Electric once Braddock Cunningham became the person that was buying NC&E.
Okay. Christina was working part-time at as a vet tech, correct?
Correct.
When she died. And Bradley Post was helping her out financially, was he not?
I couldn't give you any type of dollar amounts, but I assume so.
Was he helping with the house at Cambridge?
No,
Okay, but you all had conversations about when you were having trouble getting the house. Did you not have conversations with Christina about getting Brad Post involved to help with that?
no, I unequivocally did not want Brad Post involved.
So you never talked to Christina about, you never sent her an email or said, this house is more expensive than I thought, so maybe Brad Post could buy it and then we could rent from him?
No. So I found out October 9th, 2021, that the people I was trying to buy the home for, again, it was in foreclosure. Foreclosures were in forbearance because of COVID, and the dollar amount, the cost to close kept going up, going up, going up. My realtor called me that Saturday and said, it's got to be this much. It was approximately 10 to 15% more than I was approved for. And I told her, I can't do that, but give me a couple days. I'm going to figure something out. And so my sister and I began texting new houses to try and buy a different house, which meant I was looking for a new house at the time my sister was murdered, which means I was not trying to have Brad Post buy canebrake so I could rent it from him.
Okay. Now, when John Mello took his daughter and Christina's daughter to Italy, he had the primary custody at the time.
That was the agreement, and also he was to allow visitation as per the agreement he reached in family court, yes.
And he was a dual citizen of
I
this
know
country.
he
and
claims to be a
Italy.
dual
Let me finish the
citizen.
question, sorry. He was a dual citizen of this country and Italy, isn't that true?
I know he claims to be a dual citizen. I cannot ascertain the truth of that statement.
And your niece became an Italian citizen while she was in Italy.
I know he claims she became an Italian citizen. I cannot ascertain the truth of that statement.
Okay, and
Show me the documents, man. You're going to make the
talked about
Show me the
having a bodyguard or someone to drive you around while you were in Italy and then back here. Brad Post was paying for that, wasn't he?
I don't know who paid. I didn't see an invoice.
So when Christina went to Italy in mid-April for the final hearing, she went alone that time, as you testified, correct?
I didn't go with her. That's correct. I understand she went alone.
And she returned to this country with Aida, right?
She returned with my niece April 22nd when they landed in Greenville.
And you met her at the airport?
Yes, I did.
The guardian ad litem was there?
Yes, she was.
Brad Post was there?
Yes, he was.
Who else was there?
Representative from Lindsey Graham's office was there. Friends of the family were there. My parents, people, my sister's neighbor from the duplex where she used to live, and her children were there.
And Brad Post was there?
As I said earlier, yes, he was there.
And he proposed to her at the airport, didn't he?
That was a choice that he made, yes.
Then there was a welcome party later that night too, same day?
No, sir. Everybody was at the airport with flowers, with balloons, with signs. My sister and my niece got packed into my car. I took them to the apartment. I picked up Indian takeout food, and we ate Indian takeout food at my home that night.
Okay, so the welcome party was what happened at the airport.
Yes.
And so just to be clear then, Aida was out of the home and gone between October the 5th of 2020 and then mid-April of 2021, correct?
My understanding is October 4th, but again, since I was not there when they left the flight, I would have to check documents.
Okay, now you all moved into the canebrake house on May the 14th of 2021, right?
That's correct. That's when the movers came on Friday the 14th.
Okay, and you testified today something that contradicts what you told Investigator Sparkman in your interview about the where everyone stayed in the house.
I was in the tan room, the master room, in the back with the bay window, right over the nook. My sister was across the hall in the yellow bedroom. My niece's bedroom was the hot pink bedroom just down the hall.
Okay, but you told Investigator Sparkman that room had been turned into a playroom and that your niece
No, the
stayed.
purple bedroom was going to be the designated playroom.
So do you remember telling Investigator Sparkman that your niece slept in the bed in the same room with Christina?
No, I'm not saying she didn't. I'm saying there were times that she would sleep there. She would sleep on the couch. She might sleep in her bed. And my understanding is she could have slept with her father as well.
And you told Investigator Sparkman, though, that you didn't have a room, that the room that was supposed to be for her was turned into a playroom and that she stayed with Christina.
I don't believe I said that she didn't have a room. It clearly had her toys in it, had her clothes in it, had her bed in it. Now, again, I just discovered that my sister was dead in my house and I was homeless, so it's entirely possible I misspoke, and for that I apologize.
That was several days later.
Woo, you go, girl. Oh my gosh,
I'm
I
sorry if I
like
misspoke.
you.
Okay.
You don't mind telling it how it is. I gotta do it, y'all. You don't like me putting my makeup on, don't
Now,
watch.
Brad Post would come by the house every day, would he not?
I can't say it was every day, depending on the mercurial relationship. Sometimes they were in a better spot. So there would be times where he wouldn't come over at all. There would be times where he would come over and have dinner.
But while they were dating and not broken up, as you told Investigator Sparkman, Brad Post would come over every day. Isn't that true?
Bless you. Again, not a matter of broken up. If they were in a good patch or a bad patch, as anybody is having a good patch or a bad patch, there would be times he'd be there every day, yes, for dinner or what have you. There would be times where he wasn't.
Now, you mentioned Ida wasn't allowed to play outside
No, I said we wouldn't let her play outside by herself.
by herself. So, and you mentioned that she had friends in the neighborhood. So would friends come over and play inside with her in the
Well, no,
house?
she would play outside with friends. We would do our best to, again, keep an eye out on her, on the friends, as any adult would do to make sure the children are going to be safe, especially with the creek nearby. So she would play in the house, outside of the house.
Okay. And her friends would play outside with her and play inside with her?
Yes.
Now, I have to ask you just a few questions about the packages that you received, that you were asked about by the solicitor. You mentioned the pictures that were in the packages, but in addition to the pictures, there were some website postings that were included, were there not?
I wasn't shown any by the solicitor.
Do you remember when you looked at the packages though, do you remember seeing the website from the escort service?
I saw that there was something textual. I didn't
go there?
lend credence to it.
No.
Again, I hate to have to ask you about this, but were you aware of that part of your sister's past?
I was aware that allegations had been made in family court, just like there had been allegations made I was going to try and kidnap my niece. So I didn't lend credence to them.
Are you aware that she gave a deposition in which she did give credence to those allegations?
Objection, Your Honor. Sustained.
You're going a bit too far, dude. You're going a little too far.
So after the death of your sister, Christina, where was Ida?
I'm sorry, could you clarify the question?
After your sister died, where was your niece?
I would also ask you to rephrase that question to be accurate.
Okay, who did your niece live with?
So after my sister was murdered, what is the question for that?
Where did your niece live?
The guardian ad litem, after my sister was murdered, got an ex parte emergency placement with me. My niece and I stayed with friends, and that's where we went.
All right, and then what happened with Aida on October the 19th of 2021?
She was put into foster care.
Okay, and what time of day was it?
It was at night.
Okay, and
Why would
Christine
you
got
in
it?
foster
Yes.
care? That's
About what time
interesting.
at night?
It was approximately 10:30 at night.
Okay. How long were the police at the house on that day?
I don't know, maybe an hour, less.
And she was taken into emergency protective custody at that time?
Yes.
Why?
And who got custody of Aida?
Would you clarify the question, please?
Where does Aida live now?
Oh, I've reached an agreement with Mr. Mello right now.
Okay, so you gave up custody to allow
I
John Mello?
never had custody, but
You dropped your petition to try to get custody.
I did not drop a petition. I reached an agreement with Mr. Mello,
Okay.
and he has custody.
Okay, you never had custody.
Wow.
I had ex parte custody briefly.
Okay, and then after Ida was taken out of the home, shortly thereafter, she went to
This
live
is
with John
getting
Mello, and she still
spicy,
lives with John
y'all.
Mello, right?
She was not with John Mello for the first almost year and a half after her mother's death, almost 2 years. She was in foster care, and then she was in third-party placement. He did not receive custody of her until August of 2023.
Okay, and she remains with him.
To the best of my knowledge, yes.
And John Mello was exonerated of the charges of taking Aida to Italy. Is that right?
I believe what you're looking for is a directed verdict of not guilty, not actually exonerated by a jury. Yes.
So a judge threw it out, basically.
A judge said South Carolina state law says a non-custodial parent has no rights to their child. Yes, that is correct.
So a judge threw it out. One moment.
Y'all, I like her. She doesn't mince words, I tell you. Y'all, she's good. Real good. I would like to have her as my sister. Actually, my sister would have been just like her. Sister-in-law, my gosh, she would have chewed him up and spit him out before he knew what hit him. Sorry, y'all, I'm putting makeup on, but I got to look good for my son's birthday. I can't go around looking all ragged. My hair looks ragged. Yeah, I know. He's looking to try and find something to hang on her, and he can't. And I just love that.
That's all the questions we have. Thank you. Just briefly, Your Honor. After the murder of your sister,
Cross-examination.
where did where did your niece go?
Are you talking short term or long term? Again, she was ex parte emergency placed in my care. She was removed from my care and put in foster care for 2 months. After that, she was placed with Allison and Lamar Sutherland from December of 2021 until December of 2022, where she was then placed
horrible.
with her half sister, Isabella Mello, John Mello's eldest child. She was there until August of 2023. And then in August of 2023, when I reached an agreement with Mr. Mello, where I had visitation and my niece was returned to his custody.
And have you seen your niece?
I've not seen my niece since August of 2024.
And do you have rights to see her?
Horrible. My gosh. August of 2024?
We currently have active family court action.
Just the makeup approved.
So you and John Mello are now in a family court action over the custody or access to your niece.
There is a new action, and the agreement that we reached is currently being appealed in South Carolina State Court of Appeals.
Fighting it.
Any recross?
No recross, Your Honor. We would just ask that the witness remain under subpoena. Thank you.
Oh, dang it. Poor woman. Y'all know what that means. She's still under her subpoena, which means she can't do anything. She's still under subpoena. That's horrible. That's a horrible place to be. Well, I'm out of hairspray. Okay, do I look decent for my boy tonight? Wow. So what do y'all think about that? Okay, let's zoom. Go through the break. Looks like we got oh, that guy's going to be a short witness.
Again.
Oh, look how he's dressed. Y'all, look how he's dressed.
Currently, I'm a photographer.
Mr. Menegon, do you reside in Greenville County?
Yes, sir.
And where do you live?
Doe Street.
And what do you do for a living?
Currently, I'm a photographer.
And how long have you been doing that?
Since I was 6 years old.
Back in 2020, 2021, were you working for John Mello?
Yes, sir.
And what did you do for John Mello?
I was helping him clean his house while he was out of town.
Okay. And how long did you do that?
On and off for several months.
And what about October of 2020 through 2021, was John Mello living in the United States during that time?
I believe so, but I'm not entirely sure because I didn't keep up with all his movements because I was at the time working 2 jobs and I had to keep track of everything all at once.
Well, how did y'all communicate?
Text messages or video chats.
And so he would text you and ask you to do things?
That's when he worked when I was telling you, sir.
Okay. And what kind of things would he ask?
I work cleaning up. She was moving back to Italy. He was helping me clean his house up so he could get ready for sale.
And what about, and how would he pay you?
Cash.
And where was this location?
It was on Blake Street.
Now, back in 2020, 2021, did you meet Zach Hughes?
I met him while John was in Italy. And I did a little work around the house with Zach. That's about all I did with him.
So how did you meet Zach?
Through John.
Through John, and then did you and Zach work together?
On and off throughout a couple of days, yes, sir.
And where would y'all work together at?
At the house.
At the Blake Street house?
Yes, sir.
And how long did you do that with Zach?
About 2 weeks, so everything was done. We were doing mostly outside work, a little bit inside, cleaning up around the house and inside.
And then after October 13th, 2021, did you ever talk with investigators?
I was pulled over.
I did
I
too.
will get off the bus. I was stopped by 2 investigators at the vape store on Lawrence Road, taken back to the county. That when I was there, questioned if I had any involvement in the crime that I did not know I committed at the time.
And was that Detective Sparkman and Master Deputy Wolf? Do you recognize
Yes,
them?
sir.
And what did you tell them?
I had no idea what the crime was committed. I willingly gave them my phone to go through it so they could check everything. I gave them all the access codes, everything. So I had no.
Oh, you had a
Yes, sir.
lawyer, boo.
And what about, did you voluntarily give them your DNA? Did they swab your mouth?
I don't recall.
Oh my God, you did all that without a lawyer?
Did they ask you about any other associates that John Mello may have?
No, sir. Not from my recollection.
Well, did you not tell them about Zach Hughes?
I knew Zach Hughes, but that's to the point where I only knew Zach Hughes because of John Mello. I didn't know him before that or during the fact, after the fact.
No, but did you tell these investigators?
That I worked with Zach Hughes, yes, sir.
You told them, the investigators, that you worked with Zach Hughes?
Briefly, not for a long period of time.
Did you tell them that you knew Zach Hughes through John Mello?
I would object to leaving.
What did you tell them about
I only knew Zach
John Mello and
Hughes.
Zach Hughes?
I only know John Mello. I knew John Mello for years. I knew Zach Hughes for a brief period of time. This whole situation, I had no idea about the murder, none of that stuff.
Absolutely. But did you tell investigators?
I only knew Mello. I only knew Zach Hughes through John Mello briefly. After we stopped working together, that's the last time I talked to him.
Thank you, Mr. Nagle.
Just to make sure I understand this, you knew Zach for just a total of about 2 weeks, is that right?
Yes, sir. He's a good man, in my opinion. I know that's off record.
They got 2 mics on that thing. That's why we're getting a good recording. They got their own feed. Oh my gosh, what did he do to? Oh, that's why that was. I was like, what is that big? You know me. I notice everything. He's like, I know nothing. I don't want to know nothing. I don't want to be here. I'm gone. Thank you very much.
You're on the state calls Master Deputy Blake Wolf.
You guys, if anybody wants your DNA, if anybody wants to dump your phone onto a hard drive or do a Cellbrite data, do not do so without an attorney, even if you're innocent, because you don't know what they have and what's going on that could easily be switched around. Don't ever do that without a subpoena, a warrant, excuse me, warrant. Get a warrant. It needs to become your vocabulary words. Warrant.
Right, Master Deputy Wolf. Who do you work for?
The Greenville County Sheriff's Office.
And how long have you been working with them?
I began working with the Greenville County Sheriff's Office in 2019. Before that, I was employed by the Greenville County Department of Public Safety for 7 years.
And what do you currently do for the Greenville County Sheriff's Office?
I'm a master deputy assigned to Bravo Platoon.
Were you ever in homicide?
Yes, sir.
No.
A little over 3 years.
Did you get involved in this case back in October 13th of 2021?
Yes, sir, I did.
Tell the story how you got involved in this case.
I was asked to co-lead this case with Investigator Sparkman on October 15th. When Miss Parcell was murdered, I was involved in another case. We concluded that case on the 14th, and then I was asked to assist with this case on the 15th.
So on the 15th, did you head out to the scene?
No, sir.
What did you do on the 15th?
So the first thing I was asked to do is a Google geofence search warrant for the location where Miss Parcell was murdered.
And what is a Google geofence?
So if you have any Google apps on your cell phone and allow them to store your location data, we can find out, we can get access to that data through Google. So when we have a location where a murder occurred, we can send them a search warrant for that location, a specific radius around that location for a time frame. And if any devices were in that radius, they will let us know. But that only applies to people who allow them to track their location data.
Did you recover anything of significance from those efforts?
No, sir.
So what else did you start doing involved in this?
Turn off your phone.
On October 19th and the 20th, I went back.
This is what's bad about watching all this. If you're going to alive somebody, first of all, put your phone in airplane mode off and on for a week before. And then when you get ready to go do it, you put it in airplane mode before you leave your home because you set the pattern up weeks before. And then go do the unaliving and then get home and turn it back on. I'm not trying to be mean. I am being facetious, but man, I can't believe how stupid some of these people are.
Back out to the Canebrake neighborhood and continued canvassing the area
Oh,
for potential witnesses
the world,
and additional
everything you
security
do.
footage.
We heard Master Deputy Stokes talk about canvassing this neighborhood. Were you doing sort of the same thing?
Yes, sir.
Did y'all do it 2 separate times?
Yes, sir.
Why is that?
People were at home. People come and go. Her murder happened earlier in the day. People could have been at work. So we go at, usually more than once at different times just to try to catch people when they're at home.
And in doing so, did you talk with Donna Gorman?
Yes, sir, I did.
About when did you talk with her?
That'd be the afternoon of October 20th.
And at that time, had y'all obtained Ring cameras and video footage related to this case?
Yes, sir, we had.
And did you show her a copy of the individual that was on a bike at that time?
No, I did not.
Did anybody else speak with Donna Gorman?
Investigator Riley Stokes.
Do you know when he spoke with her?
The day of Miss Parcell's murder.
All right. About when did you obtain video footage of a suspect leaving on a bicycle?
October 14th, I believe.
All right. So after you continued to canvass the neighborhood, what did you do?
I made contact with Miss Gorman and spoke with her.
And then after that, what did you do?
After that, it was on October 22nd that myself and Investigator Sparkman learned that Michael Manigault is somebody that was familiar with John Mello, and it was suggested that we speak with him.
Did you, in fact, try to go and locate Michael Manigault?
Yes, sir.
All right. And where did you locate him?
So we were told that he rides the Green Link buses. So we went around to some of their bus stops and we located him getting off a bus on Lawrence Road.
And did you speak with him?
Yes, sir, we did.
Was that the gentleman who just testified?
Yes, sir, it was.
And did you have the occasion to obtain a DNA sample from him?
Yes, sir. He gave consent.
And where did you take that sample?
It was in the CID interview room in the homicide office.
Did y'all carry him down there, or did he meet y'all there?
No, he doesn't have a vehicle, so he rode in Investigator Sparkman's SUV.
And down there, did you take a buccal swab sample?
Yes, sir.
All right, I'm going to show you what's been marked as State's Exhibit 111. Ask if you recognize that.
Yes, sir.
And what is that?
This is the packaging for the buccal swab that I collected from Mr. Manigault.
All right. And you like to open it?
Yes.
See what's inside of it. And inside State's Exhibit 11.
Yes, sir. This is the buccal swab I collected from Mr. Manigault, 2 of them.
Now, what did you do with those buccal swabs?
I placed them into our property and evidence room.
Now, after you spoke with Mr. Manigault, what did you do?
I began researching Zachary Hughes.
And so how would you go about doing that?
So I started, I just did a basic Google search of Zachary Hughes, Greenville, South Carolina.
And what'd you find?
I found,
May we approach? Sure.
What are they? Oh, yeah, I'm on. Thought for a minute I couldn't quite. Let me see. I'm going to zoom this a little bit.
search warrants for 200 Tyndall Avenue, Mr. Hughes's truck, his DNA, and his cell phone.
Now, did you, after talking with Mr. Manigault and your independent research, did you learn where John Mello lived or had a house at the time?
Yes, sir.
And where is that?
So he has a house here in Greenville in 12 Blake Street.
And did you also look into the location of Mr. Mello at this particular time?
Yes, sir.
And were you able to confirm where he wasn't?
Yes. We obviously had to consider him as a potential suspect. We were told at the beginning he was potentially in Italy, so we had to confirm that.
Were you able to confirm that?
Yes, sir.
So you went and got a search warrant for 200 Tyndall.
Yes, sir.
Did y'all go out to 200 Tyndall?
Yes, sir, we did.
And did you execute a search warrant on that house?
Yes, sir, we did.
All right. Tell this jury how that occurred.
So we started by meeting at a predetermined location a few miles from the address, and we had a deputy in a unmarked vehicle drive by the house to make sure Mr. Hughes was going to be there. Mr. Hughes was actually leaving the driveway at that time, so we waited at our predetermined location until he returned. Once he returned, we went to the house to execute the search warrant.
And did you learn who, now, did the defendant own this house?
No, sir.
Did you discover or learn who the owners of this house were?
Yes, sir.
And who was that?
Jeanette and Marshall Lynn.
So how many individuals arrived on which day was this?
This would have been October 22nd.
So October 22nd.
Yes, sir.
So about 9 days after the murder.
Yes, sir.
So tell us what happened when y'all arrived.
So when we arrived, we sent deputies to the front of the house and then to the back of the house. Their driveway is located behind the house. You have to go down a side street to get to it. And I was one of the deputies that went to the back of the house. I parked directly behind Mr. Hughes's Ford Ranger. When we exited our vehicles, he was standing inside the house right in front of a double French door. When I first observed him, he already had his hands up. So,
And did he have a cell phone?
yes, sir, he did.
Where was the cell phone?
It was in his hand.
And did you approach him or did he come out?
No, we called him out to us. Yes, sir.
And what did he do when you called him out?
He complied.
And what did he do with the cell phone?
He put it down on the table he was standing beside, just almost directly inside the French doors.
Did you secure that cell phone?
Yes, sir.
How did you do that?
It was collected by another deputy and then transported to be downloaded.
And where did they take that cell phone from?
The kitchen table. Yes, sir.
I'm going to show you what's marked as State's Exhibit 112. So you can recognize this.
Yes, sir. This is the cell phone that we collected that belonged to Mr. Hughes.
Your Honor, State moves Exhibit 112 into evidence.
No objection, Your Honor.
X, 112, come to there.
So, I'm going to show you State's Exhibits 116, 117, and 118. Ask if you recognize this.
Yes, sir. These are photos of 200 Tyndall Avenue.
Your Honor, State moves 116, 117, 118 into evidence.
No objection.
116, 117, and 118, and then States.
So, we'll show you State's Exhibit 117. What is that?
That is the front door if you're on Tyndall Avenue and you're facing the front of their house.
And was that where Zach Hughes was standing?
No, sir.
I'll show you State's Exhibit 116. What about that?
That is the back side of their residence that leads to the area where we were parked.
And where was Mr. Hughes standing when you?
You can kind of see the French doors through the bushes there, but he was standing there. Yes, sir.
All right. So did y'all effectuate the search warrant?
Yes, sir.
And did you? So what at this point? What is important to your investigation?
So at this point, we knew Miss Parcell was killed with a sharp force object. So we're looking for any type of knife, screwdriver, anything of those means, clothing, book bag, a bicycle, things like that.
And did y'all search the house looking for those items?
Yes, sir, we did.
What about who was there, who was living there during the time of the murder?
Mr. Hughes was living at the residence. I assume the Winds.
Were they there on October 13th?
No.
How do you know that?
When we were able to access Mr. Hughes' cell phone, he was receiving pictures from the Winds while they were in Europe.
And did you talk to the Winds when y'all were executing the search warrant?
Investigator Sparkman and I did, yes.
Were they compliant?
Yes, sir.
In terms of looking for a bike, did y'all locate one?
Yes, sir, we did.
I'm going to show you what's marked as State's Exhibits 119 through 125. I'm going to ask you to look at States Exhibits 119 through 125 and ask you if you recognize those.
For those of you who are watching,
Yes, sir. I recognize these
I
photos.
I know anything about it. This wasn't even on my bingo card. But another
I apologize. I'm going to have to backtrack 2 seconds. Forgot one of my
body was found
exhibits.
house
But I'm going to show you
with a bunch of rose petals
what's been marked as States Exhibit.
and flowers, and she used
I
them.
need a number.
Perpetrator with the flowers, they were everywhere.
I'm going to show you States Exhibit 132. Do you recognize this?
Yes, sir.
What is it?
So that is a photo of Mr. Hughes's vehicle with the bike in the bed of the truck on the day of Miss Parcells' murder. And then that is just a Google image of the Buncombe and Rutherford area where the camera is placed.
State moves 132 into evidence.
Okay. 32 comes into evidence.
Now back to 210. Did y'all focus on the garage at some point?
Yes, sir, we did.
I'm going to show you States Exhibit 119. Is that the garage?
Yes, sir.
Are these in evidence? I'm not sure.
Oh.
He was getting ready to.
Oh, okay. I'm sorry. I got sidetracked. All right.
So 119 through 125.
119 to 125.
Defense position. No objection. Okay.
Thank you, Your Honor.
Thank you. We like a clean record.
I understand. Thank you.
I got gifted a
A lot of
membership.
exhibits, it gets
I
confusing.
never get those.
All right. I'll show you States Exhibit 119. And you said that's the garage?
Yes, sir.
Did y'all enter inside the garage?
Yes, sir, we did.
All right.
I drink
I'll
it.
show you States Exhibit 120. And what'd you find inside?
We found several bicycles inside the garage.
Okay. Were some bikes, well, explain the different bikes that you found inside.
So there's some bikes, as you can see to the upper left of this vehicle that's, mounted on the wall. Several on the ground as well near that vehicle that were just dirty, dusty, look like they've just been sitting in a garage for a long period of time. They're not used regularly. And then to the right of that vehicle, you can see there's a bike sitting upside down on its handlebars and seat. That's a black bike that was very similar to the other two images we had. And it was pristine condition, perfectly clean.
All right. So I'm going to show you States Exhibits 121. What are the bikes on the left there? Or in this little?
Those are just some of the other bikes, the dirtier bikes that we found in their garage.
Did those bikes look like they had been ridden?
No, sir. Some of them had cobwebs on them.
All right. And I'm going to show you States Exhibit 123.
Yes, sir. That is the black bike that I mentioned earlier that was sitting upside down and was just very, very clean.
When you say very, very clean, what do you mean?
So compared to everything else in this garage, it's just a dirty, dusty garage. Things sit there and collect dust and dirt. And this bike looked like it just rolled off the showroom floor.
to show you what's marked as State's Exhibit 133. You recognize this?
Yes, sir, I do.
What is this?
This is the bike that was seized from the garage at 200 Tyndall.
Statement is 133 into evidence.
No objection. No objection, 133 comes in.
Now, did you do any comparison with this bike and the other photos?
Yes, sir.
And what did you conclude?
There's a lot of similarities, such as the frame of the bike, the shape of the handlebars, the placement of the brakes.
And you compared it to the photos from the Ring cameras?
Yes, sir.
So once y'all concluded the search of 200 Tyndall, what did you do next?
The Ford Ranger was taken back to the crime scene unit's office, so I responded there while a forensic technician processed the vehicle.
And then once you concluded that search warrant, were you able to locate another location that may be important in this case?
Yes, sir.
Tell us about that.
Through phone location, we located a residence on Indian Flats Trail in Marietta that was also owned by Jeanette Wynn.
And did y'all in fact go up to Indian Flats Trail?
Yes, sir, we did.
All right. And did y'all get a search warrant for that?
Yes, sir.
And when did you get that search warrant?
It was in April of 2023.
Why did it take so long?
The location data from his cell phone, we did not have his password, so the initial downloads were only partials.
So when you obtained information that Zach Hughes might have been at that location, you obtained a search warrant?
Yes, sir.
So where is Indian Flats?
It's in the northern area of Greenville County.
I'm sorry.
And so how long do you think drive-wise would it take to get there?
About an hour.
All right. So when did you go up there to serve a search warrant?
It was in April of 23, I believe, April 14th.
When we are watching the road, I don't know.
And who went with you?
Most of the homicide unit.
Most of the homicide unit?
Yes, sir.
And what were you looking for?
So at this point, we still had not recovered a murder weapon or clothing that Mr. Hughes or the suspect was wearing at the time of the murder.
I'm sure I missed a lot, but I'll go back and watch. Oh, I'm streaming on multiple media formats. Somebody asked for me to show my, I can't. Not connected.
All right, Master Deputy Wolf, I'm going to show you 130, States Exhibits 134 through 139. Ask if you recognize those.
Yes, sir, I do. These are photos of the Windsor residents on Indian Flat Trail.
Your state moves 134 through 139.
No objection.
No objection.
All right, I'm going to show you State's Exhibit 134. What is that?
That is the front of their residence there. And then on the tree on the right side, you can see a trail or deer camera.
Is that what you're referring to right there?
Yes, sir.
Now, as far as location or seclusion related to this house, how would you, where would you compare this house?
This is in the middle of the woods on a mountain. You could walk around naked and there's nobody to see you.
So there's no neighbors near you?
No.
Nobody?
Nobody.
Now, did y'all walk all around this house and
Yes, sir.
look at different locations? I'm going to show you State's Exhibit 137.
Okay,
What
guys,
is that?
somebody asked to see my setup.
That's a fire pit or burn pit there on their property.
I guess what you can do there is burn things.
Yes, sir.
And then I'm going to show you State's Exhibit 139.
Right over here.
That is just one of their closets that was full of cleaning materials.
Now, did y'all search the entire house
Yes, sir, we did.
and the surrounding areas?
Yes, sir.
How deep did y'all go into the woods?
Pretty good bit.
Y'all ever locate anything?
No, sir.
What about that trail camera?
That was seized under the search warrant, and then I obtained another search warrant for the SD card contained within it.
So what is a trail camera? Do you know?
Yes, sir. Most people just use them to take pictures of animals. Some people that hunt put them up in the woods to see, what's in that area. Most of them are motion activated.
Did you seize that trail camera?
Yes, sir.
And what did you do with it after you seized it?
I took it back to our office.
And were you able to look at any photos on the trail camera?
Yes, sir.
How do you do that?
So the camera contained an SD card. I got a separate search warrant to remove the photos or search the SD card. After that, you just plug that SD card into any SD card reader and all the pictures are there.
And were you able to look at any photos on this trail camera?
Yes, sir, I was.
I'm going to show you State's Exhibit 140. Ask if you recognize it.
Yes, sir. This is the trail camera we seized from that tree on Indian Flats Trail in Marietta.
State moves Exhibit 140.
No objection.
No objection.
And you were able to locate some photos on that trail camera?
Yes, sir.
All right. What were those photos of?
Zachary Hughes.
I'm going to show you State's Exhibits 141 through 145. Ask if you recognize those.
Yes, sir. These are photos of Mr. Hughes that were recovered from that trail camera.
State moves 141 through 145.
No objection.
No objection. 145.
So I'm gonna show you State's Exhibit 145. What is that?
That's a photo of Mr. Hughes,
And what is the date of that photo?
October 11th,
About what time?
a little after 10 a.m.
Was that 2 days before the murder?
Yes, sir.
Anything significant on here?
Yes, sir. The hoodie or jacket that he is wearing is significant.
Why is that?
So you can see the outside is black. We have the individual on the bicycle riding away on a black.
No way. We broke 2,800 viewers. Woohoo! We now have 2,804, which means I'm only 96 away from my 3,000 by the end of the month. Yay! Y'all are amazing. Oh, all right. Because of that, everybody who's commented today gets 3 extra. Forget it. We'll do 10 extra entries at the end of the month. Y'all don't forget, you got to also type the word I liked. Like the live, click the little thumbs up, go in comments and type ILIKED to be in today's entry. We only have 12 of y'all. Come on, guys, to be entered into the end of the month drawing for a $50 gift card. Come on. Yeah, whatever gift card you want, $50. I give the good.
But you can also tell the top being folded out. The inside is a grayish color.
Yeah,
The person who entered her house was wearing a gray jacket.
Well, I have literally 15 minutes before I'm out of here.
I'm going to show you State's Exhibit 105. Is this the photo that you're referring to?
Yes, sir, it is.
And is this what is this photo?
It's a photo of a person entering her house shortly before she was killed.
And what color is the sweatshirt?
Gray.
On the screen.
I'm going to show you State's Exhibit 141. What kind of haircut does Mr. Hughes have at that time?
I don't know what you would call it. It's shaved on the side with looks like a long ponytail in the back.
And what arm, what left or right arm is he carrying something?
Left.
Unless the image is converted like in the Canton, it's going to be the left arm.
And then State's Exhibits 142. Is that
Another picture of Mr. Hughes.
and again, this is on what day?
The same day, October 11th.
And then finally, State's Exhibit 144.
So zoomed in picture of Mr. Hughes on the same day.
So that would be what Mr. Hughes looked like on October 11th of 2021.
Yes, sir.
Just a couple more questions, Master Deputy. Approximately how far from that mountain house to the canebrake location would it take to drive?
I believe a little over an hour.
So how many flock photos did you locate of Zach Hughes's car when you did the search?
55.
Right. And of all those photos, how many did you find his car with a bike in the back?
Just one.
And what date was that?
October 13th of 2021.
Thank you.
Program. It has to look just like that or it won't take it. It's not me, it's the program. You know how many people problem
You testified that one of the reasons why you thought that the other bikes in the Wynn garage had not been ridden was you saw cobwebs on them, right?
Yes, sir.
What if anything did happen?
I don't see any cobwebs on this bike. Have you been riding this bike?
No.
Did you ride this bike over from the P&E?
No, sir.
Okay. You talked about cleaning supplies. Do you live in a house or an apartment?
A house.
Do you have cleaning supplies in your house?
Yes, sir.
Do you have them in a closet?
In a closet under sinks.
You talked about, based on your investigation, you realized that John Mello was in Italy. Isn't it true he was in Italy and with Aida from October of 2020 until April of 2021? Isn't that true?
And to the best of my knowledge, yes, sir.
You said a word, I want to make sure I understand. You said that you could be at the Wynn Mountain House and you could be what and nobody could see?
You could walk around naked.
Okay. Talked about, can I see your house?
Okay, when he's done, we're going to stop it here. I may come live after dinner and take off today. We'll see how long.
Let me show you States Exhibit 144.
You're,
Take a look at this.
yeah, we got Kurt.
Yes, sir.
Deputy Wolf, isn't it true in 144, that picture shows a person who's clean shaven?
It's hard to tell. There's a bit of a shadow in the neck.
Can you see a beard on that man?
No.
For those who don't
When you
know,
went to 200 Signal,
Harper
to execute that search warrant,
main open after
did you go by yourself?
the crash.
No, sir.
There were numerous police officers on scene, isn't that right?
Yes.
And some of those police officers were armed, is that right?
And are alive.
They're police officers, everyone's armed.
And you talked about how the winds complied that day, is that true?
Yes, sir.
Isn't it true, my client, Mr. Hughes, complied, didn't he, that day?
Yes, sir, we did.
So you testified in 2021, you were working in homicide, is that correct?
I was up there for a brief period of time to assist them. Yes, sir.
And you said you're back on the road now in Bravo platoon?
Yes, sir.
Are you a supervisor in Bravo platoon?
I'm a master deputy. I have several deputy twos that work under me as supervisor. Yes.
Okay. And is there a sergeant over that platoon as well?
There is.
So how long, so I need to be clear, were you ever assigned to homicide?
Yes.
How long were you there?
3 years.
And now you're back on the road, is that right?
Yes, sir.
You heard, were you in this courtroom when Deputy Riley Stokes testified?
Yes, sir.
And you heard his testimony about the videos that were obtained from residences in Canebrake. Is that right?
Yes, sir.
Isn't it true? And I want to.
Okay. We're going to stop you because I got to get, so I got to get up. Sensei, come here. Come on. Let's go. Is it time to go home? Okay, off. Thank you. Come on, move. Pupper says it's time to go home. It's time to go home. Okay, so what we're going to do is we're going to be back here tomorrow morning. I'm going to do 8 o'clock because there's no way. Would y'all be okay if I came in at 9? Because the early trial is actually in jury verdict. So I'll come in at 9. We'll start at 9. We will pick up here. I'll leave this set where it is. Let's go ahead and do the giveaway because that's important. It's important. Use smart. Was it? Use kind. Use smart. Use important. Oh my gosh, June! Welcome, love. Let me screenshot that so I'll remember to add it in. Thank you so much, June. You've been fabulous. Even there, you were kind of cheating over there. I knows what you was a doing. I knows exactly what you was a doing. That's okay. I watch him too. Don't worry about it. Okay, guys, I've got to go get ready for my son's birthday dinner. Thank you so much for joining me today. We do have a trial that will be in verdict watch. That's the baby Evelyn. And then we will be watching the Zachary Hughes. Some people are calling it the Rosebud murders. Some people rose petal murderers. Some people are calling it the Twisted Secret murder trial. And I know I'm saying the M word and I'm supposed to say unalive, but oh well. So anyway, what we'll be doing is this one and whatever else hits. All right. Once again, thank you so much for watching. Thank you for all my new people. You guys have been a blessing. Oh, sunny day. I hope it was a sunny day for you and everybody out there. We will see you bright and early, 9 a.m. I get to sleep in just an hour. That's okay. All right. See you. Bye. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.